Good morning. Good morning, guys. We are live. Hello, everybody. Um, gonna do day two for Jennifer Crumbley. Uh, very interesting day one. I just don't think her defense attorney did a very good job. I wasn't impressed. I mean, to say the least. I mean, as much as I was, getting all crazy there for a minute, it's just what did her attorney do that I think could have helped her at this point? And I think the opening wasn't the best, but that's fine. Hey, nobody the opening's not, yeah, whatever. You don't strike a home run on the opening. And then not questioning the first witness totally made sense. But she left some things out there that I thought should could have been picked up on the second witness. And then the third witness, yeah, I mean, she was kind of like you could tell she's not a firearms person, which kind of hurt because the prosecutor's floundering around in the gun stuff too. But it became with the ATF agent where I think she could have like been bringing things up, like the prosecutor's harping on, "Oh, this was a straw purchase. Did you guys investigate him for it? Did you guys prosecute for it? All these things we're talking about that are so bad. No, we didn't." Instead, she got stuck in the weeds on a fight about what's gun safe and what they're doing that's not right or wrong, and you know that leaves them open with a trained and witness who's trained to be hostile to defense attorneys. He's like, "Well, I didn't see anything being safe there. That's not normal. That's not safe. That's not how it should be done." She answered a bunch of questions she got burned on, which I don't think helped. So, Source Rex says, "You guys are so fast." Yeah, that's people are fast about it. Unhung Hero for $2 says, "I'm here and I'm gonna come." Don't come. Don't come. So that is it's kind of where I'm at with this. That's what I'm looking at here, how I'm thinking about it. Um, yeah. So I guess we'll get started. Yeah, day two. Let's hope this goes better. I mean, it's still really early in the trial. That helps, but I don't know what's going to happen. Like I'm just not sitting here super thrilled that it's going to be perfect. Like what she need, like what she's going to need out of this because it's just yeah. I mean, let's hope against hope here. Apparently, there's also been a bunch of fighting with the defense attorney and the prosecutor. So if that happens, I'm sure we're going to be able to see that and react to that. But let's get started. I set the timer for 10 p.m., not a.m. Really, let me see. That's something I hate about YouTube. You do all the crap right, and then it doesn't like um visibility. It's public. Done. No, it says 10 a.m. when I set it up in StreamYard. So I don't know why it's saying 10 on YouTube here. So, oh well. Yeah, I don't know what to say there. So sorry. But we're gonna get started there. Yeah, I don't know. I don't know why I did that. Hmm. All right, so enough of this nonsense. Here we go. Day two, Jennifer Crumbley, guys. And I will say, going forward, I don't know if we're gonna have time because we got to get Michelle Trakunas done and this one done. Um, Jennifer Crumbley may turn into. We'll be recapping it through the week. Like on Saturdays, we'll probably catch up and do like a weekly recap. But that's just so you're aware. We're gonna try to do this at 1.25 speed because it is 8 hours long. Also at 3 o'clock, we're gonna take a break real quick. We're gonna bounce over to see Hella over at Excited Utterance to see see what's going on with her for about a half hour, kind of like as a lunch break, and then we'll get back to this and finish up tonight, okay? This afternoon. So just wanted to give you guys a heads up on the plan. So anyway, here we go. So let's see here. Speed 1.25. All right, here we go.
Your Honor, calling people versus Jennifer Crumbley, case number 222799990, FD.
Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
And good morning, Your Honor. I'm Shannon Smith on behalf of Jennifer Crumbley.
Good morning, Your Honor. Sean Godwin on behalf of Jennifer Crumbley.
Good morning. We did get a note from the jury this morning, just for your edification, that telling me that the media is describing who they are. Someone is a radiation.
Ooh, that's not good.
Radiation oncologist or something, and has 2 children or whatever it is. I think that they are have a belief that I have more control over the media than I do. But anyway, I plan to do nothing about it. So I think they were letting me know.
Okay, thank you.
Okay. Thank you.
They don't use anyone's names or what city they were in. So
That's interesting. There's these reporters are screwing around. They need to stop that.
We're not ready. And
You're
this
not
is-
ready?
No, we're ready. But before Mr. Wendowski comes in, there are exhibits that I have previously objected to.
Okay.
That
Who is he? Who is he?
Computer crimes, Oakland Sheriff's Office.
Okay.
It's my understanding or belief that he's going to testify to some of the messages that were sent from the shooter to his friend, who we're not going to name, B. And I previously filed a motion and asked that they were excluded. I understand the court's ruling and that they're included.
Yeah, that was a year and a half ago, right?
Yep, but since that time, I have received further documents that show information that is critical to the defense from the psychiatrist who evaluated the shooter, and it appears that we have an issue that the shooter will not waive privilege.
Okay, let me ask you something. When we left yesterday, I asked whether there was any issues. I really do not like to use the juror's time talking about these things. I'm aware of this issue. I'm frankly irritated because I feel like the court has been very timely in responding to the attorneys, and I don't, the scheduling order had a motion caught up in December, and I don't appreciate the very trial homework assignments for the court. That being said, I'm aware of this issue. That's why I asked about it last night. I do plan to make a ruling on that. We've done some of our own research. I've gotten motions from those 2 psychologists, but I'm not going back a year and a half and changing my ruling that could have been appealed at that time.
Well,
I know that things have happened since then, but those things are subject to appeal. The motion to quash the denial was appealed. All kinds of things were appealed.
Wait, is she saying she wants them to appeal every single freaking thing? Like that's not generally how you do that. But she should be allowed to well, I mean, bringing them up unless something just happened in testimony is a bit. Yeah, I get that part of it, but otherwise,
To the Supreme Court for a year. I'm pretty sure it was coming back, which it did. And I know that Iowa State, so you couldn't file anything then, but these rulings were made a year and a half ago, and there's reliance on those. And the Court of Appeals and the Supreme Court have not told me that that was error, or I shouldn't do that, or anything like that. And I think there was opportunity to appeal.
Your Honor, there was opportunity. We did appeal. We appealed to the Michigan Supreme Court. The court is absolutely right. The problem is, even after the motion cut off, my office received records from jail psychiatrists that I need, that has important information.
Okay, let me tell you this. We're not arguing that motion right now.
I understand. So I'm just
Yeah.
placing my objection on the record because part of what I've asked for is that the evidence I am not going to be able to contradict that's going to come in through this witness is leaving me absolutely hamstrung. If the court rules that these psychiatrists cannot testify and the shooter is not going to testify, I'm left with this evidence coming in when I now know things I didn't know at the time. And I just learned these things, and we just got the objections to these people testifying, and from Sato this week about Ethan testifying.
That is not true. That is not true. The shooter's attorney, Ms. Lofton, asserted that privilege at the time that I provided the records. The records were provided under a protective order. The records are subject to an absolute privilege that we have been researching for the past week. There's an absolute privilege, as far as I can tell. If you can find me a case that says there isn't one, I would be happy to read that. We have spent a lot of time on the homework assignment we were given while the trial is in full swing. I found nothing that says those records aren't privileged. The privilege was asserted by Ms. Lofton at the time that you requested the records. I know it was asserted again by Sato, their new attorney, but it was asserted back in November. I can give you that date if you want. At the time that I provided those records under protective order because they could protect, the prosecution had the records, and because they could potentially lead to exculpatory evidence on behalf of the client. I didn't plan on ruling about this today, but I guess I would direct you to the Stanway case that talks about review of records. So that's of a victim witness's records, and in that instance, there was in-camera review, but there has to be a threshold showing that there would be relevance. I don't have that either. So I'm working as hard as you guys are right now. So at the moment, I'm not going to go back and change my ruling from a year and a half ago. I think everybody has had ample time. When something is filed, I respond to it in a very timely way, despite the fact that I have one or two other cases. And I'm not changing my ruling from a year and a half ago.
That's
You
offensive.
appealed it to the Court of Appeals, the Michigan Supreme Court, the U.S. Supreme Court, whoever. So
Your Honor, I'm not asking the court to change its ruling from a year and a half ago. I'm asking the court to make a new ruling based on new information that I literally got this week. I literally got this week that Ethan Crumbley will not testify pleading the fifth, and that.
I'm sorry, I have to interject. We brought this to the court's attention in November of 2022. We discussed this.
are you talking about the 803 statements?
All of it. And I don't mean to interrupt the court, but just to supplement what the court indicated, counsel for the shooter filed an objection in November of 22 and then filed another objection regarding privilege in October of 23. And at one of the very first hearings in this case, we talked about how it would be near impossible for this attorney to call somebody with a Fifth Amendment privilege. We have Fifth Amendment privilege. We have a privilege in the mental health code. And there's also the issues of hearsay, Judge, and there's nothing inconsistent in any of this. And counsel's had all this information.
Well, and Your Honor, I subpoenaed those three doctors. Those three doctors coordinated with my office to find time to come in and testify.
Okay,
And
how did we testify?
And then they had attorneys file motions this week while we've been in trial. And I filed a motion while we were in trial asking for alternative relief. I'm not asking the court to change its prior ruling. I'm asking the court.
I found no legal basis for your alternative relief, and I have tried mightily.
Well, the alternative relief, I
I
agree with you. I'm not talking about the privilege, but I'm saying when the privilege is absolute, if the privilege holder will not waive it, the court rule says, and it doesn't have to be a complainant, it doesn't have to be a victim. It says if the privilege holder will not waive it, their testimony cannot come in. And what this court is going to allow to come in through this next.
The privilege holder is not testifying.
I understand that, but the problem is the evidence coming in are statements this privilege holder made, and I have no way to cross-examine
I
to
think
show
that's a
the
fair argument.
inconsistencies and the important information.
I received no offer of proof about that. I don't know if there's inconsistencies in it.
There's not. This argument isn't based on.
Yourselves are writing
This is
itself.
something we've
I
been
don't
saying
know
for
that.
months.
I know that there's been no supplemental filing saying that there should be.
I understand your point, though.
This person is not testifying. The shooter is not testifying. So how is he someone who's providing testimony? He's not. Those are statements that were provided in 803. I was not prepared to have this discussion today, this morning. That's why I said last night, anything. The jury is waiting. I would say that I also asked that in the Zoom we had last week. I think it's disingenuous for the defense to say that they're surprised that the shooter would be taking the fifth. You are a very smart, very experienced attorney, and all this stuff is sitting on my desk. There's a case, Jack Maloney, right? You can't put someone on the stand knowing that they're going to take the fifth. And aside from shooter, what's your favorite color? What question could you ask him that would not implicate his Fifth Amendment rights?
Okay, I'm sorry. This has to be a clear record.
It's not going to be a clear record now because the jury is sitting there.
I asked to have the shooter brought in after the issue of privilege was brought up by the shooter's attorneys and by the attorneys for the doctors. I was not planning to call the shooter until this privilege issue came up this week.
No, the privilege issue came up in November.
on the actual records,
Yes.
not on the testimony. The testimony is all impeachment.
What testimony?
The testimony that I anticipate these doctors will give is straight impeachment of things the shooter said.
I need to correct the record. It is not. And Dr. Anneker informed me that she had a conversation with defense counsel last week when counsel tried to subpoena her, and Dr. Anneker explained that to counsel that it is not inconsistent. She actually
That's
said
not
that.
true.
I don't know.
That's
I don't
not
know if it's
true.
inconsistent or not. I have not read the records. I have not read these records. But the privilege was asserted at a minimum last November by the shooter's lawyer. And try as I might, I cannot find an exception to that privilege. That privilege is absolute except in limited purposes. The privilege belongs to the shooter, and it's been asserted several times. I have personally, in my staff attorney, been looking for something that would support your position. The closest I've gotten is Stanaway, and that is a victim witness, and there was a threshold offer of proof by the defense regarding what should be searched for in an in-camera review. I'm obviously not in a position to do an in-camera review of those records right now, nor have I been provided with some glaring thing that the shooter said. I lied when I wrote X in my journal, whatever it is. So,
Your Honor, I am going to put together an offer of proof of exactly what these doctors would testify to. I understand the court has not ruled yet about these doctors, aside from the fact that the privilege is absolute. I understand that. I cannot file that because of the protective order.
No, you can't file it.
So I'm gonna put it together, I'm gonna get it to everyone, and obviously we'll go from there. But I also want to state the privilege, obviously we all know the Fifth Amendment. This shooter has pled guilty, he's been sentenced. It's our position that at this point, he does not have the same Fifth Amendment rights as, for example, James Crumbley.
It's just not the
whose
law.
trial is not.
Okay, support it, because every lawyer in this room knows that sentence is going to be appealed until well after I retire.
Well, and the other thing is the evidence I intend to put in front of this jury, quite frankly, is evidence that the entire world knows about because it came out of the Miller hearing.
That's not the
So-
test for the law.
You're
or the
telling
evidence.
me why it's relevant and why it would be fair to you to admit it. I understand why you want it. I understand why you want it. I haven't seen it. I understand why you want it, but I have to follow the rules. Believe me, I have been researching this issue.
Well, and I'm sorry, that's why I'm pointing to the rule about when the privilege holder won't waive it and when the privilege holder won't testify and can't testify, I'm going to the third option, which is that evidence just can't be used. If I have
I'm
no
sorry,
way.
this is non-testimonial evidence that's being admitted today, not testimony.
It's-
Non-testimonial evidence, I'm not finished. Not testimonial evidence, and that's the basis of this court's ruling. There's no Crawford issue, there's no confrontation issue, it's non-testimonial. If it were, we have an issue. We don't.
And I believe the Crawford issue is preserved, and this is testimonial because this is information that is tantamount to testimony in this case.
The rules of evidence, 803.3 specifically, 803.1, talk about present sense impression. I did a thorough evaluation of some of those statements at that time, which was about a year and a half ago. What month was it? Maybe I'm blocking it out. I evaluated all of those statements, and I made a ruling based on a hearsay exception where the declarant whether the declarant is available or not is immaterial. So whether he testifies or not is immaterial, which says to me it's separate. Those statements are separate from any testimony. The person who made those present sense impression statements, whether they testify or not. That's what 803 says. The theory behind it is that it's done in a contemporaneous way. So I made those rulings a year and a half ago, and I invited anyone to appeal anything.
Guys, I'm sorry. I think I talked to myself for a second there. I don't think I was actually saying something to you guys. My bad. I'm just reacting to them.
So it's not that people haven't, that either side hasn't had the opportunity. So I will read any case you provide. I have been researching whether or not those records could be admitted, and I have found nothing that would direct me to allow doctors to testify about privileged records that have not been waived by the person who holds the privilege, and that person is the shooter. And that privilege has been asserted repeatedly by Ms. Lofton and by Sato.
Okay. So yes, this idea of the privileged medical records, of Ethan's medical records. Yeah, this is not, since he's not the defendant, he's not the party here, there's going to be issues of privilege. What can be brought in? What his doctors can testify to anyway? There's limited parts of that. Now, the thing that she'd be able to get around is, let's say Ethan had gone to trial and they had a full-blown hearing where all that stuff came out and was introduced and on the record, then fine, you're allowed to reintroduce those things and there's no privilege anymore because it's been breached for that trial. But since Ethan pled out, not all of this is known. Some of this may have done in motion practice, but what Jennifer probably wants done to bring it in to help him all the way, It's not there. So Ethan would have to waive that, and that has never happened. And, and that's where I'm sure that at this point he wouldn't do it anyway. And I don't know. I'm sure he doesn't like his mom, and he blames her for this. So going to him isn't going to help, and you have to go through his attorneys anyway. And the doctor can't waive it because it's just like attorney-client privilege. Absent those times where you're attacking the attorney or the doctor, the privilege to waive is for the patient or the client. So doctor-patient privilege, it's the patient's privilege to waive. Attorney-client privilege, it's the client's privilege to waive. So, there's some of that they're trying to bring in. They're trying to readdress some of the evidentiary rulings from before. And I do get the judge's point of like bringing this up the morning of, no, we're not fucking around. We're going to get going. But it also does sound like, based on some information she got the week before, she's got caught with her pants down a little bit. But the judge is also pointing out, you've had a whole week. We've had multiple hearings. Come on, let's go. Yeah, I think they kind of sat on their rights a little bit here. So
I will read any case you give me, and I've been frankly trying to help you. I can't find a case that allows for that. So,
Your Honor, the only cases I can find, and I think it's because this is a unique issue, and there has probably never been a case like this, with parents who are also charged with murder-type crimes, and the shooter is charged with a murder crime that he pled to. So this is a very unique situation. Unfortunately, it's a case of first impression. I know the court knows this. And so when I look at the cases, I agree with the court that most of the cases deal with a complaining witness or an alleged victim and their rights. But the court rule says privilege holder. It does not limit it to complainant. And I agree with this court. There's not case law. And that's why I'm asking this court to make a decision to not allow these statements pursuant to the court rule, because I have no way to defend them. But if the court's ruled, the court's ruled.
Okay, well, I just plan on ruling on that this morning.
Well, Jim, that's the thing. That is a fair point here. They're trying to bring in these statements, and they want to be able to contest them with their own statements. And I do get that. And that's where, and as she just pointed out, though, there isn't a lot of case law in this area. But that's a problem. And here's a problem. If you don't have case law and you're asking the judge, it's not even to go out kind of like just pushing the edge of a ruling or a current holding, but carpet is gone, fell off. If you're asking the judge to go way out there, like way far out there, they are very reluctant to do that. They don't want to go like trimming away at the edge of something, pushing the envelope just a little bit. Yeah, you might get them to do that, but that's really they're reluctant to push the envelope. But to go really far out there and set new case law like that, a lot of judges don't like doing it. It is a unique argument. There's no precedent, there's no authority on it, but they may have authority elsewhere. I mean, there's an inherent authority. I mean, you can always argue in fairness. It's fairness in the judicial system, the prejudicial weight, all those things that, like, his right to her right to a defense, entitled to the. I think the inherent thing there, yes. You're bringing up the Sixth Amendment, Jim, yes, and that's where I'd argue you have the inherent right to present a defense and mount a defense. So that's something I would try that way, and that's the argument she has to make. But I don't know. Yeah. And Jim's saying if they can't confront the person making a statement, it shouldn't come in. I agree with that, but I think the judge has already ruled that that's coming in. So that ship has sailed a long time ago. All right.
I will still file an offer of proof, and I will still file a list of what the evidence would have shown. And I understand the court will make a decision about the doctors testifying. That's the best I can do.
Okay, well, I'm doing the best I can do.
I know you are.
Anything else?
Just really quickly, what the court rule says is that if the privilege is absolute and the privilege holder refuses to waive the privilege to permit disclosure, the trial court shall suppress or strike the privilege holder's testimony. I'm not done. Testimony, and this is non-testimonial evidence, what we just said. There's nothing more. This isn't a case of first impression. This is the law. It's been the law for a very long time.
Well, the problem is I want the testimony, and I'm being told I can't get the testimony.
That is directed at a person who puts, like someone who is in a car accident and they're suing an insurance company and they're putting at issue, they say that I've been depressed, I can't leave my house since this accident, whatever it is. If they testify to that and then they object to having their mental health records admitted, it's problematic because that person, the witness, put their mental health issue in that case at issue. They put their mental health at issue. And so you can't use your shield as a sword. That's what that is about.
Correct.
So if you are a witness who's alleging damage to your mental health, yet you will not waive the privilege with regard to your psychological records from mental health treaters, then that testimony is stricken. There's a reason for that. You can't use your shield as a sword. That is the reason for that. That is fully separate from this issue. With regard to asking the shooter to testify, it's not that I'm saying you can't call him as a witness, but two of his attorneys have said in no uncertain terms that he's taking the fifth. Both sides, not just the prosecutor. Again, I think that's baloney. I don't know. All of this stuff is sitting in my desk. You are not allowed to put someone on the stand knowing that they're going to take the fifth. And I cannot think of a single question beyond what is your name that would not implicate his Fifth Amendment rights. So, I don't know what you could even ask him that he would answer or that his lawyers would let him answer. So it's not, I am going to prohibit you from putting any witness on the stand who takes the fifth in front of the jury. That is strictly prohibited. So are there other questions that you could ask him? I can't even imagine that would not implicate his Fifth Amendment rights. That's the problem. I understand your problem. I understand the difficulties. I do. And if you knew how much time I have spent and my staff attorney have spent on this, it's mind-boggling.
The other big issue for her is, based upon this, it's clear she's never spoken to him. So now you're getting into the dangerous territory of asking questions and you don't know what he's going to say. And if you don't know what he's going to say, you shouldn't be asking those questions of him. So that's the other big concern. Like, let's say he starts talking, you don't know what he's going to say, and it's very easy he screws you over. So at this point, yeah, he's not going to talk, and even if he wanted to, I'd be very concerned if he does want to talk and you haven't had a chance to screen it. So,
but at the moment, I have nothing that lets me say I have to rule in a way that is the most fair for the defendant, but goes against the law as I know it. I don't have something that lets me do that. If someone has something that lets me do that, I will be happy to hear about it. Okay, I'm going to enjoy it.
Thank you, Judge.
All right for the jury?
Good morning, you may be seated. Thank you for being timely. Who's next, please?
Ed Woodrowski.
Could you raise your right hand? Do you swear or affirm the testimony about to give as a true self of God?
Yes, ma'am.
Great. Could you take your seat here? Please record you have a seat. And then could you state your name for the record and spell your first and last name?
Edward Wardrowski, E-D-W-A-R-D, last name W-A-G-R-O-W-S-K-I.
Thank you. Good morning.
Good morning.
Sir, how are you employed?
I am employed with the U.S. Secret Service.
And how long have you been with the Secret Service?
Just a couple weeks.
Prior to this current job, where did you work?
The Oakland County Sheriff's Office.
How long were you with the Sheriff's Office?
28 years.
Okay, in those 28 years, where did you work?
I started out in dispatch and went to corrections after that, the road patrol, and then eventually to computer crimes.
Okay. And tell me, when you say computer crimes, what does that mean?
Do anything that has to do with the computer, cell phones, forensic examinations of computers, DVR equipment, call detail records.
Okay. How long were you in computer crimes?
10 years.
In your time in computer crimes, did you receive specialized training with forensic analysis of electronic devices?
Yes, sir.
May I approach the witness?
Sure.
This is Exhibit 422. Sir, just confirm for us that that's your CV.
It's not your objection to this.
Oh, no, I'm sorry, no objection is admission,
Yes,
also no
right.
objection to disqualifications.
CD, so you would stipulate his qualifications, you would stipulate he's an expert in forensic examination computers.
Yes, that's right. Cellular cell phone forensics, historical cell site analysis.
Yes, the defense stipulates to both of those, the CV and that he's qualified as an expert.
Historic,
Cell site analysis and cell phone forensics.
historic cell site and cell phone. You may consider him as an expert in the area of historic cell site analysis and cell phone analysis. Yeah, okay.
Yes, sir. Thank you. Well, sir, now we don't have to go through the entire CV, but let's just talk a little bit about your training as it pertains to cell phone downloads and forensic analysis.
Okay.
Okay, so is it fair to say that this field is evolving?
Always.
So you said you spent 10 years there?
Yes, sir.
What sort of things did you do in computer crimes 10 years ago?
Things were a lot different. It was actually a lot easier to do forensics back then because with updates of how the phones operate, how Apple or whoever Android operating system, they just make it more difficult. And now we have to figure that out.
What do you mean more difficult?
With encryption, file-based encryption on a hard drive, so data that you hold personal can't just be taken off the phone and given out to whoever.
So talking about what a detective in computer crimes, or first of all, what your current role at the Secret Service, what exactly do you do there?
I'm a network intrusion forensic analyst.
Okay, so would that be the same sort of duties you had in computer crimes?
Yeah, the same thing that I did, cell phone analysis, computers, just with more network intrusion, like someone hacks into a bank or something like that.
Okay, so walk me through, what is a typical day for a expert in the area of cell phone forensics?
Typical day is you come into work, you just see what work needs to be done. The case, depending on the case, how important it might be to get that, either examine those phones or contact the detective that brought that stuff in to see exactly what they're looking for on those devices.
So you'd be somebody to receive the cell phone, seize an investigation, and then conduct an investigation into that device?
Correct.
Okay, so what does that entail?
That entails, depending on the device, we have tools that are able to obtain the data from the phones. And then we then take that data because it could be voluminous, thousands and thousands, hundreds of thousands of pages, and then put it into an easy readable format called Celebrate is the company. They make a forensic analyzer reader, which makes it easy to look at.
So that reader, that's one of the tools, forensic tools you mentioned?
That's not the tool that we use. That's what we give out to investigators. The tool that we use is a little bit more than that reader tool, with the functionality that it gives us. But the reader tool makes it easy for the average investigator to look at.
Okay, so let's help me understand this. So the phone is taken as part of the evidence, a search warrant is obtained for that phone, and then you're given the phone itself. Is that right?
Correct.
Okay, so tell the jury, please, what do you do with the phone? Walk us through that step by step.
Depending on the phone, again, if it's passcode protected, if it's not passcode protected, there's different steps that we have to do. We hook it up to the tool. In this case, it would have been Celebrate again as a company, and the tool is their Celebrate Premium platform, and that's able to obtain what's called a full file system, which is everything on the phone, everything you can get off of it, as long as there's not encryption on it.
What's encryption?
Encryption is how do I describe it? I don't make it easy. It just jumbles up the information. It makes the word "the" look like absolutely nothing that you can understand.
Okay. So as an investigator in the area of digital information, you don't confine yourself just to a cell phone. Would that be right?
Oh, that's correct.
Okay. So what other sources of information would you draw upon as an investigator?
Someone's social media accounts, Facebook Messenger, Snapchat, all that stuff, anything you would download to your phone. And obviously the phones are cell phones, so you'd want to get the cell phone records from the carrier.
Okay. Now, talk to us about how you obtain the information from other sources other than just the device itself.
Via search warrant.
And before a search warrant is sent, do you send something else?
Yeah, there's something called a preservation letter. What that does is in order for us to get a search warrant, you have to have probable cause or reason a judge to believe that the information you're looking for is going to be there. So while we're trying to gather that probable cause, we tell AT&T, don't destroy these records under any circumstances for 90 days until you hear back from us.
Okay. Now, as an investigator, why is it important to not confine yourself to just the device itself? When I say device, I'm talking about a cell phone. So why would you not confine yourself just to that cell phone?
Because sometimes the stuff isn't always stored on the phone. It could be stored on a server, and the computer system, like again, Facebook, for example, or Instagram, that information isn't always stored directly on your device. It's stored on a server that your phone just accesses.
Okay. So is it your goal then as an investigator in computer forensics to gather as much information as possible?
Always.
And then when you gather the information, what do you do with it?
Start talking to the OIC, it is called the officer in charge of the case. What are you guys looking for? What do you need? How can we help you, basically?
Okay. Now, is every cell phone the same in how they store and transmit data?
No, sir.
Okay, tell me the differences.
The difference is, to put it plainly, the more advanced the phone, Apple, for example, or a higher-end Android device like a Samsung, could have file-based encryption, where a lower-end phone doesn't necessarily have that file-based encryption.
Do you know why that is?
It's just whatever the manufacturer wants to put on the phone. To keep the cost down, to not have as many developers and all that stuff, you just keep the cost down by not having that as part of your platform.
So if the user of a phone is spending more money for the device from a certain manufacturer, they can expect to have a higher level of encryption. Is that right?
Yeah, and features, yes, yes,
Okay. So then, is it possible to recover deleted content from a phone?
potentially.
And why is it potential?
Potentially because, again, you go back to that file-based encryption that I've said over and over. If it's, once you delete something on your phone, it's not necessarily always deleted on the phone, it's just encrypted. You telling it to delete it just erases the path to get to that encrypted data. And so we can't find it.
So it has nothing to do with the forensic tools at your disposal. It's regarding the manufacturer of the device itself.
That's correct.
Okay. Now, you talked about how some information can be stored on a server as opposed to a device. If something is deleted from a phone by the user, are you still able to recover it from the server?
Potentially, yes.
Okay. And tell me in what circumstances.
For this situation in particular, I did some research. Facebook Messenger, for example, two people are having a conversation. I delete it on my phone. All I do is I tell my phone I don't want to see it anymore. Where Facebook, as the other person wants to see that conversation, won't delete it so that person can still read the conversation on their end of the phone.
Okay. So let's say you and I have a Facebook Messenger chat with each other, and I delete that from my phone. If the investigator wanted to recover that information, it wouldn't be on my phone. Is that correct?
Possibly, yes, correct.
Okay. But then you could send a search warrant to Facebook, to the server, and obtain that information.
Correct.
Okay. Now, what if you and I both deleted it from our phones? What would happen then?
According to what I looked up and looked at Facebook's website, that it won't be available.
Okay. So then it's deleted completely if both users of the chat delete it.
Correct.
Okay. Now, what about deleted text messages on the device itself? Tell me how that works.
Okay, that it just comes back to possibly being able to delete or retrieve deleted text messages on how they're stored in the phone, if the database is still available, or if the app's totally deleted from the phone, and all that data is stored in the phone, and I tell it to delete that app, then it could possibly be totally gone.
So if you were to review, let's say, screenshots from one person's phone and then a forensic analysis of somebody else's phone, if the screenshots didn't match up with the forensic analysis, what would that tell you?
That was possibly deleted.
Okay. Now, during the course of this investigation, People versus Jennifer Crumbley, did you uncover evidence of deleted content from Jennifer Crumbley's phone?
That's correct, yes.
Okay, and we're gonna get into that later. But before we do, could you tell us just in general terms, what does a cell phone do that maybe a layperson wouldn't know?
It's continually working in the background, talking to a cell tower. One, so your carrier knows where you're at, so it can give you the phone call if someone's trying to get hold of you, or the text message, or it is updating your email account without you telling it to do it, because the application is just constantly looking for the signal. So you open it and there's most updated information.
So that's when the phone's powered on, right?
Correct.
Okay, so when the phone's powered on, it's constantly doing things. Would that be right?
Yes, sir.
Okay. And what about when the phone's powered off?
It's doing nothing. It's just off.
Okay, so it can't update.
Correct.
Okay, so when a phone's powered on, is it possible to obtain the location of that device?
Yes.
How so?
Because there's a feature, whether you have an Apple product or an Android product, each one of them has what they call location services, and it's actually to benefit the user of the phone. So because that information is sold to McDonald's or whatever, and next, you're near McDonald's and your device says, "Hey, I'm near McDonald's." Oh, cool, I'll send you an ad for McDonald's or a coupon for McDonald's. So that's
okay.
Yeah.
So you have, as an investigator, a fair amount of reliability in that because of the capability for somebody's phone to sell the device basically to an advertiser.
correct. Yes.
Okay. And are you able to obtain someone's location from their phone based upon other data as well?
That's correct. Yes.
And how so?
Through the carrier themselves, AT&T or T-Mobile, whatever you may have. Again, you're constantly, your cell phone's constantly talking to a cell tower, and they try to triangulate your position on where you are based on the signal back and forth from each tower.
Now, on an Android phone, for example, it automatically comes with a Gmail account. Is that right?
No, you have to make a Gmail account.
Okay, you make a Gmail account.
Yes.
Okay. So if someone were to have a Gmail account, would that also help an investigator determine the location of that device?
Absolutely, yes.
Why is that?
Because again, that information, that location services is stored within that particular Gmail account that someone might have. So if we would search warrant Google for your particular email, the Gmail, they would have, if that's turned on, the location services would be given to us.
Okay. So I want to talk about the evidence in this particular case. There were a total of 7 phones recovered, and I'll go step by step with you. So I'm going to review with you, I'll show you a slide here, some of the sources of available information. So you see that as a school shooter, his initials.
Yes, sir.
Now, is it true that you reviewed a T-Mobile phone, last 4 digits, the phone number 1551?
That's
a
right.
Facebook account?
Correct.
And an Instagram account?
Correct.
And you were able to determine, and we heard testimony yesterday, that both James and Jennifer Crumbley followed that particular account.
That's correct. They did.
Okay. So you were able to review not only the shooter's phone, but also social media, Facebook and Instagram for that individual.
Correct.
Okay. Now, regarding Jennifer Crumbley's electronic information, you reviewed information from 3 phones.
Correct.
Okay, so we have one listed as an original phone. Are you aware that her original phone was seized on November the 30th in the evening?
Yes, sir.
Okay. And then you're aware that she purchased what we refer to as a burner phone or a track phone that night?
Correct.
Okay. And then that's the number, the 947 phone number?
Correct. That's right.
Okay.
Yep.
And you're also aware that subsequent to turning over her original phone and prior to arrest, she obtained another phone?
And guys, I know this is boring, We've heard this nonsense a million times about cell phones, but we know it, but they have to lay the foundation for it. So yeah, we got to deal with it.
Correct.
And that was with her same original phone number?
Correct.
Okay, so you reviewed that device as well?
Exactly. Yes, sir.
So just so we're clear, when I say you review the device, we're talking about forensically analyzing
So-
the data on this. So,
A Faraday bag is a bag that prevents any electronic communications in or out. It's like a bag of tinfoil. That way the phone can't be accessed. It's also using like airplane mode, but that way the phone is impervious from being hacked or manipulated. So it's in a secured, it's kind of like you being air gapped. You can't get to it. You can't access it from the outside. That's what a Faraday bag does. Also makes you invulnerable to EMP.
Correct. Yeah, exactly.
okay. You were also able to obtain information from Facebook, from 2 different Facebook accounts,
Correct.
okay? And information from a search warrant served on Google regarding her Gmail account,
Correct.
okay? And that Gmail account and that Yahoo account, did that include location data?
The Gmail account, yes, yes, it does.
Gmail account did?
Yes.
Okay. Now regarding James Crumbley, again, 3 cell phones, is that right?
Correct.
Okay. His Instagram account,
Correct.
his Yahoo account,
Correct.
his Gmail account,
Correct.
an email through Charter Communications,
Correct. Yes.
and then a search warrant was served on DoorDash to obtain his DoorDash driving location history.
Correct.
Okay. Now, your goal with obtaining all of this information as an investigator into digital evidence is to obtain the who, the what, the where, the why, and turn that information over to the officer in charge and ultimately the prosecutors in the court. Is that correct?
Correct. Everything we can get.
Okay. Okay, so I'm going to show you People's Exhibit 76. I don't believe we have an objection to any of the evidence coming through Officer or Investigator Wografi, do we?
No, we have several objections. And I believe many of them are based on the record already, but let me open up 76.
This is 76?
We have no objection to 76.
Okay,
And I'm sorry, with this witness, we're gonna have to go exhibit by exhibit.
That's right. 76 isn't it?
Okay, so what are we looking at?
That is what we look at, a printout from the Celebrate Reader or Celebrate Physical Analyzer program of someone's information that came from the phone. And it's Jennifer Crumbley's, followed her son's Instagram account.
Okay, so just to give us an idea of what we're looking at here, this is a snippet from a PDF export from that forensic tool they use.
Correct, yes.
Okay, so tell me how that digital information comes to you and how it ends up looking like this.
The reports, the information that we have, you can put it in any number of formats. You can put it in a PDF like this is, a Word document or Excel spreadsheet. And you just tell the software what you want it to show you and export the software, and this is what it produces.
Okay. So moving on to Exhibit 77, this is a portion of James and Jennifer's Facebook messages. And Judge, I did want to place on the record that we do have an additional exhibit 423 that'll be introduced to this officer too. That's the entire Facebook message thread between James and Jennifer Crumbley. Counsel placed an objection on the record yesterday regarding that, so we're introducing the entire 2,000-page thread.
And Your Honor, I until I look at that 2,000-page thread, I object to it. My objection, I need to look through it. I might not object to it.
Okay.
My objection yesterday was about the exhibits the prosecution was showing, those individual exhibits, they deleted parts of those.
Hold on. Nobody deleted anything. This is
Well,
demonstrative.
oh,
The exhibits
oh.
are the same, and
Okay.
we're giving the whole thing.
No. Hold on. Yes, you did. You manipulated those exhibits because yesterday you weren't showing boom to boom to boom. You were showing single conversations. So yes, you were deleting parts of what you showed and changed them. That demonstrative aid, that's not a demonstrative. That's got an exhibit sticker. It's not a demonstrative anymore. If this is not how you presented it to the defense, this is not proper. You should only present the way you've given the defense. So yes, they should be forced to give all their slides. The fact they're making this excuse is nonsense to them because look at her screen down there. She doesn't have that. She's got this whole thing where it's like boom, boom, and then there's like a response, and then there's more. Well, that's how she has to look at it. And now she's got to fiddle fuck around in this thing to find out where this boom, boom, boom is. Is this the same thing right here? I don't know. She shouldn't be forced to figure out if these two things are the same. That's on him that's on these guys right here to be fair about that. And a lot of courts, like this judge, I'm surprised she is not getting in the way. There's judges where it would say, okay, well, that's not coming on. What are you presenting? What did you give to the defense? Well, that's how you're presenting it. Oh, judge, that's going to be a mess. And the judge will say, then you'd better fix it pretty quick. So I don't like how the state's doing this. She's right to make the argument still. So, oh, that's why I can't hit play, because this is on still. Whoops.
They're admitting an exhibit and showing the jury portions of it. They're permitted to do that, right?
Right, so, but I'm just saying, my question yesterday about the parts missing did not mean I'm asking for all thousands and thousands of texts to be introduced.
Okay.
So I'm gonna take a look at them and see if we do have an objection, and we may not.
Okay,
The other,
you've had them for a while.
what's that?
You've had them for a while.
Yeah,
Okay.
January of 22.
I guess.
She's had them for a while, but they don't know how you're presenting
The
them.
prosecution does.
They don't know how you're presenting
not
it.
want the jury to
They
get the
haven't-
impression that they're in some way hiding something, or
But they kind of are. They kind of are, though. This is not how you gave them to us. She needs time to figure out what you're showing, because you didn't give her that. So, yes, you kind of are hiding. You're putting her on the back foot. Yes, it is kind of sketch. Well, then if you don't want the jury to hear it, then why are you making new speaking objections, Judge? Why aren't you making them come to the bench? That's a you problem.
not presenting something to them. So they're presenting the portions of that exhibit that they think are relevant for purposes of this witness's testimony. In the event that you want the entire exhibit in, the prosecution is saying we don't object to that.
Right.
So it's up to you. You can let us know.
Right, and I believe the only problem is this court's made other rulings where things are discussed in those texts that are not a part of this.
Okay.
So when I reviewed their exhibits, as a whole. They're allowed to show different pieces of the exhibits, but that didn't mean I was suggesting we just admit the whole thing, because you've made other rulings about, okay?
Okay, they don't want the jury to think that they're not willing to provide the boxes and boxes of evidence. I'm sure that there are in both of these cases, but I'll leave it to you. They want to ask this witness questions about specific portions of those 2,000 pages. They don't want to show the jury 2,000 pages and then ask questions about it. So,
I completely understand that. I get that. The other thing I would ask the court is, until the exhibit is admitted, I would ask that the exhibits are not being published to the jury.
yeah,
Yes.
That's fine. Yeah, that's fine.
Okay, well,
correct.
okay, thank you.
Yeah.
So, I'm sorry, we're on exhibit 78.
78.
Okay, and
Okay.
let me just find my list really
Okay,
quick.
so 75 submitted.
In 78, we have no objection to.
Okay, yeah. Tell us what the exhibit is.
76 was admitted as well.
Yeah, just try to put the, tell us what the exhibit is prior to, so that she knows which one.
I have that 76 was admitted, 78 was admitted. The prosecution indicated they are skipping what was proposed
77.
exhibit 77.
Correct.
Okay, so,
Although we have no objection to 77.
okay, so you don't object to 76 or 78, so they're admitted. Okay. All right, go ahead.
Thank you. Okay. Do you remember my question?
No, sir, I apologize.
I don't either.
Okay. All right. So this is exhibit 78. It's been admitted. This is from the James and Jennifer Facebook message thread. Okay. So before we get into the content, you talked for a little bit before about deleted content, specifically a Facebook Messenger thread between two people.
Correct.
Okay. Now, in the course of your investigation, you came to learn that Jennifer Crumbley had a Facebook account,
That's correct.
and that James Crumbley also had one.
That's correct.
Okay. Did you uncover this particular chat thread on Jennifer Crumbley's phone?
No.
Okay. How did you obtain it?
Through a search warrant to James Crumbley's account.
Okay. So if there is an actual chat history, in this case, a 2,000-page chat history between two people, but it's not found on a device, but it's found on the server, what does that indicate to you?
That one person deleted it.
Okay. And in fact, Jennifer Crumbley had the Facebook Messenger app on her phone.
That's correct. She did.
Just this was deleted.
The chat thread, correct.
All right. Now, 78 is a few slides, so we'll go through it together. Okay, we have the date and time up there. We're going to start with March the 9th of 2021. We're going to backtrack a day to give it context, and then we're going to go through late winter, early spring of 2021. Okay, so before we get into this, is it fair to say that as an investigator who analyzes all this electronic and digital information, you were able to provide a digital footprint for the individuals you're investigating?
That's correct.
Okay, and that's the goal of your investigation, generally speaking?
Yes, sir.
Blue is who?
That is Jennifer.
That's Jennifer, okay. So she wrote, leaving at 4 today, what time you done? And that was March 9th at 2:55 p.m.
Correct.
Okay, now it says UTC -5. What does that mean?
The UTC is, people might know as GMT, it's where all time starts in Greenwich, and then it goes plus or minus depending on which way you go from that line. At that time of the year in March, we were -5 hours from the start of time. So if you add 5 hours, it would give you what the UTC actual time is on the year.
So when you see UTC minus a number, that indicates to us that that's real time.
That's right. It's already been factored in. The software did that.
Perfect, okay. So March the 9th, you able to get an idea what James and Jennifer were doing and talking about this conversation?
Yes, sir.
Okay. So she wrote leaving at 4 today. What time you done? James wrote 5. He's in green.
Correct.
And we know that because that's his Facebook ID as well as his name that came with the Celebrate reader.
Correct. Yes, sir.
Okay. And she wrote, okay, see you at 5:30.
Correct.
Sir, in all the information that you recovered, is it fair to say that James and Jennifer Crumbley communicated quite a bit through Facebook Messenger?
Yes, sir. They did.
And so the Facebook Messenger thread is substantially more so in volume and data than any text message thread you found between the two of them.
That's correct.
Okay. All right. 3:46, March 9th, Jennifer wrote, bring me socks and a drink, LOL. What did James write?
A drink? Nah.
Okay. Jennifer, got myself a drink at 4:31 p.m. And James's response?
Okay, you grabbed smokes too? Almost out, I think.
Okay. And she writes, yes. Did you check the front porch? And what did James write?
Nothing on the porch. What were you expecting?
And she wrote their new blankets. Now, are you able to determine where they go later that day?
Yes, sir.
Okay, so need hoodie, NOL socks. I believe that was supposed to be wool. He wrote hoodie check. What are no socks on my way? Okay, now this is exhibit 79. Actually, I'm going to approach, unless there's an objection to the photograph on your phone.
I have no objection, but again, I would ask.
That's fine. That's fine.
Before they,
Yeah, I agree with you.
Thank you.
I agree with you.
but no objection to 79, thank you.
79.
There are two exhibits on one side, so okay. This is 79, and underneath it is 80. Have you seen those items before?
Yes, sir.
And how have you seen them?
There were pictures on Jennifer's phone.
Okay, so I'm going to move to admit 79, I believe, stipulation, as well as 80.
I'm sorry, can I have a moment, please?
Sure.
I have no objection to 79 or 80. That's correct.
79 is admitted and 80 is admitted.
Now, as an investigator, are you able to tell when you look at a photograph that's saved on a phone where the photograph was taken and when it was taken?
Potentially, yes, sir.
Potentially. Okay, in what circumstances?
If the camera is set to record, that you wanted to tell you the date and time they was taken and the GPS location of where you're at on the earth.
Okay, so 79 and 80 on the screen. 79 is the picture itself, and then in the text box on the right, that's the metadata.
Correct.
What's metadata?
Metadata is, we call it's the data within the data. The main data here is a picture of a horse. The metadata inside that data is all the stuff the camera make, a camera model that's captured that you just don't usually ever know what happens.
You know, I think before we get into your investigation into the phones itself, I want us to back up a little bit and talk about your involvement, how you got involved in this case. So November 30th, 2021, you were a detective in computer crimes.
Yes, sir.
Okay. And do you remember that day?
Yes, sir.
Okay. Were you working?
Yes, sir.
Where were you at 12:51 p.m. on November 30th?
At 12:51 p.m., I was sitting in my office, I believe, at the Oakland County Sheriff's Office.
Okay. Did you learn of the school shooting in Oxford?
Yes, sir.
Tell me how you learned that and what you did next.
Our captain came in, and well, prior to that, our sergeant, who was off that day, had said that there was a shooter at the high school. And we thought in the office, like it was just somebody near the area that fired a long gun or something like that, from a house, and, the cops, the police are gonna show up and do their job. And then probably a few minutes after that, our captain came in and said that there was a shooting at Oxford High School, and the phrase used was all hands on deck.
Okay. So what'd you do?
Being what is referred to in the business as a computer nerd, you just grab your stuff, your computer, your laptop, what you think you might need, what we had no idea what we were getting into. And I knew Oxford was a long ways away from the Pontiac area. I figured by the time I got there, it was going to be long over, and me and my partners were just going to do what we do.
Okay. So do you get a squad car? Did you get an unmarked car?
I have an unmarked, at the time I had an unmarked white minivan with emergency lights and siren in it.
So did you start heading north then?
Yes, sir.
All right, tell me about that.
Well, at first it didn't seem real. I remember pulling out of the parking lot, and I looked to my left, and there was some patrol cars coming around the corner. There's the medical examiner's office down there.
Oh, for fuck's sake, man.
And I'm like, then it really came real. Like, holy crap! Like they know about it. It was the state police. I'm like, they know about it. Like this is serious. Like
It was
bigger
so
than I
tawy.
could ever have imagined.
Like,
So I flipped my lights on at that point and just drove north
Okay. How fast were you going?
as fast as the van will let me.
How long did it take you to get there?
I have no idea. It seemed like eternity. I can tell you that much.
So
It's hard being a
Oxford High
tin
School,
boo
it's a large
one.
school.
It's so
It's one level,
scary.
it's one story rather.
Yes, sir.
As far as area, it's got a pretty big footprint. Okay, so where did you go when you pulled up?
When I was driving there, there's a lot of radio traffic, a lot. I remember I was actually at 24 and Lapeer Road, and 24 Lapeer Road in Updike, and they called that S1 was in custody. And I was still, I know, a ways off from there. But that, we didn't know what was going on. We didn't know if there was a second shooter, third shooter, a bomb landed somewhere. So, it just didn't stop. And I drove north on 24. Again, it seemed like eternity. And with every half mile I drove, it seemed like there was another emergency vehicle falling in behind me.
Yesterday was described as a caravan. Would that be accurate?
Oh, it was definitely carried. There was one time we got into, I remember approaching a light, we were getting closer, and there was, the light had just turned red. So cross traffic was going to start, which obviously is a dangerous situation, being in the car. Actually, the white minivan that no one believes is a police car. And so as I approached, I got up into the intersection. I inched my way in there to stop traffic and hold the intersection. And I counted every vehicle that went past me. There were 18 or SWAT trucks, ambulance, patrol cars from agencies that were nowhere even near our area.
So tell me what you see when you pull up on the scene.
Like I said, there's a lot of chatter on the radio. I'm not familiar with the area of Oxford at the time. I had no idea where the school was. All I could hear was the staging area and Ray Road. And so I'm just thinking, I'm just going to drive north. I'm going to follow this caravan. We're going to go up there. And as soon as I see the Meyer, I'm going to stop there because I had no idea where the heck I'm going. I didn't bother putting my GPS, of course. And I turn onto Ray Road, and all I see is I see kids that look like my kids. They were girls wearing real, small clothing. And I had one kid, I didn't have a shoe on. They were coming down the road, coming towards the Meyer, and just like walking across the snow. And I remember it was cold that day. I had 2 coats on, and I was shaking when I got out of my car. And there was kids just walking past me, dressed like anybody in this courtroom is right now, with not ready for the weather.
So you said you went to the Meyer and Ray Road?
Yes.
Did you learn that was the reunification point for parents and children?
At the time, I didn't know that was a reunification point. I just saw that there were a ton of kids going there. When I got out of my car, walked down there. They were sending everybody down to the garden area to try to get, the names of people that had gotten to that point. And once I got, that would be at the south end of the Myers. Once I got to the garden area, there were kids just everywhere, just staying in the cold or making their way into I'm sorry.
Okay. What did you do when you arrived? Where did you go?
Like I said, I went to the garden area. I picked up on what they were trying to do. They were passing out notebooks just to write down everybody's names and phone number, all the students that were coming in. So I first started just collecting that. And then they started telling everybody, we got to go outside and get all the kids inside because, again, it was freezing out there. And so I go back outside and I start trying to direct people to go inside. And I know the trauma they just experienced. So I'm not gonna force them in the building. I'm not gonna grab them and drag them in there. And I remember putting my arm on a couple of the kids' shoulders and they didn't move, they didn't nudge, they didn't do anything. There were parents there just standing there. There were some parents that had made it reunified with their kids.
They probably wondered why there was some
I remember seeing
sweaty
school
guy.
buses pull up.
Some sweaty guy was crying,
School buses
touching him.
Students on it that had made it out of the school.
Did you go to the school?
Yes, I was probably at the Meyer for 15 minutes maybe. And then Detective Jeff Enger had called me and said that he was attempting to obtain the security footage from the school.
Where does Jeff Enger work?
He's also a detective in the computer crimes unit, worked with me.
So you were asked to go to the school.
Yes, sir.
Why were you asked to go there?
At that time, I was a little more versed in DVR systems. Jeff had told me, Detective Enger told me that he was looking to try to get that off of there, and he just didn't want to get it right, of course. And so he asked me to come up there and help him.
Okay. So you drove to the high school from Meyer, or did you walk?
I drove.
Okay. And where did you go when you got there?
I drove to what would have been the north entrance of the school.
The main entrance?
Yes, the main
Okay.
entrance.
And tell me what you saw when you walked in.
When I first walked in, there's vehicles people walking in and coming in and out, crazy chaos. And I walk in and Detective or Sergeant Sean Wilson was standing at the door, keeping security, so to speak, at the time, making sure people aren't coming in that shouldn't be there.
Okay. And where did you go?
I asked where the security office was because that's where Detective Enger told me he was. And people pointed me, eventually it was back behind the main office.
Okay. So tell me what you did when you arrived and who was there.
Jim Rourke was there, who was a school security at the time. He was trying to get the video footage. Detective Jeff Enger was in the room. Lieutenant Marsban was in the room. Deputy Lewert, who was a school resource officer, was in the room. And ATF agent was also in the room.
Mr. Brandon?
Yes, exactly, yes.
Special agent, not Mr., I'm sorry.
Yes.
Did you know him at the time?
I had no idea who he was.
And you said you had a familiarity with DVR systems, that's why you were called.
Correct, yes, sir.
Okay, so what was your specific role at this part of the investigation?
I wasn't given a direct mission or anything at that time because they were looking for a second bad guy or third bad guy. And so I knew that people would want to know, the bosses would want to know what happened.
I would have objected
where did
right
it
there
start?
because that's not
Who
fair.
was it if they didn't know that, or were there more people or whatever? So we just started to look for the shooter in the hallway that started.
Was the school made safe at that point? They were still clearing the school?
No, it was not.
Okay, so the officers were still conducting their searches, like you said, they weren't sure if it was one shooter, two shooter, three
Yeah,
shooters?
it might have been, I'm sorry. It might have been 1:30, 1:45 at this time, maybe a little bit later than that.
Okay, that's the time you arrived at the school?
And got to the office,
Got
correct?
to the office, okay, thank you. Did you learn how many surveillance cameras were active in Oxford High School on November the 30th of 21?
Yes, there's well over 90 of them.
Okay. And so
90
it was
cameras?
your job
Jeez.
at that point, or your role as you saw to identify who the shooter was?
Correct.
Okay,
Guys, just so you understand, Ethan did not go to trial. Ethan pled out. So there was no trial for Ethan. That's also part of the reason why the defense attorneys got a tougher time. If he had testified or things that had come in his trial, she'd have no issue bringing them in. But Ethan pled out. So Ethan pled out and got life without parole, which, I mean, I don't know why he pled out because it's like he was going to get the same thing no matter what. So, like, him pleading out didn't help him. So, because it's not like Michigan's got the death penalty. So, but there was no trial for Ethan. If you guys are wondering, well, why don't they do X, Y, and Z or talk about whatever? Ethan's trial never happened. So he pled out a couple weeks ago, and that was it. So
how did you go about doing that?
We started in the hallway, the 200 hallway where it all started, in the bathroom that the shooter came out. And we attempted to backtrack him going in there. I remember it took us like 15 minutes to try to figure out because he had actually changed his clothes. We didn't know who the shooter was. We didn't know his name in the office at that time. He was in custody at the time. We didn't know. And I remember someone in the office, someone saying, eventually giving us his name and then saying that he was in the school counselor's office earlier that day. So we went back to that time of day when he was going in out of the school counseling office to find out what he was actually wearing at that time. And we were able to follow him to the bathroom then.
How long did that process take you?
Well, because we didn't know what he was wearing. It took us 20 minutes to try to figure that out.
Now, are you the person, so you backtrack to the point where the shooter walked into the bathroom that he emerged from to be in the shooting, is that right?
Correct, yes, sir.
Okay. So are you the person, the investigator, who actually put together the footage of the shooting itself?
Yes, sir.
So you're familiar with the path the shooter took in the school?
Very much so, yes.
I'm going to ask you to walk us through that. So he said, you told us that he went into a bathroom. That's the bathroom adjacent to room 258?
Correct, yes.
Okay, tell us what happens next.
He comes out of the bathroom. What I envision is he comes out of the bathroom with a proud chest, with his almost like his shoulders are back, like he's
objection, objective, proud shoulders. Who the hell are you? You don't know his state of mind. Object. This is pure speculation. Who cares what he did? Nobody's contesting he shot anyone. She should be objecting right now, getting in front of this. This is nonsense. You know, nobody cares what you got to say, Fed boy. No one cares.
excited. He comes out of the bathroom and immediately to his left is a victim, and he shoots her in her neck, and then her boyfriend was there and shot him in his. He put his hand up and shot him in his mouth.
That's right outside 258?
Yes, sir.
What happened next?
He then quickly turned his gun to a group of 4 girls that were just standing there. He shot Hannah St. Julian, and she immediately fell to the ground. And then he continued shooting in the area that those girls were, and they sort of just like fell on top of each other, because they were hit as well.
May I approach this?
Sure.
This is a map. It's already been admitted. You can use this to describe.
What is it?
That's 5, Judge.
Judge Fox. Okay. Exhibit 5.
At this point, it's under a minute that all that shooting happened. And then, so at that point, obviously, it must have really, again, kicked in, for lack of a phrase, to to the victims in the hallway, and they started running. Then the shooter, with just a one-arm grab, just started just firing rounds down the hallway with no regard for obviously anything. And bullets are flying, and there was
Objection. This is not your narration time.
there's
You're
one
not
girl
the editor.
who was you see at the end of the hallway. She just as the shooting starts, she drops down into the fetal position in an attempt to protect herself, and
It's so snowy. Oh, this right here. Come on. I get it, but if you can't handle your shit, man, go home. Like, I don't need the editorializing. You shouldn't be up to editorializing. Like, why are we covering this? What did he do? He walked down the hall and shot people. Not, oh my God, it was so bad. No, just, I don't even think we need this, but come on.
the shooter runs up to her and just puts the gun right to her head. And that was Madison. And you see her fall over. He then goes around the hallway. And there's, at this time, all the kids have gotten out of the area, most of the kids. You see two girls. One stops at a classroom that obviously the victims inside have already locked the door, so you can't pull it open. You see her trying to tug on that door. And there's another girl with dark hair that comes running up behind her and like grabs her while the shooter is just shooting down the hallway. And then they just take off running further down the hallway. Now he sees he's rounded the corner from where it all started. Continues going down the hallway. I think at that point he might have reloaded his gun and continued down the hallway. I'm sorry. And then he stops as he gets to, like, there's a courtyard, what they call the cubby. Jim worked when they call this area the cubby, where the cameras are. And you see Tate Neer, he comes in the door and then just takes a left. He must not have known what was going on. And that's when the shooter leveled the gun, like if you were at a gun range and practicing. Leveled the gun, appeared to look down the sights of the gun. And fired
Stop
around.
with this, man.
Tate just fell instantly.
He's using their names like he
continues
knows
on down
them.
the hallway.
Like,
Walks past Tate. Doesn't care to
he knew
acknowledge
him.
the fact that even happened.
The sweaty
I'm
guy.
sorry. Prior to walking down the hallway, that's right. He, while Tate's body was laying there, you see the shooter with the gun still level fires another round, and it causes Tate's body to jerk. I don't know if it hit him in the hip or the backside or whatever. Tate's body jerks, and then the shooter walks past him.
No,
You see his feet at the top of
guys.
the camera frame. There's not a camera that picks him
He
up.
went to prison.
If there's not enough movement, they don't start recording. But you see his feet stop in what I later found out to be a teacher's classroom, and he turns. And then
Yes, he's doing this on purpose. I think part of this is this guy thinks he can, like, oh, I know who they are, so I can talk about them and use their names like I totally know them. Like, hey, I'm cool, I'm with it, I'm officer friendly. I think that's a little bit of it. I think this is him hamming it up a little bit. I mean, this just reeks of just douche chilling. This awkward, sweaty guy up on the stand talking about these kids like he knew them. Like, ugh.
he fires into that classroom. He continues on down the hallway, looking into classrooms and stuff like that. There was one, as he gets so far down the hallway, he fired a couple rounds down the hallway. Once he gets to a certain point, all the children are gone at this point. The teachers had gotten them out of there and ran, out of the building and out through the door, wherever the heck they could get out of there. As he's coming back, you see him stop because the way that classroom was, if you're walking away from it, it's on your right-hand side, you don't see the classroom because it's actually behind you at this point. But as he's coming back, he must have seen people hiding in the corner because he can now see through the window, and he fires off a few rounds through that window. He keeps coming down. He's coming back down the hallway now at this point. And then the assistant principal, Gibson Marshall, I didn't know her at the time. He walks right past her, and sort of, I don't know what she said to him, but if she said anything. But you see like the shooter as he's walking by, and the gun's in his hand, and he sort of just turns his head and just, I don't know why, but he turns his head, looks away from her, doesn't even look at her, doesn't acknowledge her after as he's walking past. And then he continues on down the hallway. and stops at the bathroom where Justin was killed. And just like an abrupt stop, like, okay, well, and he just turned right and went to the bathroom.
So I didn't tell you I was going to ask you that. You obviously have this committed to memory.
Yes.
How many times have you seen this footage?
Like I said before, I don't know, it's burned in my brain.
And it was your responsibility to obtain that footage, to get the information to officials at the sheriff's office and federal law enforcement as well?
Yes, sir.
So you were the person that had to watch, rewind, over and over again?
Countless times, yes.
Judge, this might be a good time for a short break.
Okay.
Your Honor, my client could use a second if we could please. She's like, I'm trying to like,
Okay,
we could.
okay, I understand. We
Thank
understand.
you.
I understand. Okay, so we're going to take a 10-minute break, so if you can be ready to.
That was just obnoxious and a half right there, guys.
I'm having demoting and promoting people while I understand your sergeant.
No, ma'am, I'm an analyst now. I'm civilian employee, I'm
Oh, you're a
sorry.
civilian.
I'm sorry.
An analyst, yeah, I'm sure there's a lot of analyzing going on there.
You, are,
Ed.
still witnessing so on, so you can't discuss your testimony with anyone during the break.
Yes,
Okay?
ma'am. Yes,
All
ma'am.
right, you can start.
Yeah, basically, this is Ethan's trial. To be fair, they need to present some of what happened because to show that she's guilty of and like she's an accomplice, and that's kind of the theory here that basically she enabled this to happen. They do have to show what happened, but to show it on the scale of like this is basically Ethan's trial, and they're that's what they're doing here. And yes, it's nonsense, but they are allowed to present their evidence. And yes, I agree it's highly prejudicial, but a court is going to say, like the Michigan courts are going to say, yeah, this was fine, even though we know it's not. So, yeah, let's see what happens.
All right, the jury.
Assuming yeah. Okay. You can take it downstairs. You can be seated.
Also, real quick, we got a couple of super chats I need to get through. Whiskey77 says this case started to watch not because of the context, because the lawyers on both sides are unprofessional and annoying. Yeah, that does not help things. That does not help at all. It's hard to watch a compelling story when the actors in it or the parts in it are not likable. And then Nick Naylor for $2 says, thank you, by the way, is saying the screeching heartbeat is driving me up the wall. Which one? Which one? You need to be more specific, sir. So yeah. But yeah, I pretty much agree. Yes, I love how they take out all their stuff with them. Jesus Christ, you guys. That's just, yeah, cute. So let's see where we are. Okay, here we go. Looks like they're back. Everybody Stevens says, is it a novel case? Yes. No other school shooters' parents have been tried like this. Not even the parents of the Columbine shooters. Charlie, those chains and all that, that's the jail transport policy from the sheriff's office. That's a security policy. And that's every inmate they bring up. Doesn't matter who you are. You get shackled when you're being walked around and you're not in court and not in front of the jury. That's kind of a standard deal.
Apologize every time I get there and fire breaks out. So I'll stop here. Ready for the jury?
Yes, Judge.
Yes, Judge, thank you. And you just leave it. Yes, yes.
Oh, here's the witness. You can retake the stand if you like. right, you may be seated.
Yes, ma'am.
Go ahead.
May I proceed?
Sure.
Okay. Now, just one more question about November the 30th. When you arrived at the Meyer and Ray Road, were there just a few parents there or a lot of parents there?
There are dozens of parents just standing there just waiting.
Now, I want to direct your attention now to the late winter of 2021 and the early spring of 2021, specifically how you came to know about information regarding that time period in your review of the defendant's device. So I had already introduced this exhibit. 79 is the photograph, 80 is the metadata. Okay. And if you could tell us, did you recover evidence around this time frame that was of note to you of an investigator in this case?
Yes.
Okay. So like I said, we're going to start with March the 9th and move backwards from there. May I first one?
Sure.
This is people's proposed 81. Sir, I just handed you a map. We were talking about metadata and how it can occasionally give an investigator an idea of where and when a photograph was taken.
Sure.
Okay. And if we look at the screen here on exhibit 80, we have coordinates at the bottom of that metadata. Is that correct?
That's correct.
Okay. And so 81, I've just handed you, that's the coordinates plugged into a map.
Yeah, and a good, yes, correct.
People move to omit 81.
No objection.
81's
I'm sorry, 80.
It's a Google map of metadata.
Yep, no objection.
81.
So this is 81 on the screen here. And that tells you, in addition to the metadata, where the picture was taken, where that device was when the picture was taken.
Correct.
Okay. Again, this is March 9th of 2021.
Correct.
Okay. Okay, now I'm going to ask you about what Jennifer's son was texting Jennifer about on March 9th, 2021. And approach witness.
Sure.
This is People's Proposed Exhibit 82. Sir, those are text messages exported from Jennifer Crumbley's phone. Have you seen that in the past?
Yes, sir, I have.
Okay, and how did you come to see that?
From the phone extraction.
Okay, and you extracted the information, you reviewed those messages?
Correct, yes.
People move to omit 82.
Any questions, 82?
I'm sorry.
82 is a text message between shooter and Jennifer Pages 105-106 dated March 9th, 2021.
Yeah, I believe that the court, I've
Previously
previously,
lodged an
thank you.
objection that I will correct its preserved. 82 is made.
Thank you. So I'm going to publish that. There's multiple slides, and then you can look at the screen. So this information is from Jennifer's original phone. Is that right?
Correct.
Okay. And so People's 82, we have multiple slides here. The blue is the defendant's son. Is that correct?
Correct.
Okay. And what is he writing at March 9th, 2021 at 7:50 in the evening?
He's asking if Jennifer could come home. There's someone in the house, I think.
Okay. And what's the next text he writes?
It's the third one says someone walked into the bathroom and flushed the toilet and left the light on.
Okay. That's March 9th, 2021 at 7:50.
Correct, yes, sir.
Okay. And then March 9th, 7:50, 52 seconds. What does he write?
And I thought it was you, but when I came out, no one was home.
And then he writes, there's no one in the house though.
Correct.
Dude, my door just slammed. That's at 8 p.m.
Yes.
Maybe it's just my paranoia. That's at 8:01 p.m. March the 9th.
Yes.
Okay. And then this is 8:01 p.m. text to his mother, the defendant, but when are you going to get home? And when was the next text response in the phone download that you recovered?
The next response was the following day on March 10th, where she said, "Where's your dad?" at 10 a.m., 10:21 a.m.
May I approach witness? Sure. This is People's Proposed Exhibit 83. Sir, take a look at that and tell me if you recognize that handed you.
Yes, sir.
And how do you recognize that?
It's an extraction report in a PDF format of a call log from a cell phone.
Okay. And that call log specifically was recovered on the shooter's phone.
Correct.
Okay. This is from March of 9th, 2021 to March the 20th, 2021.
That's on the last page. Yes, correct.
Okay. Thank you. People move to admits 83.
And I have no objection to that.
83 is admitted.
So the slide I'm going to show you is a snippet of that. We're going to go back to Exhibit 83 throughout your testimony.
Okay.
Specifically, because we're talking about March the 9th right now. March the 9th, 2021, the phone call to either his mom or dad, to his father, James Crumbley. It was a missed call at 7:31 a.m. Is that right?
That's correct, yes.
And his mom called him at 8:38 p.m., March the 9th. I'm sorry, March the 10th.
Correct, on the 10th.
Okay, so the time those text messages were being sent to his mother, there were no phone calls or texts back in that relevant time period.
Correct.
Now, I'm going to back up a day to March the 8th to give this context. May I approach the minutes?
Sure.
This is People's Proposed Exhibit 84. Exhibit 84 is the portion of a Facebook thread between James and Jennifer Crumbley, pages 386 and 388 from March the 8th of 21. Is that right?
Correct.
And you've seen this before?
Yes, sir.
People move to omit 84.
No objection, Your Honor.
84 is admitted.
So I'll direct your attention to the screen. This is blue again is Jennifer, green is James. Is that right?
Correct.
Okay, and that's because this chat specifically was deleted from Jennifer's phone.
That's correct, it was.
Okay. So Jennifer's words.
How do you know specifically that was deleted?
James, right?
How do you know that was
IDK?
deleted?
I don't know.
Okay. And she writes, "What do you mean, IDK?" His response,
I don't know exactly what I said. We'll know after he gets home.
and Jennifer wrote, "Does he have his phone? Why isn't he home yet? He should be home by now." That's March 8th, 21 at 3:12 p.m.
That's correct.
Okay. Then she writes, "Freaking out." And James's response,
He does not get home until 3:16.
and then Jennifer wrote, "I told you to pick him up because he's upset and I don't want him to do anything stupid, goddammit."
Correct.
That's March 8th, 21, 3:13 p.m.
That's correct.
Okay. And James
Oh,
writes, "Dude, chill. He was fine. I'm trying to fucking work."
okay. You know how the defense attorney said that stuff at the beginning about like, oh, she was so worried about him. This is now it looks like she's lying because if any of the jury remembers that, now it looks like she's lying and hiding stuff. Which, oh my God, like that's once again, you've got to be careful what you say in an opening. If any of the jury remembers that now, everything she says from now on, they're going to ignore her.
Correct, he did.
Okay. So for context, this is the day before those text messages were sent by the defendant's son to the defendant.
Correct.
I want to move on to March the 17th of 2021. May I approach the witness?
Sure.
This is People's Proposed 85. Sure. 85 is the Facebook thread between James and Jennifer Crumbley, pages 432 to 435 from March 17th. Do you recognize that?
Yes, sir.
And how do you recognize it?
Again, it's a printout of a Facebook chat.
Okay. And you've, of course, seen that before?
Yes, sir.
Because you were the one to pull the information?
Correct, yes, sir.
85.
85.
People moved to mid-85.
Your Honor, I'm trying to pull it up right now.
Okay, sure.
And this is the problem. They didn't give it to her in the setup they're doing, which is not fair to them. So,
It's hard for me to determine. from this-
yeah, because she's got to figure out exactly what, This is why they
Your
should
Honor,
give it to her ahead of time. This is a
I do
mess.
object to 84 because there's portions of it that are not admissible, in my opinion.
84.
I'm sorry, 85. I'm sorry, 85. There are portions of 85 that the defense objects to, and they have not been previously ruled upon by the court. May we approach?
Yes. You want to go in the hallway? I don't know. Because
I think we first need to find what the actual objection is.
The
Because we have a
objection,
foundation to chain, we have a stipulation to chain and the foundation. He's already testified to a number of portions of this very same Facebook thread.
it's hard for me to know if I've seen this one before or if I know what it is.
this has not been the subject of a prior ruling.
Okay.
I object to portions of page 432. It does discuss a topic that has been ruled to be inadmissible. So I'm asking that those portions of 85 be struck. They're irrelevant.
Okay, can I see it?
May I approach?
May I approach?
That may or may not help.
This is nonsense. The way the state's doing this, the way the state's doing this is not proper. They should be, a lot of judges I've been in front of would have admonished them. Why isn't this done? Why is this done in a way where the defense is trying to catch up? Because you know what? It does look like you're sandbagging them. It does look like you haven't given them everything. You're presenting them with things that they've never seen before in the presentation format. This is where this judge needs to put her foot down. Like, why are you guys not doing it the way you gave it out? Like, this does reek of double dealing. This does reek of hiding the ball. I mean, this whole situation could have been avoided if they had given this to her ahead of time and she could have objected. So yes, I do think this is nonsense from the state, the way they're handling this. This is not fair. This, there shouldn't be surprises. She shouldn't have to scramble to figure it out. This is eating up time in the trial. So yeah, I think this is just absolute nonsense by the state. Admonishment without consequences means nothing. Yeah, well, they need to get chewed out. They deserve it. That's what it's saying. Is this a good thing for the defense so they have an easily appealable issue? Yeah, but letting in this one issue, this one text message, is not going to sink their case. So, yes, it's an appealable issue, but guys, remember what I said. What do courts like to say? Harmless error. She's guilty anyway. You know, we had this issue went to the Michigan Court of Appeals. I said none of these judges are going to risk. None of these judges are going to look around and say, I don't want to be judged anymore, so I'm going to let her go free. You know, that was never going to happen. She was never getting away with this. So let's be real. Let's be honest. Like we all knew what was going to happen there. And we all know what's going to happen here. We all know what's going to happen on an appeal. They are never going to say, oh, yeah, wait, this was a show trial. The courts are never going to do that. So this is like, you know, appeals are for losers, yes, but a politically motivated case, it doesn't matter. On top of that, it's even worse. I mean, if this is a politically motivated issue, they will not, no judge is going to be the one who overturns this. It would be so unpopular. So, yeah, this case is going to lead to an erosion of rights, especially Michigan, sadly.
Came up. I'm hoping that we're not going to have to exclude the jury with every exhibit. So some of this I'm relying on memory. So a year and a half ago, some evidentiary rulings were made.
Well, Judge, that's your problem. If you aren't on top of that part, like a year and a half ago, you don't remember what you did. Oh well, that is a judge problem. That's a nobody else problem. But this is once again the state doing this and nobody checking the state. You are running the courtroom. You should be able to say, I want exhibits done in this manner, in this fashion. I'm sure you never had to worry about this before, but once again, you're now playing fast. You're playing with your fast and loose rules on a big case, and you can't do that.
This might be an overgeneralization, indicating that the fact that there was alcohol in the home in and of itself is not relevant, right? And then there was a ruling about.
I'm listening, Judge.
What's your okay? What's
He's just bringing me up to speed. There wasn't room for me to.
Okay, all right. So there was a ruling about.
Council moved to exclude certain pieces of evidence, and this court made a record that was June the 27th of 22.
Okay.
And in that record, actually, it was page 40 of the transcript. The court specifically said, the court indicated that it was based upon a preliminary examination transcript. As the court recalls, neither party stipulated the exam transcript for the factual basis, and the court indicated that more evidence is being found even as we speak. I think I don't want to paraphrase because that's not a verbatim quote. Okay. And in defense counsel's open, so to bring the court up to speed on the record, counsel asked to approach and objected to any reference of alcohol. There's one text in this text message thread or Facebook thread between James and Jennifer. Jennifer on March 17th says, "Gonna get drunk and ride my horse." James responds, "Well, don't get drunk." They have a couple of more text messages in the midst of a conversation that is pertinent to our proofs. And that's because the next exhibit will be text messages from the school shooter to Jennifer Crumbley about seeing demons. And then there'll be evidence of a lack of phone calls, lack of text messages back. And to get back to the court's ruling, the court said no evidence of alcohol or substance use unless it does show some type of parental neglect. Okay. So these particular messages are the same time, the same date where the defendant's son is experiencing or stating that he's experiencing hallucinating. So this is all relevant.
And Your Honor, my point is on Exhibit 85, there are texts that do not need to be included to make the point that Mr. and Mrs. Crumbley were at the barn and not with their son. We're objecting to the texts that include buying beer, being drunk on a horse. They are irrelevant. They are also irrelevant to someone being a hypervigilant parent. I would consider myself a hypervigilant parent, and I have some cocktails once in a while. That issue is not relevant. The alcohol is not relevant. It's just an unnecessary part of this text to make them look like they're out drinking when the whole point is that they're out with their horses and not with their son.
So just not counsel's idea of what the point is.
No, it's not just that they're out with their horses and not with their son. And there's no crime. There's obviously no crime committed by people with children having cocktails, and in fact, this room would probably be in jail. But That being said, the issue is whether or not the shooter's texts are being ignored. That's the point of it.
Right, Judge. And there is an offer of proof. There's substantial evidence that has been excluded that shows the substance use of James and Jennifer Crumbley. Substantial. We're not introducing any of that because of the court's ruling. But directly on point to this, in the midst of the conversation, it is relevant. It's material, it's probative, it's under 401. People know.
Okay, well, am I able to see a specific picture of, because some of it might be, some of it might not be. So I don't want to do this all the jury.
And the state's making a fair argument that even if I would be opposed to them,
It's
a valid
shooter
argument.
is having,
and it's the argument that's going to
some
win.
Trauma, feeling some trauma, and reaching out to the parents and very warning them. That evidence to me is obviously relevant.
Correct, Judge.
So-
That's-
So
I'm not objecting to all.
they're
of
making
it.
the right
I'm
arguments,
objecting to
and
portions
the
that
law
are-
supports them.
Okay.
Because the door has been open. Counsel specifically said, I think more than once, that her client is a hyper vigilant mother.
That is not-
Hang on. Nobody says anything about having a cocktail, but when there's evidence to show that they are drinking when the
Different-
son is texting things to the mother, no call back. That's important, and it's important to show the jury.
Opening the door, she said it in an opening. That's not evidence. She can say what she wants during that, and that. Yes, guys, the jury's not in there anymore. The jury's out. But this, the door's been opened. How? How's the door been opened? There's not been any discussion of her being a hyper-vigilant mom to any of the witnesses so far. Like, where? Well, hold on now. Like, she said it during her opening argument. Okay, great. The opening argument is not evidence. It's a summation of things, and it's a presentation by counsel. So this thing here is kind of bullshit. Oh, the door's been opened. How? I mean, as much as I don't like things she's done, she has not opened the door. That's the one thing I can tell you right now. She has not opened the door at all. I mean, because she really hasn't cross-examined anyone. Now, this whole idea about not being able to show it because it shows just them, having drinks, the state's accurate that this shows, and this would be probative to show whether or not she's an attentive mother and whether or not this kid is having problems. Okay, fine. Yes, they're going to be allowed to show that every day that ends in Y. That is an entirely valid argument. I think that's the state is not wrong to make that argument, and they're not wrong to get the court to support them. I fully, as much as I don't like that, I mean, that's basic evidentiary ruling that would work there. You guys, I don't know if she's pregnant. Oh my God. I'll ask David. Maybe he knows. But that's where we are with this. So the state making this argument, I think, is very disingenuous, though, that she's opened a door. She should be, what door did I open? How? And I demand, like, specifically, what line of questioning opened the door? And that's the thing. It doesn't have to be the defendant herself saying something that makes it the door opening. The door can be opened through counsel's questions that they raise. So why am I touchy about it? Because it doesn't matter to this case. You guys are like so worried about that. You guys are so worried about that. It's just like, she just might not be good. Like, you guys are trying to make excuses for her. You guys are being Captain Save-A-Ho out there. Like, come on. That's the issue here. I'm trying to actually watch this case, and you guys are like, yeah, hold on one second. Okay, according to my producer, if you go look at her Facebook, she's clearly not pregnant. So, the satisfied lasagna, or the lasagna full of content. I'm not sure which one it is. Good to see you again, man. I'm not doing this. I am not playing your game, chat. We are not doing this today. I'm looking at it from the jury's point of view. No. Holy shit. We're gonna keep moving. We're moving. Oh, but this bringing it in that she's not a good mom, it's entirely valid. Shree says, "Who is my producer?" The lovely future Mrs. Martin 2.0 is my producer. So the issue is, and it's not that they are having drinks, but when the kid's like, "Oh my God, I'm seeing demons," and she's like, "Well, I'm gonna go ride my horse." Like, that's the issue there. Okay, guys. So that's the problem.
What they actually didn't spend their time on.
Okay, can I see the text right again? And is that the only one because the jury's pulling their heels on it? Is there any more of this?
There are more like this.
There's going to be a bunch like this. Judge, like, I don't understand why you don't think there could be a bunch like this that's going to happen still. I mean, come on now.
So these exhibits were turned over a long time
I
ago.
know.
No. I got all these text messages a long time ago.
Okay.
I found out what they were planning to use from the boxes and boxes of information. I found that out
Ridiculous.
on Tuesday night. Yeah, I had this discovery, but I can't file a motion to exclude every single line of these things. I filed many motions.
Okay.
I filed a motion about the alcohol. This part of the text that they told me 2 days ago they're going to use.
That's fair. Well, that's preposterous. You didn't say what you were using, so just suppressing. You can't just file a motion to suppress the whole box. What's being intended to use would be very helpful.
Includes alcohol. I'm just asking that the alcohol portion be struck.
Okay. I understand that, but I know that there's a lot of exhibits. And I know there's a lot of documents, but we could have had a massive motion to eliminate fest a while ago, right? So I am loath to make the jury sit there while we're going line.
Well, Judge, then you should point out that both these guys are fucked up.
I didn't intend for this issue to take a long time. I thought this would be a simple objection to just take out the text about drinking, and that's it.
Okay, so she says, "I'm going to get drunk and ride my horse." Okay, so that might not be specifically relevant, but at what time does he?
When she's on her horse, that's when he's texting her.
Okay.
And
So
just
she's
because
already on her horse,
and
okay.
he's texting her doesn't
Can't
mean
stop.
she's looking at the text and ignoring him and saying, "I'm going to have a drink instead of a." I mean,
Okay, my understanding was there was a large period of time where he was texting her and she was with the horse, and then maybe some picture of the horse. I don't know.
Correct.
Tell me.
right?
That's
She's
it,
not. You're going to hear testimony from other witnesses that the cell phone signal doesn't work out where the horse place
Well,
is.
then that's argument for counsel to make.
It is.
Right, but the fact that they're having beers out there with the horses is not relevant to the point the prosecution's even trying to make about the fact that they're unavailable and not responding to their son.
Okay, there's a text from James coming. This is not what I like to do this.
Well, Judge, then get mad at the state for kind of fucking around with this. Don't just get mad at the defense. There's two sides of this mess here. And she's not being fair in that regard.
My horse, that's at 1:30 in the afternoon.
I think that's a little problematic.
That was a day during the week when she was at work. After work, she went to the barn. The text being around 5:50 p.m. When she's at the barn, we know that from pictures and metadata.
Okay, then cans.
And so the court is aware there are no other, we took all other reference out prior to trial of alcohol use in accordance with this court's order. Of course, that's subject to the door being open.
Oh,
The door is not open by me.
I'll leave this one up now.
She's a vigilant mother.
Okay, so they go to the barn after work. Is that correct? Do we know what time approximately they go to the barn? This text is at 1:30, right?
Those texts are from during the day when they're making plans to go to the barn after work.
Right.
And then
Right, that's what
I believe the text says something about leaving now.
Okay, so when are they at the barn in relation to this texts about demons?
At the same time.
Okay, but is that at 5 o'clock, 6 o'clock, 7 o'clock?
The first text, the house is not on at 6:03 p.m.
Okay.
There's a picture of James on a horse taken by Jennifer. There's a picture of Jennifer on a
And there's
horse
no
at the same
objection
time.
to that.
All right. So she says, I'm going to get drunk and ride my horse. That she's expressing her intention for that evening.
Correct.
I'm going to allow that text, but not the next one about, well, don't get drunk. We're definitely going to have some drinks. We need to stop and get me a 12-pack of Budweiser bottles, please. I'm going to keep that out. All right. And all right, I'm going to keep that out. She is indicating her intention to go later and ride her horse and get drunk. And when she's riding her horse, when she's at the barn later, is when he is texting and getting no response. So I think that could be relevant to her ignoring her son. All right.
Yeah, bro.
But this text from James Crumbley, I'm going to exclude. Is there anything else in there that
Okay,
needs to
so
be excluded?
Just for the record, page 432,
Yeah.
the second text, the
Yeah,
message
one
back from
from
James
James
Crumbley.
Crumbley. Is there anything else in there?
I'm looking on.
Because I don't want to.
No.
We were making good headway yesterday. Now we're moving in the sales pace.
You're moving at a snail's pace because the state is kind of jerking things around.
Well, Your Honor, there's also a text responding to the one about buying gears. Jennifer just says, okay, but glass is not a good idea. I mean,
Yeah, but you can strike that too, because it's referring to the text about it. It's not. Well,
so it would just be those two portions.
okay, yeah, can you strike that? I don't know how easy it is to do it up here. but-
It'll just take a minute.
Okay, all right. Are there any other issues such as this?
I'm
And
looking
look
right
and
now.
look at them. And, oh, we went. Oh my God! And then all of a sudden, typical for the state, judges know you can't do it. All right, screw it. We'll fix it.
Your Honor, I mean, the next exhibit is on the
Nonsense.
subject of a prior ruling.
Okay,
I'm,
good, that's a good way to do it.
okay, exhibit 87, 88, 89, 90, 91, 92.
We're trying on the fly to edit an exhibit,
Okay, go
an
ahead.
objection we just got, and now there's like,
Okay, I want to find out if there's any looming issues, because I.
Oh,
we do too.
There's-
because-
there's-
bullshit! You have a team. You have a team of people, honey bun. 1, 2, 3, 4, 5, 6. You've got a whole team of people. You got a team of interns. You got an office staff ready to rock and roll. And look at her. 1 is the loneliest number that you ever knew. And she's out here gunslinging it by herself. I may not agree with what she's doing half the time, but right now she's scoring points. And she's out there by herself, throwing up fucking 3 after 3 after 3 by herself. You got a whole team here. That guy's, this guy, number 2, he's sitting here playing on the computer. You can handle the rest of it. You could address things. You guys got those like fucking 20-foot thick binders. You should be able to fucking handle this. Like, come on. Oh, it's so hard. You know, she's out here crying like Big Pun. That's so hard. Go sit on this side. It's a lot harder. Oh, it's too much work. Like a government worker, like a typical government worker. Come on now. Disingenuous as hell.
10,000 steps here.
We do too.
Your Honor, I did not think this objection would be such a process. I simply was asking for like one little part of this to be struck, and
Okay,
objections during trial are common. This is
Okay.
just a very simple.
all right, but is there anything else coming up that would require the jury to step out? There's photos.
Well, I
wrote objections to such.
I have objections to many photos that are going to be brought in through a different witness, but what are they planning to use? Because I have 450 right now. If I know what's coming, I can tell the court.
Okay, well, there's a list of exhibits, and there's coming after that, after the text messages are pictures. It looks like there's pictures of James and Jennifer.
And we have no objection to those.
Okay, I just want to know if,
Your Honor, if I could just say, there's a lot of inquiry as to exactly who we're calling next, which exhibit we're, and this isn't a math formula. We really are changing this organically because we're
I
working.
get it.
So we're trying to be cooperative, but things do change.
I know, and you're not.
Aw. It's so hard with your whole defense team. Oh no. Oh lordy me, oh my
I want
boss.
to know if there's anything else that needs to be handled right now on the record.
The only other objections, I believe, with respect to
It's so
this witness, at least for the next very
hard.
long
Yeah.
time, are objections the court's already ruled on. So,
Okay, thank you.
okay, so at least we can get through, I mean, this whole page of exhibits with no problem.
Okay, perhaps council can meet with us after court today to go over the next proposed exhibits, and then we can see what objections.
Okay, yeah, it's just because I don't want to take your time.
That sounds great.
All right.
Thank
Okay.
you.
All right, so,
So 85 is modified and we're,
yes.
thank you.
Um, are you ready for the jury?
I think so.
Okay. Are you ready?
See, you say that, but the funny thing is, I'd be relatively boring because this would have been all sussed out ahead of time. They would have known how I operate, so we wouldn't have all these issues. Lawrence is saying, could she get a lighter sentence on appeal if she's good and remorseful? I'm not trying to be mean when I say this. I don't understand what you mean, Robert. I'm not sure what you mean there by that. So, sorry. But anyways, we're gonna keep going here.
With, when you say all those, what do you mean? Yeah, no, okay, these ones, just tell me how far you want to go, because I do agree with all those. Up through 100.
Oh, we want to meet now. I love that part too. Well, we'll meet with you now. It's like what, after you've been shitting on her for a couple of days?
I mean, yeah.
You may be seated. I apologize, there's a large volume of information, and we want to streamline it for you as much as possible. Right? You're sworn in.
Yes, ma'am.
Okay, go ahead.
Thank you. Okay, we're on exhibit 84, I think. All right. This is between James and Jennifer Crumbley. Again, Jennifer is in blue, James is in green. We'll start at the top because I don't know how we left off. Does he have his phone from Jennifer, March the 8th?
I'm sorry, you said you're on exhibit 84, but I believe it's 85.
84 was admitted.
84 is admitted. Yes, because 85 is March 17th.
The 84 was on March 8th.
Okay, so you're on 80, I'm on 84, okay, but mine
84 is
is,
on March 8th, and this one is on March.
This is 84 on the screen.
That's 84, yeah.
okay,
Yeah.
I'm sorry,
He might
it's
have.
scrolled down, so okay, thank you.
James responds with, yes, but he won't answer while he is walking. I will let you know the minute he walks in.
Okay. Jennifer's response, I'm serious, freaking out. Is he home yet? And then, okay, now we're moving on to 85. So James and Jennifer Facebook messages. This is from March 17th of 2021. And you've seen this before.
Yes, sir.
And this is admitted pursuant to the order that we just had on the record, correct, Judge? Thank you. Okay, March 17th, 2021, 1:23 p.m. Jennifer writes, cool, leaving at 4 today. Fuck this place. James' response is what?
LOL, you had your stuff for the barn?
And then
Oh my God,
Jennifer's
she
response,
hates her
yeah.
job.
Gonna get
Oh,
drunk and ride
no.
my horse. That's March 17th, 2021, 30 p.m.
Correct.
There's a response back. And then what does James say?
James says, okay, then cans, you had a debit card.
And Jennifer's response, I know, hate my job. Can you bring out last, please? He says yes.
Oh no, she's a horrible
Correct.
human being. She doesn't like her job. Throw her in jail. 500 years. She should never be allowed to walk in free air again.
Now, on that same day, you're finding text messages from Jennifer's son to her.
This is where's the
concerning
Vonce
March 17th,
conference?
2021.
Yes, sir.
Okay. This is People's Proposed 86. I don't believe we have an objection to this.
No objection, thank you.
This is 86.
86.
86 admitted.
All right. What does Jennifer's son write to her on March 17th, 2021 at 6:03 p.m.?
He says, okay, the house is now haunted.
And then what?
Some weird shit just happens and now I'm scared. Then it follows with, I got some videos.
Okay, Your Honor, I apologize. This was previously the subject of a motion. I do object, however, the court has already ruled it's admissible. I'm sorry, I misspoke.
Yes, I
Okay.
yes, I have already ruled on this.
Okay, sorry about that.
No, that's right.
Okay. Just at the top.
And then Ethan says, continues with, and a picture of the demon. It's throwing bowls. The word bowls is in all caps. He then says, I am not joking. It fucked up the kitchen.
And the next message after that?
He says, I'm just going to be outsider for a while. Can you at least text back?
Okay, so that's from 6:03 to 6:29. The last text, you least text back was
Hey, this is
6:29
not
p.m.
this is
Correct,
not
yes.
good.
Okay.
These
And
are
the
not
next
good.
response from the defendant to her son is when?
2 days later, it's 4:11 in the afternoon. Where's your dad?
Unless he's like got a
So
history
this
of
is
being a
people's 87 and
spasmatron.
88. I don't believe there's an objection to either of these two exhibits.
No objection.
Okay, 87 is the picture.
St.
88 is the
Patrick's
metadata
Day.
with the picture. So, could you please tell us when and where this picture was taken?
It was taken, the GPS is similar to the previous ones at a horse barn. He's on a horse. It was taken on March 17th at 6:03 p.m.
Okay, 6:03. That's the same time that the text message regarding the house being haunted and saw a demon.
Correct.
Okay, and this is actually found on Jennifer Crumbley's phone.
That's correct. It was.
And who's that picture of?
That's James Crumbley.
And that's St. Patrick's Day, correct?
Correct.
Got to throw in the alcohol angle.
This is exhibit 88 and 89 and 90. 89 is the photograph, 90 is the metadata.
And we have no objection to 88, 89, or 90.
And this is also St. Patrick's.
Can you move for their admission before you come on the screen?
Yes, sir.
Okay, thank you.
This is also St. Patrick's Day 2021. Is that correct?
Correct. Same day.
And this is an image also on Jennifer Crumbley's phone.
Correct.
Okay. And
That
when
is
was this taken?
sloppy. You should ask for that
March 17th at
permission before
6:03
you
p.m.
publish.
Same location.
It appears so. Yes.
Now I'm going to move you on to exhibit 91 and exhibit 92. I don't believe there's an objection to either of these pieces of evidence.
There's no objection.
91 and 94.
Thank you, Judge. Again, we're still talking about St. Patrick's Day 2021. What time was this picture taken?
This was taken at 6:28 in the evening.
Okay. And again, is that time and date significant to you as an investigator in this case?
Yes, it is.
Why?
It was the time of Ethan was sending, the shooter was sending the text messages.
Okay. And this is also on Jennifer Crumbley's phone,
Correct.
91 and 92. 93 and 94.
We have no objection to 93 and 94.
93 and 94.
Thank you, Judge. Exhibit 93, also a picture captured on Jennifer Crumbley's phone. This is also St. Patrick's Day, 2021, and this is at 6:30 p.m.
Correct.
Same location as the other photographs we
It
just
appears so.
mentioned?
Yes, sir.
Okay. I'm going to go back to exhibit 83. This has already been admitted. This is the phone log found on the shooter's phone. So the time we're speaking of, those text messages where he sent his mother indication that he was seeing bowls, flash, shelf, and the demon, that was between 6:03 p.m. and 6:29 p.m. Is that right?
That's correct.
Okay. So we already saw that there was not a text back from Jennifer Crumbley, but tell us about the phone log. What did he show?
It shows a phone call from Jennifer Crumbley at 7:24 p.m.
Okay. So that's about an hour and a half after he texted about the house.
But he did call
That's
her.
correct.
And
So
that
there
was a
was
19-second call?
there was a
Correct.
response.
Okay.
Did you see Tillery's message?
I'm going to move on to March the 19th, 2021. This is a Facebook conversation between James and Jennifer regarding their son that day. This is people's 95. I don't believe they have an objection to this.
No, there was no objection.
95 is admitted.
Okay. Again, Jennifer in blue, James in green.
Correct.
Okay. She said, "Is he awake?" And what did James respond?
James responds with, yeah.
Jennifer wrote, "How is he?"
James then responds with, he woke up looking like he had way, in all caps, W-A-Y, too much to drink last night, complaining about a headache.
This actually, I don't know the exact how this would work in Michigan, because in Michigan, a 17-year-old is an adult. But the thing is, I think they would argue that they were his parents. So he's 15 years old. They are in loco parentis. They are the ones in control over him. They're acting as his parents. They're the ones in charge of handling, up until that point, they were the ones in charge of getting him care, taking care of him, doing all this stuff. So I think that's probably what the argument would be as a matter of law. I don't know how well that would hold up in court ultimately under scrutiny, but I'm presuming that's the argument to be made. That's actually a very good question. I may ask David about that if he comes, if he's able to get on later this afternoon, because I'm a little questioned about that there. So, and David's saying, anything incriminating come up yet? Not necessarily so far. I think, there's this issue of the state kind of monkeying around with the exhibits that they're offering. Oh, here you go. And actually somebody who can,
Hello.
Hi, David. Making a lot simple. So you guys weren't aware this is like right down the street. It's actually David's backyard. They're doing
It
it in the treehouse.
Yes, that's exactly where they're holding this.
That's what the courthouse is. So no, this they have not done anything in that room. Or they haven't done anything bad yet. Or nothing
Yeah.
incriminating's really happened.
Yeah.
But
I see like some back and
Yeah.
forth.
Yeah.
And I don't know how far you are into it. They were still on direct, right?
Yeah, this is the big back and forth about how you guys are basically, and this is something I don't know, because you've been in this court, like you've been in this courtroom. Well, I don't, and have you been in
Yeah.
front of this judge before?
Yeah, I have.
Okay.
I practiced in front of
So-
this judge quite a few times.
So I don't want to, if I say something and you can't comment, that's okay. But
Sure.
this issue of the state, like they're doing, here, I'll take this off for a second. And the neat thing is I can draw on the screen. They were doing for a while where they were only showing a line or two of text messages, and they're showing that as an exhibit. And she's like, "Wait, you haven't given that to me like that." And they're like, "No, how preposterous! We gave you everything." Yeah, they gave her a box of like a dump of data, but it sounds like they aren't showing the exhibits to her ahead of time that they're presenting.
So what
And-
they did, so what
Yeah.
they did was,
Yeah.
and you could see it a little bit maybe later in
Mhm.
today's hearing, but definitely in
Yeah.
the preliminary examination. It's like
Yeah.
4 foot stack tall of documents,
Yeah,
which is all the text communications. They gave all of that to her,
yeah,
but then
Mhm.
and they identified like this series of text messages that we're going to identify as exhibit whatever 101, but it's 900 some pages long, and they weren't identifying ahead of time what exact page numbers or what exact text messages they were using as that exhibit. You know, of exhibit 101, which is 900 some pages long, they're only using 3 pages, and they're not telling her ahead of time what 3 pages those are. That'll actually come up towards the end of the trial. The last few minutes, they have a sort of a hearing about that.
Okay, because I'm not going to lie, I've been in front of judges who they would have stopped this immediately and said to the prosecution, "You've altered exhibits." Because when you change an exhibit, like if I'm the prosecutor, David, and I give you discovery, I'm just using you as the example for everybody in chat. If I give David all this discovery, but I present it in a different way, that's a new exhibit.
Right.
That's new discovery. I've altered what I've given him. This is a different item now. Even if I just condense it down and I'm cropping it, that's altered. If I take a video and I cut it down, that's altered. The only time you might get a little bit of a difference is like if I have color photos and I gave you black and whites.
Right.
Okay, but like I would have the right to ask for color photos. They would just give me digitals. Anytime they change something, that's an alteration of the exhibit. And that means I don't have that exhibit anymore. You've got a new document that I've never seen. And instead, they're making her scroll through 500 pages of text messages when they've got one they just want to show. And I was pointing this out before. When this whole thing happened, is the lady sitting there? Is she the prosecutor, the county prosecutor?
She is the elected county prosecutor, Karen McDonald. And then
so that is her.
Yeah.
So I thought it was funny while the one guy's sitting there working on trying to fix it, and she brings up something else, and the prosecutor stands up. It's like, "Well, we're working on this right now," and I'm like, "There's like 5 of you at the table. There's there's Shannon Smith by herself." And it's like, what? There's one guy working on the computer. You can handle the rest of this. You have an entire team. You have office staff ready to go. You have an entire squad of people ready to rock and roll. And for her to sit there and scream, "This is too much at once," I thought was very disingenuous. And the guy prosecutor who's been kind of leading, I'm sorry, you probably deal with him, and you might think he's probably a nice guy in real life. He's a complete fucking asshole in this trial.
No, he's an
my
asshole.
opinion. He is? Okay.
Yeah, no, I don't know him personally. I'm not buddies with him, but he's definitely acting as an asshole, right? In this particular case.
Well, and I just bring that
just
because that's the pond you have to swim in, so I don't necessarily want you to have to take that position.
I bet you should hear some of the things that I've been saying about him. I've been streaming this case for the last couple of years, and definitely this trial for the last couple of days.
Yeah.
But what's interesting is that they go through these text messages. The one most important thing that came out of opening statements that resonate with me, and I keep repeating, is slivers of evidence from the forest of trees, right? if you
Mhm.
heard the defense say that, and she'll reference that again,
Mhm.
that they are pulling out a dozen or 24 text messages amongst thousands and tens of thousands of text messages between these parties and everything else.
Yeah.
And they're just trying to make it look like this mother didn't do anything.
Mhm.
And it really forces the defendant to have to take the stand. The defense said that she's going to testify.
And yeah, I guess the one thing I will say about her opening, I don't like making promises in my openings.
I know.
Because let's say there's a change in the ground radar. Let's say there's a change in the battle.
Mhm.
I've promised you something that I have not delivered on now. And yes, there's a Fifth Amendment and the jury's admonished to understand that doesn't matter. But guess what? You made a promise you haven't kept.
Yep.
And why isn't she talking now? Well, now you're a liar. So that was like my biggest problem with her opening. I get it wasn't the best, but you know what? We don't have to hit home runs. I thought it was kind of long-winded.
It was a
But
little long-winded. It was a little convoluted. You need to see cross-examine of this witness.
Yeah. Okay.
I feel like the defense is a little overwhelmed, to be quite honest.
Oh, sure. Well, the one thing I am a little disappointed in her in is they showed a video and she's like, well, I didn't watch that because it's not relevant to our case. And it's like, that's not the answer I want to hear coming out of your mouth.
Yeah.
It's like, you should watch it and say it's not relevant. But it's like, yes, everything Ethan did has, them showing these kids getting smoked in school does nothing but to inflame the jury. And I get that. But she should have watched it like, I've seen it. Not like,
well, it would have been so the issue there was that the defendant was crying, right?
Yeah.
And that maybe the prosecutor was crying, but maybe the defense attorney was crying. Maybe the defense attorney was responding to her client crying the way she was.
Yeah, no, that part I'm okay with.
My client has never seen this before. I have to go to their offices to see it. She's in Oakland County Jail. I obviously can't show it to her. She's never seen it. This is her son doing very bad things on that day. Very bad stuff. It's traumatizing for her. And like the judge said, some emotions are involuntary. You can't control them. And that would have been a better approach other than I just don't like her response as a thing. It's not my style. That's the bottom line.
Yeah, well, and it sounds weird to the jury, but that whole when the prosecutor's like, well, we don't have to cry. It's like, bitch, it's like, that's not, this is like, okay, oh my God, we're holding the state to a standard. Sorry.
Mm-hmm.
And also, I think this is nonsense treating this like it's kiddie porn, that she can't have a copy. Oh, we're sorry. We don't want it leaked. Too fucking bad.
Yeah, I know. But there's a gag order for place. And if the prosecutor turns it over to the defense and it gets leaked
out, you know where it came from.
You know where it came from, right?
Yeah, I don't know. Jeez, I probably would have. I have a feeling this judge seems a little more prosecution friendly. I feel like I would have walked myself into trouble long ago on this case. But like, oh, I don't like. Too bad. I'm not coming to your office to view it. And I guess I'd have been filing tons of interlocutory appeals.
Well, there were a ton filed, but not probably enough. There's a new issue that creeped up that you heard arguing at the beginning of this with Ethan Crumbley and his testimony. What I don't like about this judge, her ruling. So some of her rulings have been fair, like she excluded the state's experts. But what she did allow are these text messages, and apparently Ethan's journals are going to come in. And she got those under present sense impression exception to the hearsay rule. And I don't feel like that's appropriate.
That's not a present sense. That's Ethan's own present sense impression. So it's almost like that's because the present sense impression is
of the
witness. If you read, if I had read them that day, what did I think? It's like now we're way after the fact, and these are present sense impression to months old statements. Yeah, that's not. Yeah, I agree. Wait, hold on. I'm trying to think my way through this. How would I
know, right? How would you get there? I have a hard time with it, other than she found a way to.
I mean, good for her. But that makes no sense to me, and I can't believe the judge let that in because this judge seems to know her evidence pretty good.
She does. She wanted it in. She didn't want the hamstring the court on the whole Ethan or the prosecution on the whole Ethan thing.
Yeah.
I don't know. I'm not going to try to read the tea leaves for the judge, but she seems balanced to some extent. Like she called out the prosecutor. Your own witness can't say that this was predictable. So no, we're not going to allow your witness to testify.
Yeah, no, and I think overall she's been pretty good. I'm just surprised the judge made that ruling. Like, I understand maybe the judge is like, look, I understand it's not fair. You can't have Ethan here, so she's kind of giving her one. But at the end of the day, I still disagree with this ruling that, well, if you're going to bring in a witness, you know they're going to plead the fifth, you can't bring him in. It's bullshit. I'm making him come up there and say that.
Yeah. There's a lot of issues I have with the whole Ethan Crumbley Fifth Amendment and all the saga that goes with it. Yeah,
it doesn't matter. That's my presentation of evidence is he won't answer questions because, okay, well, that's the state's problem. You know, they should offer him immunity at this point or something.
Yeah. They wouldn't even mention his name during jury selection. When they went through the list of like 100 potential witnesses, they didn't mention his name at all because he had already filed his Fifth Amendment notice.
Well, but that's still, I think they claim they're doing that because, we don't want him to have, pride in what he did. No, it's because if they remove that name, there's only one name they're hearing, Jennifer. If there's no more Ethan, all they hear is Jennifer. And I think that's why they did that.
Yeah.
They were able to hide it under that. We don't want to give them credit. I think they, the state is using an ulterior motive there.
The other thing that I'm still looking for an answer for, and I've emailed the court a couple of times. In Michigan, the jury's allowed to ask questions. They're not in this case, and I don't know why.
Is that up to the judge, or do they have the right?
It's up to the judge.
Okay.
But I don't know why, so I was trying to get some answers to that.
Does she normally do that?
Yeah, she normally would.
Oh, I think she knows it's going to turn into they're going to ask all kinds of stuff they're not allowed to ask.
Well, but the thing is that the jury writes it down, it goes to the judge, the attorneys confer, and once there's a ruling on whether or not it's an appropriate question, then the judge reads it to the witness.
Yes.
Now, it might slow down the process, and maybe that's the real reason why. But I don't know. I was excited for jury questions, particularly on this case.
And David's right. Normally, like the courts I've been in where the questions get asked, you stand there in front of the judge, you go through them, and the judge says, okay, there's and the judge announces like, okay, there's 2 questions we can ask, the rest we can't for evidentiary reasons. And, but I've had trials before where you're ask a question, juror number, whatever, you don't know which number it is, but you see the writing come back the next time around. Why wouldn't you answer my question?
Yeah, I know.
It's like, what are you hiding from us? And I'm like, holy Jesus. And
another weird little thing with this particular case is I covered a case, Megan Amirowitz, who was charged with the involuntary manslaughter of her dad. Yeah. Who lie on her. She was in Oakland County Jail with Jennifer. I covered that case, actually did an interview with Megan's mom and Megan. Well, I learned then that Megan had made friends with Jennifer Crumbley while in Oakland County Jail and saw Jennifer as a mother. And so I did an interview with her about Jennifer. Well, now she's a state's witness. Megan is. And I'm wondering if she's supposed to be like some sort of prison snitch or something.
I have a feeling maybe, yeah.
So that's interesting as well.
But yeah, this Secret Service agent, I hope she tears him apart because while he's sitting there and he's like, he came out all proud with his chest out. It's like, if I was, and I don't know Shannon Smith's style, but I'd be like, objection, who the fuck are you? Why? I don't need your editorializing. I don't need you crying. What did he do? He started shooting people. Like, come on, bro. Let's get. I hopped in my white van for, when I came out there and I just started hugging all the little churtling as some sweaty weird guy they've never seen before.
Are you talking about the ATF agent or this?
No, I'm talking about the guy who's the Secret Service guy now.
Oh yeah, yeah.
He worked for the sheriff's department. He's like, I just started hugging the children. I'm sure they're like, fuck is this guy hugging me? Oh, I'm here for y'all. It's like just some of the ATF agent. I will say last night though, we were watching her. I think she stepped on a couple of landmines out there with that, where she talks about like what's normal. And it's like, because then the state got up and said like, well, are you normally supposed to keep guns locked up? Yes. Why? And there was like, Ethan playing with the gun and taking pictures with it.
By the way, the other thing with the ATF agent,
she set herself up there to not look good there.
She did what she should have hammered on. And like what I'm grasping in real time is Google Locations is placing both Jennifer and James at the home with Ethan, and therefore you don't know. Well, that took wrestling. You don't know if his parents are standing right there with him. That took like 25 minutes to wrestle that.
He's trained to do that.
I know, that was so infuriating. But she finally got there, and then she needed to move on. But instead, she then asked a bunch of convoluted questions. And
Well, the one big one I think she should have asked is, so the ATF is in charge of the ATF investigates straw purchases, right? Yeah. Did she get charged with doing a straw purchase? No. Boom, move on from there.
Yeah.
Because like the state's hammering on this that it was a crime. Like, you know what? If the state, because the state's got a problem, because if they try to go up and say, well, do you prosecute every crime you see? If he says no, they look like the state's in a bit of a bind at that point because they kept on pointing out how this is wrong. Well, if the feds never prosecuted it, that looks bad. It's not like he can go up there and say, well, do you prosecute every crime you see? And he'll say, well, no, we don't always arrest people. It's like, would you, and this is where, if this is where you can kind of get, I think, the ATF in a little trouble there. Would you agree this is not an average situation? If he says, yes, I agree, that makes it look like they kind of jerk this around. Where if he says, oh, no, this happens all the time, that you can kind of ship, okay, then why are we here? He'll be like, oh, no, in the hood. He's like, this is Oakland. He'd look at her and be like, look, it's Oakland County. Out in the hood part of Oakland County, kids are shooting up places and mom is like, they got guns stashed in the house and mom don't care. Boom. And you can, I think there's ways you could have done, I also will say for her, she's not a firearm person and it shows. And the ATF guy knows, like, in these cops know enough more that they're kind of like, they can avoid the questions, but sometimes I don't think they're also getting what she's getting at, but she's not a gun person and it shows. And I think that's a bit of an issue for her.
Yeah.
I don't think she did her homework on that ahead of time.
No, I don't think so. I don't know if the defense attorney is pregnant. Everyone keeps asking me. I have no idea. It doesn't matter anyways.
No, they have their everybody's got their kinks, so that's why they're asking, I guess.
I guess. Did somebody say
so?
No, cool. So you've been streaming for 2 hours, so you've got another 4 hours, 5 hours to go.
Yeah, I got a couple more. Yeah.
All right. Well, I won't hold you up. I just wanted to pop in and say hi and
thank you.
This is very interesting case. I'll watch with you a bit if you want.
Oh, sure. Yeah, if you want to, that's fine. You'll hear me spurg out a little bit. So I'm sorry in advance.
By the time this trial is over, she'll be knocked up by the time this trial is over. So by
Jesus, you guys. Yeah. So it's youtube.com at Making Law Simple. Guys, that's where you can find David. He'll be streaming the trial starting tomorrow morning at 8:30. And I will say real quick, because I'm doing the Michelle Trakunas trial. She's a lady up in Connecticut. She's like she's the mistress who helped hide the body and they dumped it all over Hartford, Connecticut. It's funny because the judge up there, he's like, yeah, we're going to start at like 10:30. So like they'll run like 5 hours a day total, including like lunch. And I'm like, where's this judge been all my life? Because yes, when you're like in the Midwest, when we do trials, it's like we're starting up at 8:30 in the morning. Have a great day, counselor.
Yeah, no, that's exactly what it is. And then they're going till 5 and they get like a half hour. I jumped on Laid Back Law on Friday. I thought I was going to have like an hour and a half. And I jumped on. I was on for like 25 minutes and then it was up back in court. So
a half hour lunch?
Yeah, it was real quick.
Jeez.
Yeah.
That's going to piss off the jury more than anybody.
Well, the jury has their lunch brought in for them. So they just go into the back room and eat it.
Well, I know, but still, but that's nicer getting like catered.
Yeah, they are getting catered.
So,
so someone had asked, right before I came on, about juveniles being charged. So, the culpability of the parents doesn't
go away.
Yeah, it doesn't go away just because they're charged as an adult. Essentially, if the minor is between ages of 14 and 18 in Michigan, and what they're alleged to have done amounts to a felony, they can, at the election of the prosecution, charge them as an adult. That's really what it is. It doesn't go to the mens rea or the parent's culpability or anyone else's culpability. It just has to do with that defendant. It doesn't affect any other person involved. So, so that's how they can be charged, even though he was charged as an adult.
Exactly. And that's, I think I made that argument. I don't know if it came off as clear, but yes, Michigan, you can be an adult at 17 in Michigan too. So
yeah, that's
a little different than Ohio and, some other states.
Yeah, but as young as 14, we had a 14-year-old go away for a long time, but he got parole, doing some nasty stuff.
Got parole. Well, there we go. And also, David, are you a big wrestling guy?
WWE wrestling or
Yeah,
like
yeah.
singlet wrestling?
I-
I
I'm
used to
not-
be back in the
Not,
day.
yeah, not
I'm
Dan
Stone
Gable type.
Cold and The Rock kind of
Okay.
generation. And Hulk Hogan.
So
before
I don't
that.
know if you heard. There's if you read about what happened with Vince McMahon lately.
I
it's-
heard about it. I haven't read it
Oh.
yet. Is it bad?
Yeah, it's if this all happened, I'm partially surprised because he's like a 75-year-old guy doing all kinds of crazy sexcapades. But
Is this
it was
alleged
funny
to have
because
happened like recently or 30 years ago.
oh no, it happened like in the past 2 or 3 years.
Okay.
So I read the complaint on Friday night, and it was really hard not to do it in Vince voice.
I have to go back and check it out.
Yes. So if you get the chance, read the complaint. It's hilarious.
All right.
But anyways, let's get back to this. Sounds like it's going to get more interesting coming up, if I'm not mistaken, based on what you said. So here we go.
And then her response as well, he was really worked up and out of control, so I can see why. That's March 19th, 21 at 9:41 a.m.
Correct.
About 48 seconds later, she wrote, all I know is he needs to eat, go to work, and work hard and not complain, and he can get his stuff back.
Correct.
And then March 19th later on, he responded and didn't get it. That's Jennifer Crumbley's word?
That's correct, yes.
Yes. Because you did have Mark 95 down for admission, correct?
Yes.
Thank you. Okay. Now, the next day, March the 20th, did you find text messages from the school shooter to his mother, the defendant, of a concerning nature from that day?
Yes.
This is Exhibit 96. I believe this was subject to a previous ruling.
Any objection, aside from what was already noted?
No,
96.
The reason
Thank
I
you.
say that is they say that they only text and care about their horses or something else.
Yeah, they're parenting him. Apparently, he got in trouble,
Yeah.
so he can get his stuff back. Yeah.
Yeah.
We're still on 95 on the slide. James wrote, Jesus, yes. He said, referring to their son, let me ask you a question. Why am I in your guys' room? LOL. And Jennifer's response is what?
OMG. Oh my God.
This is a little clumsy the way they.
I have to back up just a little bit, Judge. Sorry, thank you. So just to make sure everybody's on the same page, this is Exhibit 95. This is March 19th.
This is not. I'm not impressed with how they're
2021
doing this at all.
At 9:41 a.m. when Jennifer wrote,
They've had all this time to
was worked
prepare,
up, out of
too.
control. In the same text message conversation, there's no breaks in this exhibit. And the conversation continued. James wrote what?
I totally thought you were giving him a Xanax last night. ...
And Jennifer's response was,
Does he seem better?
and then
No melatonin.
and James wrote what?
I know.
And Jennifer wrote,
But he hasn't had one before, so I should have only given him half.
and then James' response is, he's doing his school, says his head hurts. He took Tylenol.
Correct.
Okay. And Jennifer's response was, is he okay to work? That's at March 19th at 11 a.m.
Correct.
And James' response,
Was yeah.
and then
Yeah.
also it's 11:13 a.m.
Correct.
Okay. And then Jennifer wrote 11:38 a.m. on March 19th. Does he remember what he did?
Correct.
Okay. What was James's response?
James responds with, dude, I am working on a demo right now. I have not talked to him and he is doing school.
And then her response is,
Okay, then, geesh.
okay, thank you. This is 96 that we just admitted. This is from March the 20th of 2021. And again, did you find text messages from the school shooter to the defendant of a concerning nature?
Correct.
Okay. In the blue, that's all the school shooter's words?
Correct.
Okay. What did he write to her?
He starts with, I finished picking up the room. That was at 2:38 on the 20th.
2:33.
2:33, I'm sorry, yes. He then says, I cleaned until the clothes started flying off the shelf.
And then what?
This stuff only happens when I'm home alone.
Okay, it's March 20th, 2021 at 2:34 p.m.
Correct.
Was
This
he
is
ever
the same date
diagnosed
time?
with having hallucinations,
What
or
did
is
you
this him
I
making?
picked the
shit
clothes
up?
back up though.
This is him making
It's
stuff
March
up.
20th at
He was never
2:34.
diagnosed with anything. Even
Okay.
with all the post stuff for his Miller hearing,
Yeah.
and all the psychological evaluations that he went
Yeah.
through, he's never been diagnosed with anything. Also, I will say around
And
this
that's
time-
what she wanted to bring in. It sounds like this morning she was complaining about trying to get in.
Yeah, that's what the
Showed this
defense
is all
counsel wants to bring in.
nonsense.
Yep, exactly.
Okay.
And there was a ruling by the court that that stuff can come in, and prior to the trial, anyways. And I don't know if there's an issue with it coming in now or not.
It
since
sounded
Ethan's
like
not
they
coming
were
in.
bringing up the privilege issue that Ethan hadn't waived privilege and you can't just get all these records.
Yes. But the judge made a clear ruling that the privilege is it doesn't apply in this case because it is it's relevant to the defense's defense and the state's allegations and things like that. So it was allowing his mental health records to come in despite his objection to it, despite Ethan's objection to it.
Okay, because it sounds like the judge had said, no, you're not allowed to. So I don't know. Maybe there was another set of records they were talking about because I was a little
confused by that too. What I think they were talking about is, so Ethan has now given a notice that he intends to plead the fifth and not be called to the stand. And the defense filed a motion to compel Ethan to appear, to at least plead the fifth, apparently.
Yeah.
Yeah. And that's what they're talking about. Also, I think it also had to do with an argument that the defense was making. Well, if Ethan's not going to testify, then the state shouldn't be allowed to admit the text messages and the journal entries.
Yeah, I agree.
And that's where the judge had said earlier, no, I already made a ruling on that under 803.1, which is the present sense impression BS argument. I don't know how they got that. But anyways, it was like the present sense impression upon the parents having seen it. If you could, maybe, I don't know. If you could, that's the only thing I could think of. If you can establish that the parents actually saw these messages. A lot of the bad ones are between Ethan and his friend. But what I wanted to say was in March, or end of March, early April, his friend is sent away to somewhere. We don't know. We're assuming it's some sort of camp for troubled youth or something like that.
Okay.
And some people in my chat were wondering, well, is he acting up the same way his friend did in order to then get sent to the same place because his only friend is now gone and he wants to go with his friend there? But we don't know because all that is hush hush. We don't talk about the friend. We don't talk about what he did, who he is, what he did, where he went or anything.
Okay.
So that's kind of an interesting little part that might be feeding into some of this. I'm seeing demon stuff now.
Yeah, because I see this all, and I'm like, oh, the shelves are coming apart, and I'm like, he must act like a spaz all the time. They're just like, yeah, whatever, you're being a dumbass. It's kind of the vibe I get from this.
Yeah, well, like my son, when he was younger, he's 16 now, but when he was younger, he really loved ghost hunters, like when he was 13, 14 or so.
Yeah.
And he would always be like, Dad, there's a ghost in the house, whatever. I'm like, oh, okay,
you're like, okay,
cool.
Cool story. Yeah.
Yeah, thanks. Whatever, or, I had this demon visit me in my sleep last night. Okay.
Okay, cool. Yeah. Tell him to take you away next time.
Yeah. But, then maybe, a few hours later or whatever, we'll have a talk about it when I get home. He's like, okay, there wasn't a demon in your room. But, as kids do kids things. And you don't
that's what I hear.
Respond to it immediately. This is not an emergency situation.
Yeah, I just get the feeling like it's happened a million times before. She's like, oh, for fuck's sake. I'm ignoring this now. So
yeah. And there's just a whole bunch with Ethan. Like Ethan, during his sentencing, took all the blame and said his parents had do nothing with it. And I was like, okay, cool. And he said he was going to testify.
Well, that's a transcript. That's a transcript thing, too. You said this.
Yeah, it is.
Played the fifth. There's no more culpability for you to assume either.
Well, the other thing, though, is that he's filed. So in Michigan, you can file to set aside your plea if you don't get the sentence that you were expecting. And since he got no parole, he has filed an appeal on his no parole and a motion to set aside his plea. So technically, if that gets done, then everything's open again. And anything he says will be used against him. So that's how he has the Fifth Amendment issues. So that's what's going on with that.
Okay.
Yeah.
That's interesting you guys have that right, because here it's just like, oh, well.
Yeah.
Whoopsie doodle.
I mean, I don't think it's going to get granted. His motion to set aside his guilty plea, I don't think it's going to get granted, because usually that's when you have a Cobb's agreement where the prosecutor and the defense and the judge have all agreed on a sentence ahead of time. And then if that doesn't materialize, then you can withdraw it. But so I don't think it's going to work, but it's still up in the air. So technically he still has that Fifth Amendment protection.
Okay. All right. Well, let's keep going, guys. I hope
I could jump off and stop.
No, not at all. Not at all. I appreciate that. You're able to provide a little more information that I don't have. So if you want to stick around, David, I'm happy to have you. So
yeah, I can stick around for a bit.
Yeah,
we got the Lions game coming up.
Well, oh yeah. Well, good luck. I'd say can't wish the Browns luck right now. So
Right.
Correct.
And when was the next response to that?
By Jennifer was on the 22nd of March at 8:17 p.m.
So I'm going back to exhibit 83, which is the phone log found, recovered off the school shooter's phone.
That's funny.
Specific to these days. Okay. So we just went through March the 20th, and those messages were sent about 2:30 in the afternoon, if you recall. Is that right?
Yes, sir.
Okay. And were there any phone calls in that time period?
No, there was not.
Okay. In fact, the next call was 6:37 p.m. on March the 20th.
Correct.
I'll put the jury in chat.
No objection. Oh, sorry, you can say the numbers. There's no objection.
97 and 98, Judge, I believe would be admitted.
We have no objection.
97,
Thank you. So, sir, were you able to tell where James and Jennifer Crumbley were yet again on that day?
Yes, sir.
Okay. This is 97 and 98. 97 is the photograph, 98 the metadata. This is March 20th, 2021 at 1:51 p.m.
Correct.
Okay. And if you recall, the text messages from the school shooter were sent to his mother about 2:30 in the afternoon.
Correct.
Okay. So tell us where Jennifer and James Crumbley were at the same time.
They're
Almost
riding the horses
cool shooter, not school shooter.
99 and 100
No objection.
Is it 99?
and 100.
No objection to either one?
No objection to either one.
99 and 100 are admitted.
Thank you, Joe. Okay. Now this was taken off of the last picture. Was taken off of James Crumbley's phone, 97, 98.
That's correct.
99 and 100 were taken off of Jennifer Crumbley's phone.
Correct.
Okay. So the capture time here, March 20th, 2021, 11:58 a.m.
That's correct.
Okay. So then that would indicate to you that they were at the barn at least from that period of time until at least 1:51 p.m.
Correct.
Okay. Sir, during the course of your investigation, did you come to learn that the school shooter had only one friend?
Yes.
And did you also learn that that individual was abruptly taken from the state of Michigan about a month before the shooting occurred?
Yes, he was.
And did you review the text message thread between the school shooter and that other individual?
Yes.
You looked at the entirety of the phone of the school shooter as well as James and Jennifer Crumbley's phone, is that right?
That's correct.
If you could give us an idea, the volume of the data found in the text message thread between the school shooter and his friend.
There was over 20,000 text messages.
That is
between
very
two people.
questionable. I agree.
I've done exams on phones where
Locked.
the combined number of text messages is that much.
So what's the relative size and data between that particular text message thread and any other thread between the school shooter and anybody else?
I think the most text between any other person might have been near 500 as an individual person.
I'm going to show you a portion that's been previously admitted by this
Fair point, vodka
of that
blood.
text message thread from April the 4th of 2021, April the 5th of 2021. That's exhibit 101.
And the court's previously ruled on this.
All right. One one's admitted.
Thank you, Judge. So we have names redacted. 101 was found
Thank you,
on the
Judge.
shooter's phone, is that correct?
That's correct.
Okay, so in this instance then, the green would be his words, the shooter's words.
Correct, yes.
Okay. Tell us what he wrote to his friend on April the 4th of 21.
The shooter wrote, like, I hear people talking to me and see someone in the distance, and then corrected the spelling of the word distance.
It's April 4th, 11:56.
Correct.
Okay.
Yeah.
What else?
The shooter said, I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to, quote, suck it up.
And then what?
He then says, like, it's at the point that I'm asking to go to the doctor. Then he says, my mom laughed when I told her.
So that's
So this is Ethan talking to a friend, right?
Yep. Yeah.
And
So
he
how is
went
this
to the
admissible?
doctor. They took him to a doctor.
Well, okay. Do we know
Ta-da!
that?
Ethan said so. And we can't get his medical record, so Ethan said so. Or like the state's claiming Ethan is the important person here. They said he went to the doctor. Boom, done.
The thing though is that this is like double. That's not even double hearsay, but it's like a weird out of left field hearsay. And in addition, what would your first question be on cross examination regarding this particular document?
Yeah, who is he talking to?
Well, who's he talking to? Do you know for sure that he did go to the doctor? He didn't go to the doctor. Do you know the outcome of that? Do you know what
actually,
the
I would,
diagnosis was? Do you know anything other than he told a friend?
well, I would stay away from that. I would just say, hey, they're telling you this is Ethan's words, and from the mouth of babes is their argument here. Ethan was screaming for help. Okay, they got him help. The state even said they got him for help. They're not contradicting that. They didn't bring in a doctor to say, oh, he didn't come in, or they're going to say, "Oh, Jennifer didn't actually take him anywhere." I would just I would hang the state on this text right here. They gave me some pills and they told me to suck it up.
Yeah.
Well, they didn't bother telling you what that actually means. I would just hang the state's own words. Look, she did it. Boom. And I'd point out, like, oh, parents don't listen to their angsty teen who's got mental health issues. Every teenage boy in America. It's like, welcome to becoming a parent in America. You all remember your times. Was it tough being a kid? Yeah. You felt like your parents didn't listen. Oh, God, it's like your parents didn't listen to you. I know. Well, Ethan's mom took him to the doctor. The state even said so.
Yeah.
They're not, because I'd point out, like, they're claiming that they're not saying this is a lie.
Well, later on, they'll say they'll imply that Jennifer was all concerned about the horses because the horses had this rash that they were taking care of, but there's no texts about their son at this point. Like, what? But you just saw a prior text where they're talking about their son. They're obviously communicating about their son.
Yeah.
And just because it's not said in text doesn't mean that it didn't happen either. But that's the implication that the state's trying to say, is that if it wasn't said in text, it wasn't happening.
Yeah.
They obviously didn't care about their son at this time, only their horse.
Yeah, and like I said, David, I'm sorry, I wasn't trying to jump on you there. I was just like, he took him to the doctor.
Yeah.
Care has been met. Duty of care. Let's go home. I would immediately make a motion at this point. They claimed there was no duty of care met. She took him to a doctor. We're going home. Pack your bags.
This was all admitted at the preliminary examination. There was a motion to quash the preliminary examination. And this judge said no.
And this judge seeing this saying, oh, well, they never did anything. Well, they clearly did something.
Yeah. And the Court of Appeals opinion said basically, well, did they give him unfettered access to the gun? And did he actually pay for it himself, meaning Ethan? And was it really his? Was this a straw purchase? Mm-hmm. If the state can establish that, then they might have a cause of action here. It's essentially what the Court of Appeals said. But we're not seeing that argument being made, at least just yet.
Well, and I also still think that this judge is not, even if I was this judge, okay, great. I get it, though. She doesn't want to do that because she doesn't want to get fired. Because if she were to throw this case out and say, they met the duty of care, Jennifer, you're free to go. Have a nice day. She's not going to be judged come next election. So I get that. And I also get why the Court of Appeals punted too. They don't want to lose their job.
Well, I think they also want to see what the Supreme Court said is we want to see a full factual development before we weigh in on this.
Oh,
we haven't seen a full factual development. And that could be the very thing that this judge is sitting on too. She hasn't seen a full factual development on this.
Mm-hmm.
So who knows?
Yeah, but I mean, the argument is, well, they never took care of him. It's like, but they clearly did. So, I don't know. I see that as a fatal argument.
I do too. I do. It's a really bad argument.
So, all right. Well, here we go.
April 4th, 2021, 11:57 p.m. His words, my mom laughed when I told her.
That's correct.
Okay. Now, April the 5th at 12:06 a.m. So we were looking at a conversation right up until midnight, April 4th, and now we're in the early morning hours of April the 5th. What did the shooter write?
Shooter wrote, but I'm having bad insomnia RN for right now and paranoia.
And then what?
He then says, I need help.
Okay. And the next text?
I was thinking I calling 911 so I could go to the hospital.
Then there's a response from his friend on April the 5th.
Correct.
At 12 a.m. And then what did the shooter write?
The shooter writes, but then my parents would be really pissed.
Now, April the 5th, 2021 at 12:30 a.m. What did the shooter write?
Shooter writes, I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. Then he says, but this time I'm going to tell them about the voices.
All right. Next text.
He then says, like I am mentally and physically dying.
Okay, well, that's not good looking good.
Yeah, I know.
But he's already been to the doctor, so.
Well, that's my point. Is like we don't know if he's just spouting off to his friend or if this is true. We can't.
He's a dumb kid.
Examination of James's phone, Jennifer's phone. and the school
But we have to
shooter's
take
phone,
these words at
you're
their
able to
face
look at
value.
certain apps that are installed.
Yeah,
Is that
but you
right?
shouldn't
That's
have to.
correct.
You should be able to
Did you
cross-examine these
discover
words
if
if
an
you
app
can.
called
Exactly.
Life360 was installed
Yeah.
on Jennifer Crumbley's phone?
Yes, it was.
And what is Life360?
Life360, it's a tracking app that friends and family can install on their phone so they can know where they're at. I have it on my phone, and there's a family group, and my kids are on it, and I'm on it, my wife.
Did you find that app on James Crumbley's phone?
Yes, it was.
And through that app, you can
His
see where
kids never
someone's
lie
at and
on
where they've been.
those.
Is that right?
That's correct.
Was the phone ever
And you looked
activated,
through
or was the
school
app
shooter's
ever
phone as well, the
active?
defendant's son?
Correct.
Was that app installed on his phone?
No, it wasn't.
So it's just installed on James's phone and Jennifer's phone.
Correct, it was.
And that was on April the 5th of 2021.
I believe that's when it was installed, yes.
That's the same day as these text messages, like I am mentally and physically dying, and asking to go to the doctor.
Correct.
Exhibits 102 and 103.
I'm sorry, are these, this is 102 and 103? We have no objection, sorry.
102 and 103. I'm sorry, did you say that the date of installation is April 5th? Is that what you said?
Yes, ma'am.
So on the screen here, we can see the timestamp purchase date, April 5th,
You guys can see the
2021.
cat.
That's on Jennifer Crumbley's phone,
Huh.
correct?
Correct, yes.
Okay. And exhibit 103 on James Crumbley's phone, we have April the 5th, 2021 as well.
Correct.
During the course of your evaluation of all the electronic information, digital evidence available to you, did you uncover evidence in the spring of 21 of Jennifer Crumbley talking to a friend about what she saw as depression in her son?
Yes,
And were you able to review a Facebook conversation between Jennifer Crumbley and actually the school shooter's only friend's mother?
yes.
Okay. So I want to make sure that
Objection.
I'm
How do you
clear
know
with
it's
you.
his only
in
friend?
April of 2021, which is the same month.
I know, I
these
hate
text
these
messages,
things, but there's no
Jennifer Crumbley
objections.
texted her son's.
I think it
only
works
friend,
actually
mother,
for the
correct?
defense.
Correct.
Okay. And in that conversation is when you uncovered
Okay.
concerning text messages as an investigator to this case.
Correct.
This is 104.
Objection. What concerning? That's
Thank you,
editorializing by the state
and
too.
let me just
But
take a look, I'm sorry.
Yeah.
Yeah, I have no objection to this, thank you.
The defense
That just,
will get objected
Yes,
to when
thank you.
asked to characterize
Okay,
text
this is
messages.
April
later.
29, 2021.
oh yeah, that's because that's how the state works.
Now, this is
Don't
from
give them an inch if they're
Jennifer
assholes.
Crumbley's search warrant return, correct?
That's correct.
So she's agreeing to these.
Correct.
All right. So what did she write?
She starts with, Ethan isn't bowling tonight. Just want to let you know. Not sure if they need a partner or not.
Okay. And then her son's friend's mother, also named Jennifer, writes, is he feeling okay?
Correct.
And the defendant's response?
She responds back with, yesterday he wasn't, and he's been acting kind of depressed. So I don't know what's going on.
Okay. This conversation continue?
Yes, it does.
What does the defendant write?
The defendant says, I'm not sure if there's something bothering at school. He really doesn't feel good. I can't get anything out of him.
Okay. And the person she's communicating with writes her son's name too. He stayed home from school today. The only time he's happy is when he's with the school shooter.
Correct.
And then her son has 2 E's and 2 B's. I'm wondering if he's worried about that. That's the other individual worried about her own son.
Correct.
Okay. That's 5:24 p.m. on April the 29th.
That's correct.
The conversation continues. What does the defendant write?
The defendant says, yeah, this is all new to me. I'm not used to Ethan being moody. He's usually pretty happy, and we'll talk about anything. I do know Ethan's been stressed about school and his grades. We called the school, but she wasn't in. Social, do it tomorrow. I think his grades have a lot to do with it. He just got to a point where he got so far behind when we were out of town. He's having difficult time making it up.
And then the other individual writes, I'm sorry, her son's struggling too. To be honest, I'm sick of fighting with him about it. Stupid online school really messed him up. I'm thankful her son has the shooter as a friend. They laugh and have a great time together. That's
So this
April
really was all
5/31.
because of COVID.
That's correct.
Okay. And then what does Jennifer respond?
Jennifer responds with, yeah, me too. I'm just glad they're still getting along. And it wasn't an issue with those two as to why he was being depressed. The online
This
school is
case is a
horrible. I've
direct
given up
result
too.
of.
I just told him to do the best. Don't worry about it. Next
Yeah,
year
no,
is
I'm
the new year.
serious.
Okay.
Sounds
and then
like.
What's the next?
Sounds entirely
She
like
says
that.
maybe if, he's referring to the shooter's friend, feeling better, if he wants to come over after work on Saturday, he can take him up to go bowling and make up their scores. He's more than welcome to stay the night and go to work in the morning. We set up a little shooting range in the backyard for Ethan's BB gun. They could do that.
Okay. And the response was her son's been excited to shoot.
Correct.
Okay. And that was April 29, 2021.
Yes.
Okay. Now, around this time frame in the text message conversation and the videos on the school shooter's phone, did you discover extremely disturbing information?
Yes, sir.
Okay. And I'm not asking you to go into detail, but as an investigator, it was important to you.
Yes, it was.
Okay. And
I just need to stop it because, like, him doing all of this the moment, yeah, like apparently you already know the answer to this. She'll start doing it and they'll object to her.
Yep, absolutely.
This is why, as a defense attorney, I don't give an inch on this stuff. Object. Because the moment I like go down that road, they're gonna make objection here and say objection.
Yeah.
No,
calls
you
for
don't give these people an
speculation.
inch. Yeah.
Yeah. Well, what do you
not
mean
give them an
by?
inch.
Yeah. What do you mean by whatever?
Although there
You're
are
trying
some,
to interpret
Yeah.
with the meaning behind the words.
there are,
That's
and
what
there
he's
are
doing
some,
right now.
yeah, and there are some judges though I've been in front of where it's like you've already asked him to do that, so he's apparently. And I had a case once where that started to happen, and I had objected, and they kept making arguments, and I made the same arguments back, and the judge is like, "Yeah," and the prosecutor starts complaining. He's like, "You're the one who made this guy the speculation expert."
Yeah.
So-
Yeah. But this judge didn't. This judge didn't do that.
So
So don't
yeah.
let the state give an inch.
Yeah.
If they're calling
Yeah.
for their witnesses to speculate on thoughts behind
Mhm.
words and things like that, they can't, because they're not going to do it on your side. Once you start crossing them, they're going to clam up and they're not going to get friendly, and then the other side's going to object. So don't let them do it on direct.
And I will say, unlike the other trials we ever watched where I complain that the state doesn't prep its witnesses, these witnesses are excellently prepped.
Yes.
So that I will give them credit for that. They've actually done their job in getting these people ready. So
In fact, it was in the days after these messages were sent,
Yes, it was.
and the school shooter shared that with his friend, his only friend he had.
That's correct.
about a hump a lot.
You mentioned that his only friend was taken out of the state,
Correct.
and it seemed to be without notice to the school shooter.
Correct.
Did you uncover evidence that either James or Jennifer Crumbley commented on the fact that his only son was taken, or his only friend was taken out of the state?
Yes.
This is Exhibit 105.
Every case has got a coffer.
Yes, I have no objection to 105, thank you.
What if I was a minute?
And you said that was around about a month before the shooting in Oxford High School?
Yes, it was.
Okay. So this is from Jennifer Crumbley's Facebook, again, to the mother of her son's only friend.
Correct.
Okay, and this is October 31st, 2021, 9 o'clock in the morning.
Yes.
Okay, and what does she write?
Jennifer writes, James filled me in on Ethan's friends last night. I'm so sorry you guys are having to make such a hard decision. Please let me know if you need anything.
Okay.
So this is
And
the
then November
mother of
3rd,
the
she wrote
friend.
what?
She says, how are you guys
Yeah.
all doing? Been thinking of all of you.
Why are
All
we
you
not
allow.
calling her to the stand?
And you know from your
Yeah.
investigation, this is the time frame when the shooter's friend was taken out of state.
That is correct.
Okay. In this conversation, November the 4th, that other individual writes what to Jennifer Crumbley?
She writes, hi, Jen. We're doing okay. It was the hardest thing I've ever had to do. I worry about him constantly and miss him terribly. I know that he's where he needs to be to get better, though. Thanks so much for checking on us. I appreciate you and your family. She's referring to her son, the shooter's friend, was only happy and relaxed with you guys.
And in response,
Jennifer responds with, please keep us updated. I know Ethan misses him. If you guys need anything at all, please don't hesitate to ask.
and that was again in November of 2021 before the shooting.
Correct on the 4th, yes.
Okay. Now I'm going to direct your attention to the days around the shooting and what you were able to obtain as far as a digital footprint of the Crumbley camera.
Okay.
Starting November 26, 2021, is that date significant to you?
Yes, it is.
Why is that?
That was the day the gun was purchased.
And we heard yesterday that the gun is in the murder weapon?
Yes, sir.
Okay. That was a 9mm 6-hour handgun?
Yes, it was.
Okay. That's been admitted in evidence, and we heard it was bought from a firearms store in Oxford.
That's correct.
Okay. This is 106?
I have no objection to this.
106 is a minute?
Okay. This is just as an example of what information you can obtain from a search warrant on a Gmail account.
That's correct.
Okay. And so this is from James Crumbley's Gmail account, November 26, 2021, confirming that he was in fact at that firearms store at 12:08 p.m.
Correct.
Okay. Now, we talked about obtaining locations from somebody. This is 107.
We have no objection.
107 is a minute?
Before we get into 107, Exhibit 417, it's a video. Sir, in your analysis of the shooter's phone and Jennifer Crumbley's phone, social media accounts, you were able to obtain videos taken by the school shooter with that handgun, the murder weapon?
That's correct.
Okay. So 417, people move to admit and publish to the jury. It's a video taken from November 26, 2021.
And Your Honor, I'm sorry, I have to just take a look really quick, because we just jumped ahead like a
Yeah,
couple.
it's 417.
Yeah, let me just take a quick look, I'm sorry.
Was this putting in the text? I don't
And
think the
actually,
state's
I don't
going
have
to,
417 in the exhibits that I was given. Can I see?
the state's not going to be happy with anything that the parents would have
It
done
wasn't on
because
my
obviously
hard drive, but
it wasn't enough, right?
Yeah. We actually ended up shooting everybody.
Your Honor, I
but
have no way to play this.
they would have been-
I don't have this.
All these
Can I
are
just
just,
have,
it's a very short video.
it's not on our, I just. need to
Notice
see
he's
what
saying,
it
I don't
is. Can you
have
just
it.
have the
It's a
computer
very
and show
short
it to me
video.
real
They're
quick?
they're coming up
Is
with.
there audio?
No.
Was it provided to the defense?
Yes.
It's,
We're showing a preliminary examination as well.
Your Honor, I'm sorry, it's not on the exhibits they gave me on the desk. So there's a million videos in this case and I have no
Okay,
idea which
See,
one
this
it
is
is.
a
I
problem.
probably have no objection. Can I just see what video it is?
Sure.
This is
I
a
guess
that's a
I-
massive evidentiary issue. Once again,
Yeah, but
This-
it makes the defense sound disorganized and like a giant mess.
I don't have
Yes.
a flash drive player on here, so can we just
And it-
end this
and it
meeting up for
makes-
1 second and just take a quick.
you know,
look?
and that's
And I
yeah,
apologize,
that
I
is
don't know.
that is
There's a lot of stuff. I don't want to release the.
I would have-
because their lunch
If I was
is-
defense counsel, I step
had
back,
made
take a
them-
breath, and be like, "Listen, Judge, I was provided a disc
And
of
then
the
lost it.
exhibits. This one is not on there. Don't know why.
Okay, and so
They
this is
failed to give it to
417.
me, but I need to see it ahead of time.
Okay,
yeah. Yes.
Again, it's more style at this point with the defense.
No, I
counsel.
agree, but yeah, it does. It's all about how is the jury looking at you? Because yeah, they're going to be like, oh my god, this lady's not on top of it,
Okay,
and
we
she
have no
comes
objection to
across
this
as
one.
like
And
the
I apologize.
unprepared
I-
defense
Listen,
attorney,
I know, I
Thank
get
you.
it, I get it.
which is like the stereotype.
Stop.
Right.
Okay, so 417 is admitted.
So what are they?
This, to me,
Okay.
these videos,
Yeah, Judge.
this is the
Thank
one
you.
I'm thinking of. The
This is
start
what
of-
you obtained from the shooter's phone, and it was captured 6:39 p.m. on November 26, 2021.
Oh wait, no, this
That's
is
correct.
something different. Never mind.
Okay.
Maybe he
So
wanted
that
to
video was
inspect the
taken
barrel, but
evening
didn't
of firearm
want to stick his
purchase.
eye
Correct.
down it the barrel.
Yeah.
And that is in fact the murder weapon, the 6-hour 9mm.
Yes, sir.
Objection. You
context.
actually have no idea.
Yeah, you have absolutely no idea that
I have
this
no
is the
objection
guy.
to this.
What number is it?
Have you seen the
107
serial
and
number?
108.
No.
107 was previously admitted, 108 is admitted.
Okay, now, Agent Brandon testified yesterday to much about the evidence regarding the firearms. I'm going to move you ahead to November 27th, which is the next day, the day after the 6 hours purchased.
Okay.
All right. So,
Yes.
all right, 107.
See, I
This
would have
is
objected. I
evidence
would have.
obtained from
I would have objected right there, doing that whole like scrolling through exhibits thing. They did that intentionally because
Yeah,
he could
I
have
know.
clicked where he needed to go.
Yeah, the way they do this, both sides are a mess with these exhibits. And granted that there's a lot, but you should have them set up ahead of time. There's no excuse.
Yeah. Well, but it's also they have these separate like slides or whatever. That's fine, but I'm attributing this at this point now to the state. Yeah, they're being sloppy, but they're also using their sloppiness as an excuse to screw and be prejudicial. So
Oh, and there's a lot of speaking objections if you haven't caught on yet, too.
yeah, which
hate
I think
those.
is blows my mind. She just lets them. Well, the trial I've been
This-
covering too, tons of speaking objections, and I'm like,
This was addressed during jury voir dire when I was there on
Yeah.
Tuesday. Is that
Mhm.
there's a jury sitting, two jury members sitting right up in the face of the witness, 5
Mhm.
feet from the judge. And the judge actually said, I don't know how we're going to be able to conduct sidebars without the jury being able to hear. We
Mhm.
might have to go into chambers. And so every time you hear the defense counsel saying, can we go into chambers? It's because she wants to do a sidebar so that the jury doesn't hear it. And she's like, well, just what's the issue? Because she doesn't want to take the time to go back into chambers.
yeah,
And then you get all
Oh,
these
that's a
speaking
mess.
arguments in front of the jury.
so. Oof. All right, guys. Well, here we go. Let's see what this is going to be.
James Crumbley's Gmail account. Is that right?
That's correct.
Okay, so you were able to tell what James Crumbley was doing from 8 a.m. to 8:59 p.m. on November 27th, 2021.
Correct.
Okay, and tell us what was he doing.
He was delivering DoorDash.
So these dots, these data points are what? What do they signify?
Those are the GPS locations that were provided when the location services was turned on from Google.
So we know he was out of the house basically the whole day.
Correct.
Okay. Now, 108, we have Jennifer Crumbley's Gmail data points. And from what time period?
That's from 2:29 p.m. to 3:32 p.m.
Okay, and this is exhibit 108, it shows she's out of the house from about 2:30 to 3:30. Is that right?
That's correct.
Okay, thank you. Now, the next day is Sunday, November the 28th, 2021. Did you get a feel for what Jennifer Crumbley was discussing based upon her Facebook messages, what her plan was doing on November the 28th, 2021?
Yes,
And in fact, you recovered chat history with an individual named Kira Pennick.
that's correct.
Okay. And through the course of this investigation, did you come to learn who that person was?
Yes, I did.
Who's that?
She was the owner of the horse farm.
Okay. That's the horse farm where Jennifer and James Crumbley would board their horses?
Correct.
Okay. So she's going to testify.
What was the
later on
name of
this
their
trial.
horse? We haven't heard the horse's
You
name.
reviewed their Facebook chat.
Judy, I think,
Correct.
Billy or Bobby or
So that's
something.
one of them.
Oh, okay. I
Two
thought
of
it'd be
them.
funny.
Your Honor, can I
Aw.
just have a moment? This is a,
It says it's a Fred.
She may or may not have acquired her horse while intoxicated on a bottle of wine and ordered it over the internet.
the exhibit that I received from the prosecution is 967 pages long. So I'm
Well,
thinking
I
that
mean,
what I got is not,
hopefully the
It's
horses
not
are being fed in the meantime.
We're not going to go through without.
Yeah.
well, no, I'm
Let's
just,
do it.
okay, I'm sorry. So what pages are they admitting is?
9:30 to 9:33.
Okay, 9:30. Okay, give me just a moment. I'm
Okay.
sorry. I got the whole file like,
It's on the exhibit list. With
Yeah,
the
there's,
pages.
it's the exhibit list.
Well, it's on the exhibit list, but it's not how you're presenting it.
On Tuesday, I'm not sure.
That's not helpful.
I'm sure with the defense if it was the same day or not, but
I,
it
that's,
says pages 9:30 to 9:33.
That is an asshole argument.
I know, I'm just.
It's on your
scrolling.
list.
It's just taking me a little bit to scroll through.
She looks a little frantic there. As I say, this whole thing is making her look disheveled. And she's apologizing to the court for not being able, it's not her who should be apologizing. It's the prosecutor for not being clear with
I'm
his
sorry, I'm trying to get
exhibits.
to 900. It just takes a little bit to load.
She
just
keeps
to
saying,
the
I'm
file.
sorry.
Yeah,
Stop saying,
and she
"I'm
keeps
sorry."
talking. It's taking a little bit to load. Yeah, don't apologize for that stuff.
It's not you.
Okay, so
It's the
pages
state that
901
didn't
to
give you the
9:30.
exhibits. I got to go get a drink.
Exactly what was
I'll be
on the
back.
exhibit list.
All right, see you,
I'm
David.
trying to get to the
Oh, no, I'm
pages.
gonna be here. I'm
The
just stepping
file
away
they
from the
gave me is
camera.
much larger
Oh,
than
you're
the
stepping
pages.
out. Okay.
On every other exhibit, they have narrowed it down, and this one is much bigger. I just need a
Okay,
moment.
you're good. You're good. The exhibit list says the pages.
I know, but I can't pull it up fast enough because my computer's, I'm trying to go as fast as I can.
Okay.
Okay, I have no objection to this.
Okay, thank you. 109 is in there.
Thank you. And this is a portion of exhibit 1. Okay, so green is who?
It's Jennifer.
Okay, and what's she writing?
Was his front swollen again?
Okay, and then the response?
It was from Kira Pennick. Right. I'm the same. I'm not sure. I'm not doing chores, but I'll ask my dad when I see him.
Okay, so did you come to learn when Jennifer writes, "Was his foot swollen again?" She's referring to one of her horses.
Correct. Yes.
Okay. And Kira's response?
If Billy keeps stacking up, I think you should have the vet out for him. Just want to make sure it isn't anything serious.
And Billy's who?
The horse.
Oh, so it's Billy
And
the
Jennifer's
horse.
response?
He's got mid fever. James is coming out in the morning to put some stuff on him and calling vet for antibiotics. And then she corrects with mud.
Billy's one horse and they have 2 horses at this point, right?
Correct.
And then what does Kira say?
Kira, then that's crazy. Never seen it react like that. Want me to just put stuff on it daily? I can. I didn't do chores this weekend, so don't know if it got done.
So the last message in this exhibit from Jennifer Crumbley to the individual who boards those 2 horses is November 28th, 2021. That's Sunday, 8:18 p.m., Sunday night.
Correct.
And she writes, "Yes, let's do Tuesday. I'll have James leave the mixture out there. I don't think he's sore from the ground. He's just fine lunging. Just need to keep moisture off his scratches and get him on antibiotics. Should be clear to me."
That's correct.
And that's again in reference to one of our horses.
That's correct.
Now, did Jennifer go to the barn that day?
Yes.
When you say that, did you tell me?
Yes, thank you, Judge. This is 110-111.
No objection to those.
110 and 111.
Thank you. 110, this is from her Gmail search warrant return. We can tell that she's at the barn at noon on November 28th.
That's correct.
Okay, and she's back at home. This is exhibit 111 at about 2 o'clock.
Correct.
Now, moving on to Monday, November the 29th. That's the day before the shooting, right?
That's correct.
Okay. Now, what's the first thing that you see of importance to you as a forensic investigator from the day before the shooting that occurred on one of her devices?
It was a web history search or a web search.
This is exhibit 113.
We have no objection. I just want to make sure, I'm sorry, 112 was admitted.
No, 112 was not omitted. That's
Yeah, 112 is not admitted. That's
Okay, so 113, we have no objection, thank you.
113 's admitted.
Thank you. Okay, 113. This is a snippet from a Celebrate extraction report of Jennifer Crumbley's web history.
That's correct.
Okay. So tell us, please, what was she researching November 29th, 2021 at 3:05 in the morning?
In the second column, you can see where it says research clinical depression treatment options. It was Yahoo search that was used.
Okay.
In the third column, you can see exactly that's what was in the URL bar, the web address bar that you typed
And that's the day before the shooting in the early morning hours?
at 3:05 a.m.
All right, now let's talk about the Facebook conversation between James and Jennifer from later that day, Monday the 29th. This is 114.
I have no objection.
114 is admitted.
Thank you. Okay. November the 29th, 2021, 8 a.m. Jennifer writes to James, "Are you at the barn?" And then about 40 minutes later, she sends a question mark. Is that right?
That's correct.
Okay. And then James responds to what?
He responds starting with the question mark, working on Billy.
So it appears, at least from this message thread, that he's at the barn with their horse Billy.
That's correct.
And then he sent a picture.
That's correct.
Can you tell what that's of?
It's horse's legs, it appears.
Okay. And what does Jennifer respond to that picture?
Do the fronts too.
Okay, this is
Do you
9:21
care about
a.m.
the
What did
horse's
Jennifer say?
disease?
Jennifer asked,
Yeah,
did
I'm
you
hearing
call the
about the
vet?
horse problems.
And then what?
Make sure you get back in between his heel balls.
Okay. And James's response to that?
He responds with, I did, and then fronts too.
And that's at 9:34 a.m. on November the 29th.
That's correct.
It has a disease that
9:35
requires
was
daily
James'
care.
He texts, what exactly should I tell vet? Type out for me, leaving barn now.
Okay. And then Jennifer responds, "Billy looks to have scratches / mud fever. He's starting to stock up on all fours and concerned about infection. He's not lame, sensitive to the touch, and they go down when he moves. Is there an antibiotic I can get him on? We just put Desitin and antibacterial on his legs today." Yes. November 29th, 9:41 a.m. Is that right?
That's correct.
Okay. And then she sends a message to him.
Correct.
And what does she say?
She says, was he stocked up this morning?
And then James's response.
James responds with, he was stocked up more in the back than in the front. In fact, the front didn't really look stocked up at all. So I launched on for a few minutes before I put the stuff on it. And it took the swelling down a little bit, but I got the cream all over,
Oh,
in
it's supposed to say
between his heel
lunged.
balls and stuff like that. I'll call the vet here in a minute.
Now, sir, it's been a little tedious going through all of the messages regarding the horses. Give us an idea, because you're the one who actually extracted that information from Facebook and reviewed it. How often will they show concern over their horses?
Quite often.
Okay. Okay, and Jennifer's response, this is the same conversation, November 29th at 9:58 a.m.
She responds with, it made sense, LOL.
Okay, and then James responds more about the horse, is that right?
That's correct.
Okay. And Jennifer responds to that message,
Yes, she did.
and that's at 10:15 a.m.
Correct.
Okay. Now, this same day, same time period, did you uncover evidence that someone from Oxford High School left a message for Jennifer Crumbley?
Yes, correct.
Okay. And in fact, that was at 9:41 a.m.
That's correct.
Okay, so that was in the midst of the Facebook conversation between James and Jennifer about their horse.
Correct.
Okay. And we were able to obtain that voicemail from Jennifer Crumbley's phone records.
Yes.
People moved to him at 1:15.
No objection, Your Honor.
115 is admitted.
Thank you.
Hi, Ms. Crumbley. My name is Pam Bryan. I'm calling from Oxford High School, and I'm here with Mr. Hopkins, who's the counselor. I was just calling to let you know that you spoke with Ethan, had a really nice conversation. One of the teachers that sent an email to the office, she was concerned because Ethan, when she was walking around the room checking assignments, but he was on his cell and looking at bullets and that sort of thing. So she just wanted to have a conversation. We did, and said he's at the shooting range with you this weekend, and we're like, that, guns are a hobby for a lot of people, and shooting ranges, and that's perfectly normal. And that we just wanted to make sure, had a conversation with him about the things he searches at school, and things versus searching at home, like Mr. Hopkins did a good example of like the teacher makes beer at home, perfectly normal and healthy, but he's using searches for making beer at school. So we had a conversation. He was great. He said, yes, we did. So I just wanted to let you know we did have a conversation with him, and about 5 minutes, and he was like, all right, if you have any questions, you can give me a call. Otherwise, it'll be a great holiday. Thanks. Bye-bye.
Can you pause it?
Okay, that was the day before the shooting at 9:41 a.m.
Correct.
Okay. Did Jennifer Crumbley access that voicemail?
Eventually, yes.
Okay, this is Exhibit 116.
We have no objection.
Okay. that recording is important, I believe. And so this is the day before. So this is November 29th, 2021. The shooting happened November 30th, 2021. The shooter, Ethan, was seen by his teacher looking up bullets on his phone. He was brought down to the office. He had a meeting with Pam, the woman who called, and I think another assistant principal. And they said, what are you doing? He said, I'm looking at bullets. We got a new gun. I went to the range and I was just curious about this stuff. And the school sent him back to class. And then they called home and they said, yeah, we had a conversation with him. He was looking at bullets. We told him like, it's not appropriate to look at bullets. Mr. So-and-so, the assistant principal, whatever his name is, he makes beer at home. He brews his own beer, but he's not going to look that up at school. It's just not something you do at school. Going to the range, shooting, it's completely normal for kids. It's a completely normal hobby for people. He's not in trouble. No big deal. I just wanted to let you know we had a conversation with him. Call me back if you have any other questions. Have a nice holiday. Bye-bye. That was the message the day before. Nobody's concerned. They know he has a gun. They know he just got a gun. They know he's been going to the shooting range. They know everything that's been going on with him as far as his friend disappearing, or not his friend leaving. They know he's struggling with grades and things like that, but nobody has a concern, and they leave that very pleasant message. And then immediately afterwards is where Jennifer, you see, I probably see the text messages where Jennifer texts her son about this. So she's obviously responding and following up. She's not ignoring the situation, but that recording, I just posted a video up today of just that recording because I think it shows the level of nobody saw this coming that everyone needs to keep in mind. So sorry to rant. I just wanted to point that out. Oh, you're muted, Sean.
Oh, I agree. No, that makes sense. And it's, we're so scared of this kid. Yet, like everything's okay, hunky dory. And then the next day they're not like, once again, it goes to like nobody checked him. And I love how the state says, well, there's other people who are culpable. But today we're just talking about Jennifer. That's where, like, when the school administrators come in, are you being charged? Or have you been investigated? Have you been notified you've been charged? And I would just, they can object, but it's like, well, no. So the state's argument of
just ask it.
What?
You don't need the answer. You could just ask it.
I know, but I would just ask it because then at that point, it's like they told you all these other people are in trouble. No one else is.
Yeah.
Just her.
But my other point is that, so this is a non-disciplinary phone call. Hey, just wanted to let you know we had a phone call with your son. We sent him back to class. No big deal.
And what's the presence at depression? No big deal. Yeah.
No big deal. But then mom even responds and texts the son and says, what are you doing? Why are you looking this up in school? Don't be stupid. Don't get caught.
Yes. So it's interesting. It is interesting. Alrighty. So here we go, guys.
Thank you, Chuck. And according to your analysis, she accessed the voicemail at 11:49 a.m.
That's correct.
Okay. So that's still in the midst of the conversation she was having with James about their horse.
Correct.
Did you uncover evidence that Jennifer Crumbley texted her son about that voicemail?
Yes.
Okay. This is Exhibit 117.
I have no objection.
117 is admitted.
Okay. Now, owner, Green, this is Jennifer because it's from her phone. Is that right?
Correct.
Okay. And in fact, you were able to take the whole text message conversation that existed between between Jennifer Crumbley and her son. Is that right? And if it were to be printed out, it'd be over 200 pages or so. Is that right?
Sounds about right, yes.
Okay. So I'm going to show you portions from November 29th, and we'll refer back to this. So November 29th at 11:53 a.m., this is a few minutes after she listened to the voicemail. What did she write to her son?
She says, seriously, 2 question marks, looking at bullets in school, question mark, question mark.
And he writes back, what? And then, oh, yeah?
Correct.
And then he wrote what?
I already went to the office for that. It was in first hour. All I did was look up a certain caliber at the end of class because I was curious. It was on my phone.
Okay, that's 11:53 a.m., November 29th?
11:54.
11:54, thank you. And then
I hear my son
completely
voices in
harmless.
these texts, by the
Teachers
way.
just have no privacy.
Yeah, no,
They said I'm all good.
I hear me if I was able to have a cell phone in high
Next
school.
message.
Right?
The shooter continues, I understood why. They talked to me and they said, I'm good.
Okay, then he wrote, this is nothing I should get in trouble. This is nothing I should get in trouble about. He
Correct.
wrote that to the defendant at 11:55 a.m.
That's correct.
And what was her response to that?
You're not. They left me a voicemail with a hand over face emoji twice.
Okay. And then what did she say?
She then says, did you at least show them a pic of your new gun?
So she wrote at 12:14 p.m., did you at least show them a pic of your new gun?
Correct.
And his response?
No, I didn't show them the pic. My God.
And then what?
I only told them I went to the range with you on Saturday.
Okay.
He told
I only told them I went to the range with you on Saturday.
Correct.
they knew the day before they had this meeting.
And then what did he say?
He had a
It was a
gun
harmless act.
fully.
Go ahead.
I have this bullet cartridge in my room that I didn't, what kind of bullet it was, and it said it was a
Oh, so
22.
he's looking up ahead.
So at the end of the
stamp.
first hour, I just looked up different
Yeah.
types of 22 bullets. And I guess the teachers can't get their eyes off my screen, SMH.
And then what did Jennifer respond to that?
She responds with, LOL, I'm period, not mad. You're not, you have to learn, not period, to period, get caught, period.
Yeah, don't be an idiot about it.
And his response
That's
to
what my
that?
parents would say.
IK, I know, LOL.
Don't be a dingus.
And then?
2 laughing emojis. And then he responds with, I just didn't want something this little to get me in trouble because, well, I didn't want to get in trouble, LOL.
Okay. And then what did he write?
The shooter says, I want to hear the voicemail when I get home, though. Also, I never tried to hide me looking up the bullet. I just didn't think a teacher would be staring at my phone.
And then what did she say to the defendant?
She says, okay, I saved it.
Sir, did you find evidence that Jennifer discussed this incident with her husband, James, that day?
Yes.
118.
Thank you. No objection to 118.
This is a Facebook message between James and Jennifer Crumbley.
Correct.
Okay. And then Jennifer's now in blue.
Correct, yes.
Okay. And what did she write?
She writes, Ethan, tell you what happened today.
And his response?
James' response was, yeah.
And correct me if I'm wrong, but there's no further discussion between the two of them on Facebook Messenger.
No, there's not.
Now, sir, I wanted to take you back to the day of the shooting, November the 30th, 2021. And what we'll do is go step by step what you were able to discern from your available sources of information.
Okay.
Exhibit 119. Well, first of all, we already talked about how you were the individual who went through all the surveillance video.
Correct.
And it was your responsibility to put together that timeline.
Correct.
And did you also put together the timeline when the school shooter was dropped off at school?
Yes,
Okay. And he was dropped off at 7:46 a.m. on November the 30th?
that's correct.
Any objection to this?
No objection.
119.
Do you see him being dropped off
Yes. It's him with a gray hoodie and got a black t-shirt on.
right there?
Correct.
Judge, and looking at the time, this might be a good time to break for lunch, given the fact that we're starting to go through the evidence from the day of the shooting.
If your lunch is ready,
Yeah, well, that's good.
just because this is now it's a transition.
Oh, okay. All right. Your lunch is here, so.
Do you know, like, are they getting different food every day, or are they just getting catered like Subway? Do you know?
I don't know. The
No.
judges
Oh, I'm
made
sorry, ma'am. I apologize. Yes, ma'am. No, you're,
sorry, the judges
Yeah.
made jokes about her like home cooking lunch
Yeah.
for the jurors. I don't know where exactly they're getting it from. There's a cafeteria.
Cheesy
on the first
potatoes
floor.
every day.
No, yeah, but there is a cafeteria
Yeah.
in the basement, but she doesn't want the jurors mingling with people because everyone goes down there. So
Yeah,
she's decided to bring in lunch for them.
Especially after that first day, where like the news is going around, like, are you guys the Crumbley jurors?
So dumb. I was like, it's not me. It wasn't me because I was there for day one
Yeah.
of jury selection, and then I didn't show for day two. And I emailed them. I didn't want them thinking like I was out there talking to jurors
Yeah.
and now I'm gone. Like, no, it wasn't me.
There are judge like, and I get she doesn't want to waste time, but I'm surprised she didn't start hauling in reporters. Like, was that you? Because that's a contempt issue right there. Like, they know better.
Yeah,
Um,
everyone knows better. But because I'm not the
Mhm.
mainstream media. I'm not affiliated with a 3-digit
Mhm.
or 3 number or letters or whatever.
Yeah.
I was there all day. I just didn't want to think it was me.
No, I get it.
Because
So
I'm the weird one coming in.
also, I'm not gonna lie, getting cafeteria food every day would suck though. So
it's really good though.
it's good there. Okay.
No, it's like it's not your normal cafeteria food. It's like a delicatessen, and they have all kinds of stuff.
Okay. Well.
So, but
But
I'll
yeah.
take this opportunity to jump off. I know you're going to stream all day. I'm
Mhm.
going to make actually sort of an update of the first 2 days video that I wanted to get out, and then I'll come back because I really want to know what you think about Cross and so like towards the end of Cross and how the day finishes up. I really want your thoughts on.
Okay, I look forward to it, guys. David over at Making Law Simple. He'll be doing this starting tomorrow morning, getting back at it 8:30 in the morning, go until the end.
And I've decided I'm going to send Sean a link for every one of my streams, and if he can pop on and wants to.
Yeah, I might have time. I might have some time this week here and there to pop in, so I can pop in and see. Because I'm curious to see how this is going live as well. So,
yeah. Okay. All right. Take care, guys. Thanks, Sean.
All right. Thanks, David.
Bye.
All right, guys. So, no lunch breaks. We're gonna keep going. So here we go.
I'm sorry.
All right.
I was thinking.
We're in the middle.
All right, so no breaks. All gas, no brakes. Ooh. Okay, hold on. Here we go. Still quiet.
A lot of time. I'm going to now direct your attention to Exhibit 119.
All right, guys. Hope you enjoyed your lunch break. Here we go.
We spent a lot of time. Oh, I'm sorry, Judge. Just for the record, so the jury knows we have paralegal Mailing Nell at table to help with the exhibits.
Okay.
Because once again, he does not trust me with good.
This is true.
That's a
Jury
interesting
spent
admission. They
some time
can't handle
talking
their
about background,
business.
the criminal
They brought the
prosecution.
paralegal
So
up to help
now
them.
about November the 30th, 2021.
It's almost like the defense attorney is telling the truth.
Digital footprint from that day.
Correct.
Okay. So Exhibit 119, which has been admitted, this is the Oxford High School surveillance video from when the defendant's son was dropped off. Is that right?
Yes, sir.
What's a long line of cars? Holy cow.
You able to determine that he was dropped off by James Crumbley at 7:46 a.m.?
That's correct.
Okay.
It's their fault they brought him to school. They should have he could have been his violence at
We will
home.
determine the time that Jennifer Crumbley got to her place of employment that day.
A little after 9 in the morning.
It's Exhibit 120.
We have no objection to that.
Thank you. Sir, this is a screenshot from surveillance footage of her employer on November the 30th, 2021. And that's Jennifer Crumbley on November 30th, 2021, entering that building at 9:04 a.m.
Correct.
Now, shortly after she arrived, did she receive a phone call from the school?
Yes, you did.
Exhibit 121.
We have no objection.
And this is a snippet from her phone log. Would that be correct?
That's correct.
Okay, so November the 30th, 2021 at 9:24 a.m. was a missed phone call, and that's from Oxford High School.
That's correct.
Okay. And she called the school back at 9:27 a.m. Is that right?
That's correct.
And they had a 5-minute and 43-second conversation?
Correct.
Okay. Now, did she receive a text shortly after that phone call?
Yes.
Right, this is Exhibit 122 and 123.
I have no objection to 122 or 123.
So 122, this is the text message found on her phone from an individual. It ended up being her son's school counselor at Oxford.
Correct.
Okay, and this is a picture of what we'll call an altered math worksheet at 9:31 a.m.
Correct.
All right, and if you were to click on that link, this would come.
Correct.
Okay. And then she also received an email with the original math worksheet.
That's correct.
All right, this is Exhibit 124.
No objection.
And this email, thank you. That was shortly thereafter. And the image in the email was in fact Exhibit 74, which was the math worksheet that her son created on November the 30th.
Correct.
Okay. So she had this information about 9:30 in the morning on November the 30th.
Correct.
Okay. Did Jennifer contact James right after that?
Yes, she did.
Exhibit 125.
No objection.
So this is a Facebook message chat, the one that was deleted from Jennifer's phone. Blue is Jennifer Crumbley, is that correct?
That is correct.
And green will be James Crumbley.
That's correct.
Okay. So at 9:33 a.m., what did Jennifer write to James?
Call now with now in all caps, emergency. And then she texted again less than 2 minutes later, emergency.
Okay. And she sent these two pictures, both the original and the altered worksheet to James?
That's correct.
And this is at 9:38 a.m.?
Correct.
What was James' response at 9:44?
James responded with, my God, WTF.
What was it?
WTF, what the fuck?
Okay.
Excuse me. Then responds, vet not here yet. It's McElmurray for Kira's horse, still waiting on vet.
And we already talked about that they were concerned over one of their horse's medical issues.
Correct.
Okay. And what was Jennifer's response at 9:50?
She responded, he said he was distraught about last night.
And James' response to that?
We talked about it this morning. And then he asked her, you talked to him?
Okay. And that's 9:51. And what was Jennifer's response?
6 minutes later, she texted, can you call?
Did Jennifer leave her work and head to the school?
Yes, she did.
Did Jennifer Crumbley also text this picture, exhibit 74, to anybody else at that time?
Yes, she did.
This is exhibit 126.
You have no objection?
Now she sent this picture, this text to Andrew Smith at 10:05 a.m.
Correct.
Okay. Did you learn who Andrew Smith was?
Yes, I did.
And that was her boss?
Yes, it was.
Okay. And what did she text with the caption on this picture?
She said, I have to go to my kid's school. Counselor just called, and this is what I'm dealing with. I'll be back 11:30 to 12 at the latest.
And did she leave her employment?
Yes, she did.
This is 127.
No objection?
Okay. This is her leaving at 10:06.
Yes.
I want to go back to exhibit 125 briefly. Skip over it. She wrote, can you call at 9:57? And then what did she write?
She wrote, heading to a school, I'm very concerned.
Okay. So at 10:04, she wrote, heading to his school, and I'm very concerned. At 10:05, she sent that picture right here to Mr. Smith.
Correct.
At 10:06, she walked out the door to the building.
Correct.
Okay. Did James and Jennifer Crumbley have a phone conversation at this point?
Yes, they did.
Okay. This is 128.
No objection?
And sir, this is a snippet from the call log found on Jennifer Crumbley's cell phone. Is that right?
Yes, it is.
Okay. So, well, first you got a phone call from the school. This is a phone call to the school counselor at 10:07 a.m.
That's correct.
That's a 40-second call.
That's correct.
Okay. So that was exhibit 121, not 128.
I'm sorry, you said
That's
121.
121.
Okay, and Your
That's part of the
Honor,
call.
I would just ask that the witness answer questions instead of the prosecutor stating essentially all the information as he goes along.
Okay, so I guess it's the objections leading.
Leading,
I'll rephrase. All right, 128.
no objection?
Did James and Jennifer have a phone conversation after this?
Yes, they did.
Well, first, this is part of exhibit 125. What time is this?
This is at 10:12,
Okay. And then what did she write?
heading to a school.
Here's exhibit 128 from James Crumbley's call log. What is this?
It's a call to Jennifer at 10:29 a.m.
Okay. So 10:29 a.m. they have a 7-minute and 16-second phone conversation.
That's correct.
Did both James and Jennifer Crumbley arrive at the Oxford High School?
Yes, they did.
Okay. And approximately what time did they arrive?
It was around 10:20, somewhere around there, I believe.
Okay. If I showed you a timeline that they get a 10:37 arrival, that sound right?
Yes, I apologize. Yes.
That's not.
Yes.
Now, we had discussed this portion of the case at a previous hearing, and you had indicated they had arrived in one car and left in one car. Did you find that to be accurate?
No, it was inaccurate.
Objection.
Okay, so tell me
That
what's
like the
next.
jury has no
It was-
idea
so
about
the
the
video system
hearing.
that they have only
That should
starts
come
recording when
up.
there's enough motion to save space on the system. So they were too far away from the camera to pick up. When I initially saw them, all of a sudden they just appeared in front of one of the cars. So I assumed that they had come together,
Okay. And what did you come to find out?
that they had drove separately.
Okay.
Does that matter? Relevance.
So exhibit 129 is a portion of the Oxford High School surveillance video that depicts their arrival and the period of time they were inside for that meeting with the counselor. Is that right?
Yes, correct.
Okay. People moved them at 129.
I have no objection, but I'm just wondering if it's the actual video, that's the.
Correct.
That's the exhibit. Okay, no objection, thank you.
129 is in here.
So there's a timestamp at the bottom. I want to make sure we see this. 10:36 a.m. and this is November 30th, 2021.
That's correct.
And let us know, please, when you see either the defendant or her husband.
The one vehicle is already backed in, and then there they are walking out.
He is the defendant and her husband
Yes,
in the magnified area.
correct, yes.
What's this portion of the video depict?
Them coming into the school,
What area of the school?
the front by where the offices are.
This is 10:39 a.m.
Correct.
What portion of the school is this?
Looks like the front office of the school.
Now this time right here, that's a broken clock, correct?
It is correct. It never changes.
So this is 10:40 a.m.
Correct. The counseling office.
I'm sorry?
They're in the counseling office. Sorry.
Did you come to learn who this person was? You greeted them?
Yes,
Who's that?
Sean Hopkins.
He's the counselor at the Oxford High School?
That's correct.
Or one of the counselors?
One of the counselors, yes.
The time skips a little bit. This is now 10:52 a.m. What do you see in this portion?
That's the shooter coming out of the Mr. Hopkins' office.
With the red backpack?
Correct.
So they walked in at 10:41 and the shooter walked out at 10:52?
Correct.
Yep. It's no guilty.
This is 10:53. What do you see?
Real quick, guys, we got a couple of super chats. I just need to get through these real quick. I don't want to take too much longer. Lefty for $5. Thank you, Lefty, is saying, F the state to its tonsils, also go 49ers. Well, I didn't see the time to give it to David, but I'm sure he appreciates that. Jen worked that ass out for $1.99. Thanks, Jen. Says, wanted to say thank you for covering this case. You're welcome. I appreciate that. Appreciate your super chat. Vin's been a member for 1 month. Thank you. Or gifted a membership. Well, whoever got that membership, I'm sure is thrilled to have it. Maybe it's Tilly at some point. And then Selena for $9.99. £9.99 actually. £9.99. £9 sterling of the King sterling from the King of England. Saying thank you, Sean, for the coverage / commentary. You're very, very welcome. You're welcome. So let's get back to this. I mean, yeah, they look like such horrible parents because they're there taking care of, problems. I guess they're guilty.
James and Jennifer Crumbley coming out of the Mr. Hopkins' office.
Now, there was something in his hand here. What is that? You can tell?
I wasn't able to tell what that is.
Guys, they said the clock wasn't working right, so it's not 12:42.
Okay. Jennifer Crumbley has a piece of paper in her hand.
Yes, she does.
Did she have that walking into the counselor's office?
No, she did not.
How do you?
And then right there, she handed that piece of paper to James Crumbley.
Correct.
This is 10:54 and almost 10:55 a.m.
Correct?
Okay. Do you see James and Jennifer Crumbley at the top of the screen?
Yes, yeah, at the top of the screen, coming from school.
Thank you. What are we seeing in the scene right here?
One of their vehicles is leaving right there, the black one. And then that third row on the far right, the other car should be leaving shortly now.
Bella, it's a good question. We'll get to that in a minute.
Okay. This is one of the Crumbley vehicles?
Yes, it is.
All right, and this is 10:57, about 10:58?
Correct.
Okay. So we saw them walk in at 10:41 to the office. Their son left at 10:52.
Correct.
And then we saw them leave the parking lot here at 10:57, 10:58.
That's correct.
So how long total, if you know, were they in the counselor's office?
It was about 12 minutes.
What's the first thing that Jennifer Crumbley did on her phone or social media after that meeting?
She sent a message to Kira.
Okay, this is 1:30.
Do we have no objection?
So this is a screenshot,
Correct.
is that right? Okay. And these were taken from Kira Pennick's phone.
That's correct.
Okay. So the icon there, the picture on the horse, this is Jennifer Crumbley's words, correct?
Yes, that's correct.
Okay. And what did she write at 10:58 a.m.?
Okay, I'll bring some out later.
Why isn't
Just had to
Kira
get my
here to
son's school-
testify to
go my
that?
son's school and meet his
She
counselor.
should be
Shit
here to
day.
testify.
And then Kira's response.
Oh, man, everything okay? Do you still want to do lesson tonight?
And then what did Jennifer respond to that?
Yeah, I still plan on doing the lesson. Everything's okay. He's just having a hard time after losing Tank, his friend going away to a treatment facility, and who knows what else. But he was caught drawing this on his math assignment today.
And then this is Exhibit 74, the math drawing that she was sent.
Correct.
And then what did Jennifer write in this post, in this message?
As long as I can get out there early enough, because I had to leave work for an hour, and I have a meeting in Southfield at 3, but I should be done with that by 4. I plan on being there. Plus, the vet said it's better for him to move around to keep his circulation going while he's dealing with mud fever. Good times.
She's talking about her horse, right?
Correct.
Okay. And when she said, I had to leave work for an hour, she's talking about when the school called her for the meeting.
That's correct.
And what was the response at 1:26 a.m.? I'm sorry, if you can read that.
It's Gary responded with OMG, oh my God, he needs some horse therapy. I bet he, then it cuts off.
Okay, that's fine. The rest of these will be in through Kira later on. What's the first thing that James does when he leaves the meeting?
Starts door dashing.
This is 1:31.
No objection?
Like, what are they supposed to do? Sit there and
So what are you
cry?
looking at right here?
That was a response from a search warrant served for DoorDash.
Okay, so we have not just the 30th, but we also have the 29th. I'm going to direct to the first.
Like, what do they want them to do?
We got November 30th, 21 at 11 a.m. Is that right?
That's correct. That's when he checks in.
Okay. So that was about 4 minutes or so, 3 minutes after he left the parking lot.
That's correct.
And Jennifer's text to Kira was about 2 minutes after she left
That's
the parking lot. Did Jennifer go back to work?
Yes, she did.
It's 1:32.
I'm sorry, we're just trying to, yes, no objection.
132.
Thank you. And this is what?
Her re-entering her place of employment 11:24 a.m.
Okay. And that's November 30th?
Correct.
You're going back to exhibit 130. First, what's the next thing she does, either on her phone or social media accounts after 11:24?
I'm sorry.
If you recall, what's the first thing that she does after 11:24 on either her phone or a social media account?
I don't recall.
Well, that's fine. We have exhibit 130 already admitted. So 11:26 a.m.
Correct.
Okay. So you read the very top line of that OMG needs horse therapy.
Correct.
This is 11:26 a.m. So she received this 2 minutes after she walked in the door at her employment.
Correct. Yes.
Okay. Thank you. Go ahead and read that.
It says, OMG, he needs some horse therapy. I bet he would love Mo. Whatever works for you, just let me know. I only have Bella's lesson tonight at 5:30, so anytime after her lesson is fine.
And what did Jennifer Crumbley write back?
Jennifer responds with, okay, yeah, well, he'll be coming with me tonight. James is working. He can't be left alone.
From the context of this conversation, did you take it that he was referring to her son?
Yes, correct.
And what did Kira write in response?
Does he want to ride?
And her response?
Jennifer responded, I don't know. Maybe brush a small horse so he's not intimidated, LOL.
And then Kira?
Kira responds with, Mo would be perfect. And then Jennifer responds with, okay.
Okay.
Kira then goes on to say, make it a family event. Coming out to the barn, really though, I've seen some amazing things done with horses, with kids.
Thank you. Now, did Jennifer Crumbley text her son after that school meeting?
Yes, she did.
This is 133.
I'm sorry, sorry. I have no objection, I'm sorry.
Thank you. Now, this is the same text thread that we referred to earlier, found on Jennifer Crumbley's phone between, this is on the shooter's phone. No, I'm sorry, Jennifer Crumbley's phone.
Yes,
The entire text thread.
correct, yes,
Thank you. Okay. Green is Jennifer Crumbley, blue is her son.
correct.
Okay. Tell us what she wrote to him at 12:21 p.m. on November 3rd.
She asked, you okay? And then he responds shortly after that, yeah, I just got back from lunch.
Okay. And her, what did she say?
About 60 minutes later, she says, you know, you can talk to us and we won't judge.
And his response to that at 12:42 p.m.
At 12:42, he says, I care, I know, thank you, I'm sorry for that, I love you.
Now, we'll introduce the rest of the thread. Did she respond to that?
Not immediately, no.
When did she respond to it?
After the shooting started,
After shooting was made public?
yes,
How many minutes later, if you know?
over a half an hour.
Now, you're the investigator who pulled the footage, you reviewed the footage, and you know the timeline of the shooting, the day of the event.
Correct.
Okay. And so at 12:42 p.m., you know that was a few minutes before the shooter went into the boys' bathroom outside of 258, classroom 258, and began to load his fire.
That's correct.
And he emerged at 12:51 p.m.
That's correct.
Now, what's the first relevant event in either James or Jennifer's phone or email or social media accounts after 12:42 p.m.?
An email was sent to James's phone from the high school.
This is 134.
No objection.
Thank you. This is an email from Oxford Community Schools sent to James Crumbley's email address at 1:09 p.m.
Correct.
And that's, to your knowledge, the active shooter alert that went out to all parents in the district?
That's correct.
Now, when James received this, he was still making DoorDash deliveries?
Yes, he was.
Were you able to pull location history from his device?
Yes, correct. Yes.
This is 113, I'm sorry, 136.
No objection.
This is 135, 136.
136, Judge. We skipped 135.
No
Wait.
objection.
I have no objection to 136.
136.
And then, are you gonna do?
No, we're skipping 136.
You're skipping, okay. Sorry, I'm just trying to keep my number straight.
136 is in there.
Thank you, Judge. So this is location data from his email, the email he received the active shooter alert,
Correct.
November 30th, 2021, and this is at what time?
This is at 1:13 p.m.
Okay. Where is this?
This is at the Meyer. He's in the parking lot of the Meyer.
Okay. And that's the Meyer off of Ray Road?
Yeah, it's the one that I responded to, yes.
Okay, so that was the reunification location for all parents.
Correct.
Did he stay there?
No, he did not.
Okay. How long was he there?
I think just a matter of minutes.
Did he call Jennifer?
Yes, he did.
This is exhibit 137.
No objection.
137 is in there.
This is a portion of the phone call from James Crumbley's cell phone download. November 30, 2021 at 1:15 p.m. He called Jennifer Crumbley.
That's correct.
Okay. And that was how long phone call?
Just less than a minute.
And based upon your analysis of his GPS locations, where was he at when he made the phone call?
He was still in the Meyer lot, I believe.
Still in Mark. Okay. Now, did you find out that Jennifer Crumbley left her work around that time?
Yes, she did.
Exhibit 138 is a surveillance video of Jennifer Crumbley leaving work. Objection?
No objection.
138 is in there.
So this is 1:18 p.m.?
Yes, it is.
Okay, so this is after the active shooter alert went out at 1:09 and after she was on the phone with her husband.
Correct.
So did it appear from your analysis that Jennifer and James Crumbley spoke on the phone after she left work?
Yeah, she did.
1:39.
I apologize, just really quick. 1:38 was the video we just saw. 1:39, we have no objection to.
Exactly.
Okay,
Guilty,
both
straight to
were
jail.
Yes.
Okay, thank you.
It's the call log off of James Crumbley's phone.
Robert,
November
thank you
30th,
for the gifts. I
2021,
know
1:19
people are
PM.
appreciate that.
And how long did they speak for?
They spoke for a little over 10 minutes.
Okay, when I say that, it should be clear.
James and
Aaron,
Jennifer.
thank you for the gifted memberships.
Could you tell that while she was on the phone with James Crumbley, did she send any messages?
Yeah, she did.
Hi, Drew.
Okay. Do you recall who she sent a message to?
I believe it was Andy Smith she sent a message to.
Yeah, being in jail does
Who
not
else
make
you
you
sent a message
healthy. It ruins you.
I don't recall. I know
Did she
there was
message her son?
Yes, she did. I apologize. Yes, yes.
Let's see, 140. Location data.
No objection?
Thank you. 140. This is GPS location data for James Crumbley. This is 1:20 p.m.
Correct.
Okay, November the 30th, and this is at their home at 112 East in Oxford?
I answer yes.
Okay, so just to back up, just to make sure we're clear, James Crumbley received the active alert email at 1:09.
Correct.
He called Jennifer Crumbley at 1:15 while he was at the Meyer parking lot,
Correct.
and he leaves the Meyer parking lot and he's home at least 1:20 p.m.
Correct.
Okay, and they had a 10-minute phone call that began at 1:19 p.m. It indicates to you that they're still on the phone?
Yes.
Okay. 141.
No objection?
Okay, so about this time of the day, could you tell if Jennifer was on the move?
Yes, she was.
Okay, so this is what time?
This is at 1:20 p.m.
Okay, and this is at her location of her employment, correct?
Yeah, Telegraph Square Lake,
Okay.
south of here.
So 42.
No objection?
So you said that while she was on the phone with her husband, she texted her son?
Yes, she did.
This is 142.
Wait, I'm sorry, hang on. Let me just pull it up real quick. I'm so sorry. Okay, sorry, thank you. Sorry, thank you.
November 30th, 2021 at 1:18 p.m. Did she respond to the message that he sent her at 12:42?
Yes.
What did she write?
She said, "I love you too."
Then
Then says, immediately after that, "You okay?" Then 4 minutes later, she says, "Ethan, don't do it."
that was at 1:22 p.m.
Yes, it was.
That was after James Crumbley was at their home, 112 East in Oxford.
That's correct.
That's while she was on the phone with him.
Correct.
You said she sent a message to her boss, Mr. Smith.
Yes, she did.
Go back to exhibit 126. What did she write him at 1:23 p.m.?
1:23, she texts, "The gun is gone, and so are the bullets."
Then what did he respond?
He responds with, "I'm praying everything is okay." And Jennifer says, "OMG," or "Oh my God, Andy, he's going to kill himself. He must be the shooter."
So that's right. A minute after she wrote to her son, "Don't do it."
Correct.
That's while she's on the phone with her husband.
That's correct.
Oh, no, she should have told her son.
Did you come to
She
find
told him,
out
don't do it. That means
James
she's
Crumbley
guilty
called
of doing
911
it.
that day?
Yes, he did.
Was that at 1:22 or 1:20, or was it later?
It was later.
And was it before or after they had this text message conversation?
It's after.
Phone call.
After.
Okay. So in fact, did you find that James Crumbley called 911 at 1:34 p.m.?
That's correct.
Exhibit 143.
It's the actual policy. No, no objection, thank you.
So just so council knows, it's all listed in the exhibit list. It says 911 call. Easier for me.
It does, but I'm like, there's one of me. I'm going as fast as I can. I'm trying.
Exhibit 143.
Okay, I have this shirt. I'm at my house. I have this year situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer gun at my house right away, please.
Okay, I'm sorry, I'm sending them to your house right now, so they're on the active shooter situation.
I understand that. There's a missing gun. I have a missing gun and my son
I can't hear
goes
this.
at the school. And we have to go meet with the counselor this morning because something that he wrote on a parent paper, and then I went down and I thought, well, what's the cops somewhere, and I made sure that I wanted to get to the hospital, so I was going to the hospital, and then someone told me that there was an active shooter, and then I went home to find out, and I think my son took the gun, I don't know, I don't know what's going on, he's really freaking out, my son's name is Ethan Crumbley, who are you, and he's out of the bar.
See if I can work anything.
Thank you.
Okay, Mr. Crumbley? All right, I'm gonna get your name and phone number and then have representatives out there at the institution, he's gonna contact you, okay? What's your first name?
Yeah, but then it's James.
Is what you say, Crumbley? Okay. And what's that phone number for you?
750-643.
Okay, do you know what your phone number was at the house this morning?
He had on a pair of sweatpants and like a gray shirt, a gray like sweatshirt.
Okay. All right, so he's gonna give you a call, okay? I can't give you the time frame because we're kind of in the middle of all of this. I can't give you a time frame, but we're gonna give you a call so that it's possible, okay?
Okay.
All right, thank you.
Sir, we saw the location data that James Crumbley left the Meyer on Ray Road at 117. He was home by at least 120.
That's correct.
What's the relative distance between the Crumbley household and Oxford High School?
Less than a mile.
Now, after this phone call was made, did you learn that James and Jennifer arrived at the Oakland County Sheriff's Office substation in Oxford?
Yes, I did.
No objection.
What was this, 144?
144, yes.
Okay, 144.
I couldn't hear anything there, so it didn't matter to me. I don't know what that
So
means.
this is call log. James Crumbley's phone call.
Yeah, it says like
Right
it was
there,
911 call, but I don't know what that
number
was.
Number 17.
Yeah, actually, it's one of the sergeants in special investigations, Sergeant Joe Bryan.
Okay, so this is after the shooter is taken into custody.
Correct.
Okay, so you know that he was taken into custody right about 1 p.m. on November 30th?
Yes, he was.
Okay, and this is 1:50 p.m.
Correct.
Okay, so Sergeant Bryan learned who the shooter's parents are. He made a phone call to James Crumbley.
Correct.
And shortly after this, did James and Jennifer Crumbley both go to the substation to meet with police?
Yes, they did.
We're gonna let the vote
No
go for another
objection.
couple minutes.
No objection to 145 or 146.
145, 146, everybody?
Just quickly, this is the verify. They were in fact at the Sheriff's Office 148, both James and Jennifer Crumbley. Is that right?
Correct. I'm sorry. Yes.
Correct. 158.
Oh, what, thank you.
Okay, so they're at the Sheriff's Office at 1:58. Did you come to learn when they went back home?
It was about a half an hour after, less.
This is 1:40.
Okay, no objection.
So you're able to,
It's not been 147?
sorry, 147 and 148. Thank you. So on Jennifer's phone, you can tell that she's at home by 2:30
Correct.
on November 30th. Okay, and same with James.
That's correct.
So this is after they went to the Sheriff's Office and their son was in custody and then went back home.
Correct.
Okay. Now, sir, did you have the opportunity in the course of your investigation to review what we have referred to as the burner phones as well as the replacement phones?
Yes, sir.
Now, I'm going to move ahead to December 4th, 2021. Are you aware that they were arrested in the early morning hours of December the 4th, 2021?
Yes, I am.
Okay. This is 149 and 150.
We have no objection to 149 or 150.
149, 150. All right, we made it.
So I'm showing you 150. May I approach the 149? Sure. So this is, just tell me what that is.
This is a report from Celebrate from a phone.
Okay. And that's from her, what we call burner phone?
Correct.
Okay. And up on the screen, 150 indicates that she has set an alarm on her burner phone.
I would just ask if the witness answer the questions. Leading.
That's fine.
It's the same.
That's fine. What does that show?
There's a thumbnail of what is seen on the right side of the screen there, of the alarms being set at 6:30 on Saturday morning and 6:45 Saturday morning.
That's December the 4th, 2021.
Yes, correct.
Okay. Now, did you find evidence on the replacement phone, which is the phone that was ported with their original numbers, that they had attempted a two-factor authentication for social media accounts?
Yes, they did.
Okay. Now, we had talked at the very beginning of your testimony about deleted content and your ability to recover deleted content. Do you remember that?
Yep.
Okay. Were you able to uncover some deleted content in this particular case?
Yes.
And we've talked about the Facebook message chat between James and Jennifer Crumbley,
Correct.
and you've already indicated that that chat was deleted from Jennifer Crumbley's phone.
That's correct.
And were you able to obtain a Facebook thread between Jennifer Crumbley and someone named Brian Malash?
Yes,
And was that through a Facebook search warrant?
yes,
And did you uncover any messages before December the 1st of 2021?
No.
Okay. So if you were to learn that they had communicated on a regular basis through the Facebook Messenger chat, but you couldn't recover it, what would that indicate to you?
that it was deleted from the phone.
But on both ends, if you couldn't
Yes,
recover from
correct.
the server.
Correct.
Okay. Now, going through the evidence that you were able to uncover from Facebook itself, could you tell that some messages were selectively deleted?
Yes,
Okay. So exhibit 151.
This is okay. Okay, no objection.
So this is a portion of what you recovered from the Jennifer Crumbley and Brian Malash Facebook chat. Is that correct?
that's correct.
Okay. So what are we looking at here?
The first message is an automated one sent from Facebook to the device. You unsent a message.
Okay. And what's the next?
The next one says, from Jennifer, we're on the run again. Helicopters, not sure where to. I'll message you.
And when was this message sent?
You can see it says +0 for UTC. So you have to subtract 5 from the actual time that's displayed there from there. So that would have been 7:31 in the morning.
And what day was that?
8:31. That was on December 12th or December 2nd. I'm sorry.
Okay. So the shooting was November 30th. That was a Tuesday. Wednesday was December the 1st. This was the morning of December the 2nd.
Correct.
And did this indicate to you that they were deleted by Jennifer Crumbley?
Yes, correct.
How can you tell that?
The message, the automated response sent from Facebook saying you unsent a message.
Also 151. What time and day is this?
This is, it's 7 p.m. UTC, which is minus 5 hours. So it's 2 p.m. on December 2nd.
Okay, that's Thursday, December 2nd. And what did she delete from her phone? What message?
She had sent him, we're fucked.
Did she delete that?
Yes, she did.
Go back to exhibit 126. Were you able to tell that Jennifer Crumbley deleted some messages she sent to Andrew Smith?
That's correct, yes.
And how were you able to tell that?
Because of the screenshots that came from Andrew Smith don't match what was it came from her
Okay.
device.
This is exhibit 151.
No objection.
Okay, so before we get to 151, which is the extraction. Yes. Before we show that on the screen, 126 here, these are the screenshots found from Andrew Smith's actual phone.
That's correct.
Okay, so at 10:05 a.m., this is Jennifer writing this and sending this picture, correct?
Correct.
Okay, and then we just gone through this. At 1:23, she wrote, "The gun is gone and so are the bullets."
Correct.
Okay, and then what did she write after that?
I'm praying everything is okay.
That's what Andrew said.
If that's what Andrew said, yeah. Then she responds, OMG, oh my God, Andy is going to kill himself. He must be the shooter.
And then what?
I need a lawyer at the substation with police. Ethan did it.
Okay, and then what did she write him at 3:39 p.m. the next day, or later that day?
Later that day. I need my job. Please don't judge me for what my son did.
And that was just a few hours after the shooting started, correct?
Correct.
Okay. And then what did he write in response and what time?
At 5:47 p.m., he responded with, I can't even begin to understand what you're going through. I'm praying for you. I asked Carolyn to text you some attorney recommendations. And then she responded with, they're taking my cell phone.
Taking my cell phone, okay. Here's 151,
Well,
and
voting's over.
top message is what?
The one which she says, I need my job.
7:43
Please don't judge me for what my
Till he
son did.
wins.
Okay, so that's on these screenshots, so we know that wasn't deleted.
Correct.
Okay, now what about this message here?
I can't even begin to understand what you're going through. I'm praying for you. I asked Carolyn to text you some attorney recommendations.
Okay, and then we also have this final message there, taking my cell phone.
Correct.
Okay, but in the entire Cellbrite extraction from the text message thread between between Jennifer Crumbley and Andrew Smith on her phone, there were no other messages, correct?
Correct.
So that means anything before that message, she deleted.
That's correct.
Okay. So the only thing, I need my job, please don't judge me for what my son did, that was 3:39 p.m. So the gun is gone and so are the bullets. Has been deleted. OMG, Andy, he's going to kill himself. He must be the shooter. That was deleted. I need a lawyer at substation with police. That was deleted. The picture she sent at 10:05 a.m. was deleted, as was the gun is gone and so are the bullets at 1:23.
That's correct.
So I'm going to turn now to the Facebook messages between Kira Pennick and Jennifer Crumbley, specifically comparing what was found on Jennifer's phone with what was found from the Facebook search warrant from that particular chat.
Okay.
All right. 153 and 154.
Did we do something with 152?
We have no objection to admitting,
This was 152, Judge. We added this one.
Okay, you don't have any objection. But 152 is in there.
no objection, right? Okay. And then I'm sorry, what was,
153, 153.
no objection,
Okay.
sorry,
To 153 and 154.
correct.
153 and 154.
Thank you.
Yes, yay, we did it.
First, I'm
Read
going to
it.
show you 153, which was the messages left on Jennifer Crumbley's phone. I'm just going to show you the top portion of what is a cell right extraction report. So tell us what we're looking at here.
We're looking at the participants involved, one of them being Kira Pennick, the other one being Jennifer Crumbley. At the very bottom of the screen, you see the conversation is the messages of 26.
Okay. And that's not 26 messages that you selected. That's all that's remaining on her phone.
That's correct.
Okay. And 154 is what?
That's the, you can see at the top extraction report, Facebook warrant return from both Kira and Jennifer. And it says instant messages 4,047.
Okay. So that would indicate that everything other than those 26 messages remaining were deleted by Jennifer Crumbley.
Correct.
And one more, Your Honor. Nothing further, sir.
Thank you, Your Honor. Good afternoon.
Good afternoon.
I want to go back to, I want to just start, you've been obviously involved in this case since the 30th of November, 2021, correct?
Correct.
And since that time, you have collected and looked at an abundance of evidence related to the Crumbleys, the shooter, the shooting, everything, correct?
Correct.
And you, when you were testifying earlier, you testified that at a previous hearing, you had testified about the parents when they first went into Oxford High School, correct?
Correct.
And on that day, you had reviewed many, many materials prior to coming to court.
Correct.
And that hearing was a preliminary examination, which is a hearing that's before a trial, correct?
Correct.
And at that hearing, you did the best job you could in terms of explaining, answering questions,
This is
Correct.
crazy.
You
They're
were
even
truthful
referencing
on that
this. You
day?
can't generally
Absolutely.
do this.
as you're being today.
Either side.
And we can agree that you made a mistake about Mr. and Mrs. Crumbley arriving in the vehicle together at the school.
Because of the video, I would jump yes.
Okay, an honest mistake.
Correct.
And it's fair to say that when you didn't have more information, you made an assumption that they had been in the same vehicle together, correct?
Correct. I didn't know how many cars they had at the time.
You see them walk into the school together, but you couldn't see before that.
Correct.
And that's why you testified. Honestly, you thought they had arrived together, but it was incorrect.
Correct.
And so you would agree with me that the more information you have about any topic
Where are you
and the
going
less
with this?
guessing, the more accurate the information will be that you give on this witness stand, correct?
I wasn't guessing before. I didn't know how many cars they had. I just saw them appear in front of the car.
It was a guess.
Right,
You
so
made
when you
just
testified
admit
and
you made a
said
guess,
they
bro.
arrived in the same car,
My
that was
dude.
incorrect.
My dude.
Correct.
And I'm saying that had you had more information about seeing the vehicles pull up or seeing each one get out of separate cars, your testimony would have been different, correct?
It would have been included in the video. Correct.
And so my point is you do the best job you can with the information you have,
Yes, ma'am.
but you're certainly not someone who can go back in time and see and know every detail of every single thing that's happened, correct?
Not every single thing. You could put together a good timeline with all the information that you gather. Yes.
And it's fair to say for this jury, you have put together as detailed of a timeline as you can about all of the events before November 30th through 11/30th and beyond 11/30th, correct?
That's correct.
And when you are doing that, you are taking data from cell phones and other investigators, from surveillance, from all these different materials that are a part of the investigation in this case.
Correct.
And it's possible that at times when you answer a question, you may not be accurate, but you're not sitting here intentionally trying to lie, correct?
It's absolutely correct.
Okay. I'm going to go back through the investigation that you did. It's fair to say, and I think you testified, you started obviously on November 30th of 2021, correct?
When the investigation started?
Yes.
Yes.
Okay.
Yes.
And
That's what she's getting at.
can you give the jury an idea of how much time it takes to get certain evidence or kind of what it looked like going forward from 11:30 when you received various pieces of information? So on 11:30th, let's talk about what you saw that day. You obviously saw the surveillance camera from the school, correct?
Yes, correct.
Okay, on that day, did you have the surveillance camera from Jennifer's office?
That came afterwards.
Okay, that came down the road.
Yes.
At that time, did you have the text messages between Jennifer Crumbley and James Crumbley?
That came out. No, that would have been afterwards.
Okay, when did that come?
It would have been within a week, 2 weeks of that. We would have had to, like I explained, the process of getting the data from a phone. Depending on how much data there is, it could take a while and then to sift through all of it. So it could be anywhere from a couple days to a couple weeks to get everything that you're looking for.
And in terms of the investigation, there were materials you had on the 30th, obviously.
Correct.
There were materials you received in the days following the 30th, correct?
Correct.
And there were some materials that law enforcement didn't have for weeks and months that became a part of this investigation. Is that a fair statement?
That's correct.
And as more and more information became available, you would turn it over to the prosecutor's office?
Correct.
And then you would assume that they would turn the evidence over to the defense for it to be used in court by all parties and the judge.
Yeah, I do my job. I don't know what they're, I have to give that up. Yes, I understand that.
Okay, so at the time on the 30th, it's fair to say all of the evidence that you have in this investigation, I'm sorry, not on the 30th. The 30th was the day of the shooting, and Mrs. Crumbley was arrested overnight between December 3rd and December 4th, correct?
Correct.
And it would be fair to say that between November 30th and December 3rd, your office and team and all law enforcement were working as hard as they could to collect information and collect evidence, correct?
Correct.
While you were working as fast as you could, there were a number of materials that you did not see until after Jennifer Crumbley was arrested.
Well, just because of the sheer volume of information that we were pulling together at the time, yeah, I mean, it took a while to go through it.
And when you're looking at all of the information about Jennifer Crumbley in this investigation, much of what you're doing is looking back in time in hindsight.
In hindsight, we're trying to put a story together, a series of events or a digital footprint of what had happened. We're trying to put that together.
And as you're trying to put that together, you're doing the best you can to make the timeline.
This is better. I
and
like
make
this.
sense, correct?
I like where she's going.
Correct.
But in terms of what happened in the months before the shooting, the day of the shooting, and the days after the shooting, you obviously were not with the Crumbleys 24/7, correct?
No, I was not with, I didn't know them before this.
And it's impossible to have, there isn't any way to have a videotape, for example, of all those months, that shooting day and the days following, correct?
Correct.
So you take bits of information and try to put it together the best you can to make sense of it.
Are you referring to this investigation or throughout life?
Well, both. I mean, I guess we do that in both, right?
I guess if in my life, if my son had hallucinations, I would have taken serious pause with that.
All right, let's stop for 1 second.
Hmm.
When you say hallucinations, you're saying that you would take serious pause, but in reality,
He's not a doctor.
you
He
did
can't
not know
comment
the
on
shooter before
hallucinations.
this shooting, correct?
No, I did not.
You do not have awareness if he was really having hallucinations, correct?
I would have taken some time to look into it.
No,
You're
probably
aware
not.
that there's this text thread, and we're going to get into it later, where he's telling his parents he's seeing things, correct?
Correct.
But you weren't a part of any of the conversations or a part of that household in those days around that text message conversation, correct?
No, I was not.
You're
I
not,
didn't know them before this.
okay, you're not aware of what Jennifer and James and their son had been talking about in person before and after those text messages.
Well, from the text message, I know the son on a couple of occasions asked or spoke with his friend about seeing a doctor or wanted to go see his doctor, tell his parents tell his parents that he wanted to go see a doctor.
And while there are texts between the shooter and his friend, you have no evidence that Mrs. Crumbley has ever seen those texts, correct?
Very good point.
That she has read them? No, I
So,
do not.
So there's text that the shooter sent to his friend, and you have no way to know whether Jennifer Crumbley ever saw those text messages, correct?
Get it.
Other than his own words saying, I'm going to tell my parents tomorrow that I want to go see a doctor.
But that doesn't mean
That
anything.
telling his friend, I want to go see a doctor.
doesn't mean
And I'm
anything.
going to tell my parents tomorrow. You don't know if he really wanted to go see a doctor or was going to tell his parents, correct?
I understand that's counsel's argument, but it's improper questions. He's already answered the question.
Okay, you don't know whether Mrs. Crumbley saw the text between her son and his friend.
No,
You have no idea.
And I'm also making the point, Your Honor, in the
That's a
question
very
is,
proper
you
argument.
also don't know if it's true that he really planned to tell his parents anything. He has a text to a friend saying that, but you don't know whether that's
Nope.
true or not, correct?
Take advantage of the
Other than
speaking
saying
objections.
A couple occasions, no, I don't.
Okay, and when you say a couple of occasions, there's text messages on certain days that that you testified about, but there's many, many, many other days, we can agree, that you have not testified about, correct?
In reference to what?
In reference to what he said to his friend, or in reference to what he said to the Crumbleys.
I mean, did he have are you asking, did he have conversations with them? I don't understand the question. I'm sorry.
I'm sorry, my
He's a
question
shitty.
is,
He's being an
you've
asshole
given
now.
us bits of information about certain days, about March 9th, about a date in April, about a date in November, correct?
Correct.
Okay, there's a lot of other dates that you did not give us information about what exactly was texted to and from Ethan Crumbley and Mrs. Crumbley, correct?
Correct. There wasn't much texting between them.
Okay, you also, there's
Ooh, that's-
certain
yeah.
messages that you testified about
You should have limited that to
between
yes or
the
no.
shooter and his friend.
Correct.
There's also a lot of other text messages between them that you have not talked about.
Well, because the stuff that was talked about was not allowed to be talked about. You talked about,
Your Honor,
Yeah.
This-
Well, I think it's important, Judge.
Yeah.
Counsel can't ask questions about evidence that she sought to exclude.
Okay,
telling this jury that I sought to exclude evidence that was irrelevant is very unfair and that is improper.
okay, well, there's a lot of improper things here. No one's hiding any evidence from the jury, okay? So I don't want any implication that this witness is hiding what evidence from someone. So,
Thank you, Judge.
so don't ask about the messages if you don't want to know.
Okay,
Well, that's
in-
such a bullshit.
when you're talking about the text messages, let's back up and.
Good
do this
job,
differently.
though, getting that out there. Like, look, there's a whole new
You
world of
went
stuff.
through text messages between the shooter and his friend to find evidence to support that the shooter was having issues, correct?
to build, we went through the text message to try to get an idea of who he was and what he was going through and what he had talked about with his friends.
And when you saw
His friend,
text
I'm sorry.
messages like you testified about involving seeing things and dishes flying and demons and things along those lines, you gathered those, and that was the evidence that you've presented to this jury to support your case, correct?
Well, because those are things of importance that he was hallucinating and seeing stuff flying off his shelves. And there's no other evidence that we could find on the phones or communication between them to say that that problem was remedied or that a phone call was made to the shooter to what's going on or how can I help you, son, or anything like that. None of that was found. So it was important that that was what he was struggling with.
Okay,
See, that's the problem when you ask some of that stuff. Like, he gets that big thing out there, and it's like, okay, well, that hurts. Bella, you're talking about the video games. Look, guys, we're not going to use, like, I understand other channels, like, they don't like using the words, like, so just say suicide. We're not going to say self-deletion and all that. Like, YouTube's going to do what it does anyway. So, apparently there's a video game suicide case. I don't know which one you're talking about. That's so I don't know. Maybe we could. Is there a trial about it or anything like that? I mean, we could certainly cover it. Especially if you guys are on locals. The big thing I would say there is, throw those things out on locals. Like, hey, here's a case, or if you want to send me an email because it's down below. Hey, can we look at this or that? Because if you just say like the video game suicide, it's like, I don't necessarily know which one you're talking about or if that is the proper way to do it. So yeah, I mean, I'm happy to look at cases. I just don't know about all of them out there. But there's a couple of super chats here I did want to address real quick too, since we had to stop. Shade Chaser for $10 saying, trying here where it will be read. If she or her hubby are found guilty, will that open up cases against witnesses and first responders who fail to stop a crime in progress? and chip away at qualified immunity. No, qualified immunity is never going away. It's not. This won't hurt that. This is the king's men will never be held accountable. And then this is different. They're arguing there's a different duty of care because it's a parent. The idea that we have an obligation to help random people, that would be, I mean, certainly you might be able to like stretch an argument, but that's generally never been upheld in modern society. So no, and it won't hurt qualified immunity. Cops will never let that happen. The government's never going to let that happen. But it's a good question. And Soul Souffle for $4.99, thank you, is saying, I, Jenna James, had not gone on the run due to threats of their lives. Can we speculate that she would not be on trial? I kind of get the feeling that they were probably going to get tried no matter what. The DA at the time, it's still their DA, is a bit of a dingbat. So I have the feeling that it only helped the case, strengthen it. But I could see them being tried no matter what at this point. Because it's not the best set of facts. You go to the gun store and 5 days later, they're dead kids. Like, it doesn't look good. It doesn't look good on its face, but that doesn't mean that's the right call to prosecute. That's how I would look at it. So here we go.
You're guessing that is what he's struggling with. You're doing the best you can, but you're getting pieces of information out of text messages, and really you don't know these people or what was going on other than what you see in these texts.
He agrees with it. He didn't know anything before this.
Okay, I apologize. Well, I keep ending up in a situation where we're trailing off and repeating, and I would just ask that stop. When Mr. and Mrs. Crumbley were at their home and law enforcement came to their house, it's accurate that the cell phones from the parents were taken by law enforcement.
The first time they came to the home?
Not necessarily the first time. I'm asking, police took the cell phones that Jennifer and James Crumbley used. Police took those phones, correct?
Yes, they did.
Okay. And when police took those phones, Mr. and Mrs. Crumbley obviously went and bought burner phones or track phones.
Correct.
And you've testified that you can see that Mr. and Mrs. Crumbley, or at least Mrs. Crumbley, attempted to get into some accounts that required two-factor authentication.
That's correct.
Can you please explain very quickly what two-factor authentication means for the jury?
It's so someone can't get into your account with just simply your password. When you open up an email account or you open up a Facebook account, and it tells you, put your phone number in here. So when you try logging in from a phone or a device that Facebook doesn't recognize, it'll send a text message to the number that you send a text message to. So then you enter that code into the app as you're trying to log into it. So it's two-factor authentication, password, and then text message from the provider.
And so for things like sometimes bank accounts or portals to get into doctors, things along those lines, sometimes two-factor authentication is required where you would need your original phone, correct?
Correct.
Or at least your phone number to be able to gain access to your own accounts.
That's correct.
There are accounts that will block you out if you're using a device it's not used to seeing when you log in.
If the two-factor authentication is set up?
Yes.
Correct.
And so in this case, you could see that Mrs. Crumbley attempted to do some two-factor authentication and was unable to do so, correct?
I don't know what she was unable to do. So I know there's a text message that was received from Instagram with a two-factor. I don't know what happened with after that.
Okay, so after buying the track phones, the burner phones, it's fair to say that Mrs. Crumbley and Mr. Crumbley went to their phone carrier and purchased new phones that have their regular phone numbers on them, correct?
Was that after the burner phones, is that what you're saying?
Yes.
Yes, they did.
Okay, so when we're talking about the Crumbleys having 6 cell phones between them, the 6 cell phones include their original phones that were given to police, correct?
That's correct.
It includes these 2 track phones that have different phone numbers where you can't do the two-factor authentication, correct?
That's correct.
And it includes the 2 phones that were purchased after that so that they could have their phone numbers back on devices and then access accounts.
That's correct.
And from the phones, when you seize them, there is evidence that Jennifer Crumbley attempted to deactivate and delete a number of social media applications, correct?
There was talk about it in text messages. You need to delete this account or whatever. I don't know if you have something in particular that you're a certain account that you're asking.
There are text messages within the exhibits the prosecution has admitted, and I can put them up, that show Mrs. Crumbley and Mr. Crumbley were trying to deactivate Facebook accounts and Instagram, correct?
I know there were text messages people texting them telling them to do that, yes.
Okay, and part of the reason people in those text messages were telling them to do that is because after the shooting, there were threats and, there were a lot of threats against Mr. and Mrs. Crumbley.
Judge, respectfully, I don't believe this officer can testify as to the reason why people said that. He can testify that there was attempts to delete and things were deleted, but the reason for the motivation, he can't testify.
Well, you can't testify about.
Well, you're claiming the motivation's bad.
Did you see threatening messages to them?
I don't recall seeing any person. No, ma'am, I don't.
Bullshit.
Do you recall that when in the text messages that Jennifer Crumbley sent out, she told Ms. Brian Maloche, she told Kira Pennick, she told multiple people that she was being threatened?
Are you telling me that?
I'm asking you.
See, here's the problem. Even if they're out there, he's not going to say yes. He's the government witness. He's not going to help, even if he can. I'm not trying to say this guy's a scumbag, but he's a scumbag. And these guys are not going to help if they can.
I don't recall if you have something to show me. I don't recall that off the top of my head.
Okay.
Well, hopefully there are some. It doesn't sound like she has them, so. Good, she's got the receipts. Good, make this guy look like an ass. Make him look like what he eats.
Okay.
He is what he is.
Okay, so in okay. I'm going to put on the screen exhibit number 130, which was admitted in your prior testimony. Is it? Yeah, sorry. Okay. Now, within the text message thread between Jennifer Crumbley and Kira Pennick, this is a screenshot that was in that text thread, correct?
This is from Kira Pennick's, a screenshot of hers? Is that what this is?
This is in exhibit 130 that's been admitted. These are screenshots with Kira Pennick. And I am asking you, this is a screenshot showing threats to Jennifer Crumbley that Jennifer Crumbley showed to Kira Pennick.
I don't know. I don't remember ever seeing. I don't know where it says Kira Pennick in the title of the image, but I don't know.
Okay.
Is there a copy of the exhibit that you could?
Yep.
Did you say this is in 130?
Your Honor, this is in 130, and I apologize. I am going to have to go in detail through each exhibit.
See, and this is the problem. He's like, well, I don't know who that could have been from, but he knows these other ones are from who they say they are. Why? Well, because. So, brilliant, isn't it? Warms your heart knowing this is how the state works.
I did not want to do that, but it's very clear I'm going to have to. So I'm going to the top of this. This is a 28-page exhibit, okay? This was
He's getting the same challenge you are, so there's so much paper that.
right.
He can say, if there's a hard copy of the exhibit, that could help him, right? Is there?
May I approach?
Yeah, can you take?
Yeah, that's,
Okay.
okay. So this was admitted, these were admitted screenshots through your testimony. Do you recall that?
Yes, I do. I see the.
Okay.
Does that document request your information?
Well, this part at the where it
Thanks.
says
That's a
that was
shame.
counselors. Yeah, that part I remember that.
Okay, and in the thread, we see what you testified about in terms of Jennifer Crumbley sending over a copy of the math assignment.
Correct. I see that. Yes.
Okay, we see the testimony you gave about Ethan being upset, having lost his friend and going away, and his dog.
Correct.
Okay, going further down, this is before before the shooting started, okay, so I'm on page 4 of that exhibit, going into page 5. This is all before the shooting, correct?
Correct.
Okay, and in this part, they're talking, Jennifer has told Kira Pennick, as you testified, about the math worksheet.
Yes,
She's told Kira Pennick about I had to go to the counselor's office to have a meeting with them.
correct.
Kira's talking about what horse Ethan could possibly be with that day that might make him feel better.
Correct.
And as the text thread goes down further, Kira and Jennifer, it's fair to say, remained in contact through the time of the shooting and after the shooting.
Correct.
Okay? And on November 30th, Kira Pennick is asking, she says, I heard there was a shooting at Oxford High School. Is Ethan okay? Correct?
Correct.
Okay? Saying, if you need anything, let me know.
Correct.
And after the time of the shooting at 4:42, Jennifer Crumbley is texting with Kira Pennick again,
Correct.
talking about how she needs to sell her horses.
Correct.
This is when she knows that the shooting has happened and she's, well, she says, my head is spinning right now, correct?
That's just, yes, correct.
Okay? She's talking to Kira Pennick about selling the house back and forth,
Correct.
okay? And Kira is talking about how she'll take care of the horses for Jennifer.
Correct.
Okay, and Jennifer says, I don't have my cell phone right now. She tells her I'm on this track phone
Correct.
because the police have her real phone.
Correct.
Okay, and then Kira tells her about how there's stuff on Facebook. People are figuring out what's going on, correct?
Correct.
And Jennifer indicates, I'm off Facebook. I'm still in shock.
Correct.
Okay, and Kira offers to send Jennifer, can you receive pictures? I'll screenshot it, correct?
Yes.
And then Kira goes on to send Jennifer screenshots of something a mutual friend posted that was about the shooting, correct?
That's correct.
And their discussions are about, it says right in the exhibit, I cannot believe people on Facebook. I'm so sorry you're having to deal with this stuff, correct?
Correct.
Okay. She asks a question about the medication, and Jennifer indicates we're at a hotel in Lapeer and that the news is live at her house, correct?
Correct.
Kira's response, at least in the text messages, is please stay safe, correct?
Correct.
And Jennifer sends her over what appears to be a screenshot from a social media app, maybe Facebook or I'm not exactly sure, but you can see that Jennifer sent a screenshot where she has received nasty messages to her.
So I'm just going to object to the form of the question. Mr. Rogowski can certainly read all of this, but calling it a threat or nasty, that's not for him to answer. That's for the jury to determine.
Well, yeah, they can hear from it,
They can read it.
but definitely they're not nice.
Okay, can you please?
Oh,
tell
no,
the jury what-
now the jury can
what
read it.
these messages say. Larry
okay.
Barton.
I'm sorry, you want to read them? What
Sure.
it says on there? It says rotten jail next to him.
Okay, Brandon Hegwood,
What a shame on you.
Kaylee Camacho,
Fuck your ugly ass kid. I hope.
I didn't find any threats. Well, except for all these ones. I didn't find anything, and I'm honest engine. I'm good old Fed boy. Fucking liar.
Adam Tank,
What a fucking coward, Ethan.
Jennifer Crumbley texts to Kira, I can't go home.
Correct.
And Kira texts back that she's concerned for Jennifer's, and when she says you guys, I'm concerned for you guys, and is expressing concern, correct?
Yeah. Yes, just stay away from the horses. Correct, yes.
Okay. She also says she's worried about your horses or hurting you while you're here, correct?
Correct.
Okay. It's fair to say that Jennifer and James are afraid of the public's reaction to what their son did.
Again, Judge, form of the question.
Yeah, I don't understand it.
Well, let me back up. I'm sorry.
I don't understand it. You fucking know
Okay,
what
so
they
we know
mean.
the news has been around the Crumbley's home.
Correct.
Okay, so following the
civil
shooting, news,
man.
there was media all over their street, correct?
I wasn't there. I don't know. I wasn't there. I can't tell you if there was media there or not.
Okay, it would surprise you if there was?
It wouldn't surprise me, no.
Okay. There were some nasty messages coming into Mrs. Crumbley.
From the screen, are you referring to, yes, I'm sorry, yes.
Okay, and Jennifer is saying
All that
she doesn't want
crying
to put
and you don't know what
anyone else
happened.
at
Come on,
risk.
dude.
And that specifically
Bro.
is on page 15 of the exhibit you're looking at.
Bro.
Correct.
Kira is telling her about, or is commenting people are ridiculous, also talking about buying horses, other random comments in there. Is that a fair statement? There's some miscellaneous, I don't know.
She also said, be honest about things too.
Yep, Kira is saying to her, the best thing you can do is be honest about things.
Correct.
Okay, Jennifer's not saying, I don't plan to be honest, right?
You didn't respond with that, no.
Okay, Jennifer's not saying, I've got a big plan to lie, help me put this together.
I don't, it's not in here, no.
Okay, we have no evidence to suggest that Jennifer's telling Kira to lie about anything for her.
Correct.
Okay, so when Kira's saying be honest, she's saying be honest, but you have no reason to believe that Jennifer's attempting to be dishonest at this point, based on that message.
At this point, no, but they were taken into custody for a couple days after they were told to turn themselves in.
I'm sorry?
They were taken into custody a couple days after they were supposed to be taken into custody.
Okay, we're gonna get there, we'll get there. Jennifer Crumbley is representing that she's trying to work out lawyer fees, figuring out about being questioned, if she's gonna be brought in, amounts she can pay, things like that, correct?
Correct.
Okay, and Jennifer is telling her, I'm bawling right now, my son ruined so many lives today.
That's correct.
And he did ruin so many lives that day.
Yes, he did.
Oh, don't focus
And-
on that.
Kira is writing back to her, she wishes she could help more, she's also in shock, correct?
Objection again, in the form of question, Judge.
Well, it was no, she's in shock, she said, she texted.
Okay, I'm sorry, she texted, I am still in shock too.
That's what she texted, correct.
And Kira encourages Jennifer, take it one day at a time, and again, just be honest about everything, it should help you through this.
Correct.
And offers to take care of the boys, which we would guess is her horses.
The two horses at her farm, correct.
Jennifer is thanking her for not judging her, like, unlike the whole world, correct?
That's what, yes, correct.
Okay, meaning that we can assume Jennifer feels the whole world is judging her.
Again, objection in the form of a question.
Yeah, I think it's a dog, he knows what the text says, he doesn't know how she feels, but that's what she said.
Okay, that's what the text says.
That's what the text is, correct.
Kira says that she's not going to essentially judge Jennifer. It doesn't remotely make her think it's their fault, correct?
That's what Kira texted, yes, correct.
And then Kira says, it sounds like Ethan was a troubled kid.
Correct.
It's unfortunate this happened.
That's correct.
Okay. And Jennifer is texting her back, I wish we had some warnings. Something. That's what Jennifer texted back to her, correct?
Yeah, the hallucinations, back to that, could have been warnings or seeing demons.
Okay. And again, you didn't know these people, you don't know the context, you don't know what they discussed. We've already covered that earlier in your testimony, right?
I do not know them before this prior.
Okay. So you've talked about the hallucinations.
And this is
many
where,
times,
oh
but
God,
nobody gets it.
if he's
There's
gonna get
text about
into that,
hallucinations.
if he wants to
We
play
all
that
agree.
game,
Those are there, okay?
he wants to play that game, boom, but he also said he went to the doctor, so he was being taken care of. Bam! He's like, well, I don't know if that's true, so then what do you know is true, huh, sir? There's ways she could fucking hammer this guy, and she's doing a pretty good job. She's putting it to him. Well, got to go home and cry and, hug random kids on the way home.
To you, those would have been alarming. You would have acted differently based on getting that text.
Absolutely, I would have.
Okay. Jennifer Crumbley is texting her friend Kira in this text thread. That's what we're going over right now.
Okay.
And her texts are saying, I wish we had warnings.
Correct, that's what she put, yes.
Okay. And Jennifer Crumbley wrote, he's a good kid. They made a terrible decision. And there may be typos, but it says, he's a good kid. They made a terrible decision, correct?
That's what she typed, yes.
Okay.
Yeah, but it's...
Kira responds back, there probably were warnings, but nobody saw them. Hindsight is always 20/20. I don't care if you agree with it or not.
That's what's typed
what
there.
Kara says.
what's
Hindsight
typed
is
there.
always 20/20, correct?
That's what's typed there, yes.
Yes.
Then Kara goes on and says, people at the barn are concerned. I'm sorry, I'll go slower, okay? A lot of people have found out Ethan's all over Facebook. That's the next thing she says, correct?
Correct,
And then she goes on to say, people at the barn are concerned.
correct,
She tells Jennifer, I think it would be best if you didn't go out to the barn, or if you do, you should be escorted by police, correct?
correct,
When someone's escorted by police, that's usually for safety reasons, correct?
possibly, yes.
Jennifer says, seriously, those horses are the only thing good in my life right now. This is after the shooting, correct?
Correct,
And Kira responds, I understand that, but we all need to be careful.
correct,
So it's fair to say there was a concern about safety regarding Jennifer after the shooting, and also other people around her were concerned for their own safety.
correct,
And it's also fair to say, and if you don't know, please just let me know if you don't know, a lot of people in this state hated Mr. and Mrs. Crumbley when they heard about this shooting.
Judge, he can't
I don't know.
answer that question.
I don't know how we can testify to that.
Okay,
There was widespread attention.
there was widespread attention.
yes, there was, that, of course,
And there were many news articles,
correct, yes,
and people on anything like this are naturally upset to see a school shooting,
absolutely,
and people naturally are angry to hear that children have died.
absolutely,
And this was the kind of event that sparked a lot of emotion in a lot of ways.
that's fair to say,
That's fair to say for you personally.
absolutely,
You would imagine that for other people, they were personally affected by this, very emotional.
yes,
And it's fair to say that this kind of a tragedy it was just horrific. We can agree it was horrific.
the shooting, yes, it was, absolutely,
Jennifer tells Kira to call her on Facebook. She's on a track phone, needs to figure some things out, correct?
correct,
If they did have a phone call, you're not aware of it. Well, and I'll slow down. The next message says, sorry, I missed your call from Kira, correct?
correct,
But we don't know what happened in between the text about calling at 11:23 and the text the following day at 2:34. We don't know if there ended up being conversations or not. Is that a fair statement?
correct,
You can't tell from this
not from
thread.
this, correct,
So they're going back and forth, talking more and more about letting her know later today, things like that. They're talking horses in between all of this. Is that a fair statement?
correct,
And on the bottom of page 22, Kira indicates, I don't want people to follow you or hurt you.
correct,
And Jennifer says, we are out of the area for a few days in a safe place until we have a better
We'll get
grasp
to
on
this,
everything,
Ellie.
correct?
that's correct,
She doesn't say, we are trying to get out of state, we're trying to get out of the country. She doesn't say anything like that, correct?
not in this chat thread,
Okay? In this, she says, we're trying to be in a safe place,
correct,
which would indicate safety is, of course, a concern.
You gotta be
to
careful
the
about
Crumbley
phrasing it that
parents.
way. You're gonna get hammered.
by saying they're in a safe place, yes, I would say that,
Kira says, I'm glad you're safe. I care about you guys, correct?
correct,
She assures her she'll take care of the horses. They'll talk about buying them, figuring out somebody to buy them, correct?
that's correct,
A few more text messages back and forth about meeting before then. And then on page 24 of that exhibit, Jennifer says, what's your number? I want to call and set up a safe place to meet, correct?
that's correct,
Okay, she mentions that her messenger is probably being monitored,
she does say that, yes,
okay? And she's talking about she needs to get stuff, discuss the horses, correct?
that's correct,
And let's see, they're going through more about whether cash or checks are best.
What page is that?
Or
I see that,
that,
yes, I'm sorry.
25.
Yes,
Okay, and you're aware that after the night of the shooting, the Crumbleys went and stayed in a local hotel.
yeah, correct. They went to a hotel, yes,
Okay, and the next day they went to a different hotel.
correct.
Okay, which was also, I mean, maybe an hour from here, a local hotel, not out of state, not out of the country, right?
Within an hour, yes.
Okay, and so in the days following the shooting, the Crumbleys did not return to their home in Oxford.
They did not know.
And as far as you know, since the day of the shooting, the Crumbleys have never returned to their home in Oxford.
No, they've never been back.
See if there's anything else, I'm sorry. Okay, and then the rest of this is talking about possible charges being announced, and things. Jennifer is saying, she's anticipating there may be charges announced, criminal charges,
Yes, at the night before, I believe, on page 26, yes.
after the shooting.
Yes,
And when she's talking about charges, she's trying to figure out if they're charges, well, I'm sorry, scratch that. She's talking about charges against herself, correct?
I'm not entirely certain if she's, it doesn't say whether she's referring to herself or somebody else.
Okay, so she's waiting to basically just figure out what's going on.
Judge, again, counsel can't narrate what she thinks her client was thinking. She can have him read the text message. I admitted it into evidence. They can have it all.
Yep, okay, so there's a text.
Okay, so the text says, Jennifer Crumbley wrote, I'm not sure what's happening.
Yeah, yes, I'm sorry, yes.
Okay. From the text message thread that the prosecution introduced between Jennifer Crumbley and Brian Maloche, we also can conclude, and if you can't, let me know, that Jennifer Crumbley was trying to deactivate and delete social media accounts.
I believe she was, yes, I believe they discussed that, yes.
And Jennifer Crumbley is asking Brian Maloche things about, can you still see James's Facebook? Can you see my Facebook? Questions like that, correct?
Correct.
Okay. James and Jennifer Crumbley Jennifer Crumbley in her text messages is very clearly making it obvious. She is telling Brian that she is shutting things down. Like that.
I don't remember the language that she used. I know they talked about it. I don't remember if she was afraid of shutting things down.
If a person has a Facebook account that they deactivate, okay, I'm gonna go even slower. When someone has a Facebook account, other people in the world have the ability to see that account, correct?
If it's public or your friends or whatever other security are saying, but yes.
However you have it set up,
Yes,
you allow who can see the account and who can't, correct?
that's correct.
If you do have an account and you don't want the world to see it, if you deactivate the account doesn't appear when people look for you on Facebook, correct?
That's correct.
So if the Facebook account is deactivated, people cannot send you messages through Facebook, correct?
That's correct.
And they can't send you messages through Facebook Messenger.
I'm not entirely certain if you'd have to deactivate Messenger as well. I don't know, because they are two separate platforms. It's under one company, Meta, Facebook, but I don't know if you have to deactivate both of them.
So with Messenger, if Jennifer Crumbley deactivated Messenger, we can agree that people wouldn't be able to send her messages.
Correct.
And in general, if a person is trying to avoid having people find them on social media, deactivating the account makes it so people don't find them, correct?
Correct.
So for example, Instagram, Jennifer Crumbley had an Instagram account and you testified about that to the jury, correct?
There's a two-factor authentication test that was found, yes, with Instagram. Is that what you're referring to?
I'm not referring to the two-factor authentication, but you testified that Jennifer Crumbley had an Instagram account. Well, we can agree she had an Instagram account.
Yeah, the post they were admitted the other day, I believe, right?
Right,
Yes.
and in that, on Instagram, the whole point of Instagram is to post photos or videos, correct?
Correct.
And we can see the Instagram account that Jennifer Crumbley had with videos and pictures she had posted over time.
Correct.
And when a person turns off or deactivates their Instagram account, other people in the world don't have the ability to see those photos any longer, correct?
That's correct.
Other people in the world don't have the ability to send messages through Instagram to the person that's deactivated their account.
Correct.
So as a computer expert, if a person is trying to avoid having people see them or find them or see posts of theirs, even old posts, deactivating the account will accomplish that task.
Correct.
On that Instagram account, you are able to tell from the data that you received other accounts that Jennifer Crumbley followed.
Correct.
So meaning that from her account, Jennifer Crumbley had certain people she was linked up with where she could see what they posted on their accounts, correct?
Correct.
And on the flip side, people she was friends with on Instagram or connected to could see what she posted.
That's correct.
And we know that Jennifer's son had an Instagram account, e.crumbley, correct?
Correct.
And we can tell that Jennifer's account was.
I don't think there's anything big on the Instagrams, though. I thought it was all Facebook and stuff. I don't recall anything about Instagram, but.
Her son's in a way that she could see what he posted on that account.
Correct.
And we can presume he could see what his mother posted.
Correct.
When you are looking through the Instagram records, you are not able to tell which posts Jennifer did in fact see or not see, correct?
Correct.
So if the shooter posted something and Jennifer Crumbley had not checked Instagram, it's possible she would not have seen it even though he posted it.
It's possible.
If he posted it and she looked at Instagram and looked at his account, looked at his profile, is that what it's called? She would certainly see anything he posted.
Looked at his account, you're saying, I'm sorry? Yes, correct.
But in terms of all of the data you have, you don't have any way to determine which Instagram pictures she did or did not see.
Correct.
Now, if she made a comment on a picture, you would know she obviously saw it because you couldn't comment unless you had seen the picture to put the comment on there, correct?
That's correct.
And on the Instagram photos, there are not comments from Jennifer Crumbley to her son about the posts, correct?
On all the photos or a particular one?
I suppose the ones that we've admitted as exhibits in this case, the photograph of the gun, for example.
Correct.
And there's no doubt the shooter licked guns.
Correct.
And there's no doubt Jennifer posted photos of the gun.
Correct.
And videos.
Correct.
And even with what she posted, we can't tell if the shooter could see her posts.
Possibly, correct.
He may have seen them, he may not have seen them.
That's correct.
In terms of people communicating, we know that people can communicate obviously by telephone, voice phone calls. I don't take many these days because I hate them, but in the old days, we could talk on the phone from one person to another, correct?
Correct.
And there's the ability, obviously, to text. People can send messages from one person to another.
Correct.
And in terms of people's habits, some people may delete texts when they get them, correct?
Correct.
Some people may keep every text they've ever had.
That's correct.
Some phones will delete texts after a certain period of time.
Not unless the user tells it to, no.
If someone gets a new phone, there are occasions where the old text from the old phone may not come up on the new phone.
I can't say for certain. I don't know. I haven't tested something like that yet. I don't know.
We can agree that everyone's personal habits in terms of how many texts they keep on their phone or don't are individual to each person.
Correct.
So when you're testifying and telling the jury about posts that you can tell or texts that you can tell are deleted or not deleted, you have never sat down and talked to Jennifer Crumbley about her habits with deleting posts or pictures or texts, correct?
That's correct.
the best you can do is look at what's deleted, what's not deleted, and tell this jury your findings.
Correct.
I want to go to March 9th of 2021. You testified pretty extensively about that date. Do you recall the materials from that date? And if not, I can certainly.
Absolutely. Yeah, if you have copies of it, I would prefer that. Yes, please.
Okay. So on that date, I will approach with copies in just a moment. I just need to pull it up on my computer. I'm going to go to exhibit number 78. Okay. So, Your Honor, may I approach the witness?
Sure. I think he has it on his screen.
You said you wanted hard copy.
Either way, it doesn't matter to me.
Okay, okay.
Are you okay with the
That's
screen? Or do you want?
I'll have that, please.
Okay.
Yes. Thank you.
Okay. So March 9th is one of the dates that you talked about.
Correct.
And the text messages that were introduced make it clear that James and Jennifer Crumbley made plans that day to go out to the barn, correct?
Correct.
And you have photos confirming that they were in fact at the barn, photos of horses they took.
Correct.
Okay, the jury has seen that the data shows the times these photographs were taken, so we know they were taken on March 9th.
Correct.
Okay, you've brought in GPS locations to prove they were there on that date.
Correct.
Okay, and it's on that date that the shooter is sending his parents some texts that were admitted through Exhibit 82. Do you recall those texts?
I do, yes.
Okay. Now, in these texts, starting at, I'm going to put it up on the screen. This has been admitted as Exhibit 82. At 3:17, we can see that the shooter asks his mom, "Where are you?"
Correct.
And I'm sorry, I have that one in my hand. Do you want me to trade with you?
I should be fine with this.
Okay.
Thank you.
I think council misspoke.
I'm sorry, Jennifer, I'm so sorry. Jennifer Crumbley asked the shooter, "Are you home now?" At 3:17.
Where are you? Yes. Is that what
I'm
you're-
sorry, where are you?
Yes.
Okay. And the shooter responded, it looks like 4 hours later, saying, "Can you get home now?" And then proceeded to send some other texts about, "There is someone else in the house, I think," and it goes on from there, correct?
Correct.
Now, in between the time of 3:17 and 7:50, okay, we can agree there's a couple hours of a gap.
That's correct.
You don't know if Jennifer Crumbley and the shooter had phone conversations or discussions over those couple of hours,
If we look at the call logs on their phones, we could possibly find that out.
okay? If we looked at the call logs and the phone calls were to and from cell phones, we would be able to tell that, correct?
Yes. Correct.
Okay, but if, let's say Jennifer Crumbley called from her office phone, it would not show up the same as if she called from her own cell phone.
Well, the number would be different, correct?
Okay, and when you and law enforcement went through looking for phone calls, there are not, you provided over several call records, but not call records for example, Jennifer Crumbley's office with Ethan Crumbley.
There are none entered as exhibits. I can't say for certain right now with all the information I looked at, if there were any, off the top of my head.
You don't know if there were any.
Right now, I don't know.
Okay. And you also don't know that day, on the 8th, you know that they're planning to be at the
He
barn.
doesn't know a lot
James
of
and Jennifer
things.
make plans to go to the barn that
Correct.
day after work,
Correct.
okay? Between the time they make these plans and the time the shooter texts, "Can you get home now?" You don't know if Jennifer Crumbley or James Crumbley has physically been with the shooter.
Right. No, I do not. From that chat thread right there, I do not know that.
You don't know the discussions on that day that may have taken place in between the shooter and his parents.
Right. From this, I can't tell you that. Is that what you're saying? I don't understand.
Right.
Correct.
Right, the best you can do is piece together bits of information, but we can agree there's gaps of time where you don't know definitively what happened.
Correct. Right now, yes.
We can agree there are any number of things that could have happened between 3:17 and 7:50 there would not be evidence to show you what exactly happened, correct?
If there is none there, you mean? Is that what you're saying?
Right.
Correct.
And the only people who would know if they can even remember the day years ago would be the people who were present. So Mrs. Crumbley and the shooter, correct?
Correct.
They would be the only people who truly know what they spoke about or didn't speak about on that day.
Correct.
So when you see these texts, and I understand you find them alarming, I imagine that the texts, and please correct me if I'm wrong, that you find alarming are the texts about there is someone in the house, I think, someone walked into the bathroom and flushed the toilet and left the light on. I thought it was you, but when I came in, no one was home. There is no one in the house, though. Those are some of the texts that you found to be problematic, correct?
In the fact that there's no response in between any of those, yes.
Okay. We can agree there's no response, but you don't know if, okay, we can agree there's no response by text between Mrs. Crumbley and the shooter, correct?
Correct.
But you also have no way to tell when you see text messages like this, at what time Mrs. Crumbley read those texts.
Correct. To be able to tell that it was read, but yes, not what time.
Okay, so for example, when the shooter texts, "Can you get home now?" And then there's someone in the house, I think, a few seconds later, and then about 30 seconds after that, another text. You have no idea if Jennifer Crumbley checked her phone to see the first text message, checked and saw the second. You don't know which one she saw.
I don't know if this is the
or
best
read, correct?
argument to make right here.
I don't know
but
the time they were read, no.
I'll let
you
it
know
run.
is that you don't see any response to them.
They're correct. There's no response.
So there's a number of possible things that could have happened in between these texts.
From 7:50 to the end of the last text,
Yeah,
she could have texted back, you mean, or called?
she could have, well, she didn't text back. We agree with that,
Correct.
right?
Yes.
Okay. When I say there's a number of things that could have happened, I mean, she could have read the text and thought this is garbage or he's joking and just set the phone down, correct?
She could have.
Okay. She could have not seen the texts because she was busy doing something.
Correct.
She could have been, we know she's at the horse ranch. Are you aware of how strong Jennifer Crumbley's cell signal is out at the farm, at the barn, where the horses are kept?
I have no idea about that. No, I do not.
Okay. If her cell signal doesn't work out where the barn is, it's possible these texts are not getting to her until she gets to a place where data uploads into the phone, correct?
That's correct.
So while we see these texts being sent, we cannot conclude that Jennifer Crumbley is reading these as they are coming to her. Fair to say?
That's the time that they were sent, the 7:50 and 14 seconds, and then 17 seconds and 39 seconds. That's when they were actually sent, and they were received on the other end, and that's marked at that time. Otherwise, it would have come in at a later time.
Okay, but my point is you don't know when she saw them, when Mrs. Crumbley actually read them.
No, but they would have been on the phone at that time.
If the phone had a signal and was able to get text, they'd be on the phone at that time, correct?
It would have been at a later time, at the time that they came in.
Okay, but if the signal wasn't working, she might not have been able to see those texts until she got to a point where the signal came in.
Correct.
Okay, there's times where you're in an area, people can be in an area with their cell phone and the signal is bad and texts are coming into them, but their phone shows nothing. That's a possibility, correct?
That's correct.
And then when the person gets to a spot with better cell phone signal, all of a sudden, all the texts they missed over whatever period of time the phone wasn't working will flood into the phone, correct?
That's correct.
And just because they come into the phone at that time, they were still sent possibly hours before.
Without testing, I can't say for certain.
You don't know.
I can't say for certain without testing, correct.
Okay, so the text messages that were sent about someone being in the house, someone walking into the bathroom, you don't know any of the responses that, or even the thoughts Jennifer Crumbley had when she did in fact read those messages.
I don't know if she would have called back if that was alarming to her. Is that what you're saying? Or
I guess what I'm saying is, so these messages are coming in, and even when she does see them, let's say if she sees them as they're coming in, you don't know what she's thinking about these.
I don't know what she's thinking, no.
Okay, and you also don't know, and obviously we've already talked about it, this has already been asked, but you obviously don't know when she's seen each message. There's no documentation like she saw this one at 8 o'clock, this one at 8:05, anything like that.
There was a time that they came into the phone, yes.
Okay. The next message we see is the text message on the following day sent to Ethan by Jennifer Crumbley that says, "Where is your dad?" Correct?
Can you just scroll down a little bit?
Yeah.
I just want to make sure I see
Yeah,
it.
no, sorry.
You know, I feel like maybe I should give the jury a break. You're not close, right?
I'm not even close.
I think the witness could probably be good.
Okay, all right, so, I'm gonna let you step down and can't discuss your testimony with anyone.
Okay.
Okay, so, all right, so, I'm gonna let you step down and can't discuss your testimony with anyone.
Okay.
Okay, so can we come back?
Sorry about that.
About 5 after 3, okay?
That's fine.
All right,
All right, to the jury.
So we're gonna take a potty break. I mean, we're no break. All gas, no brakes, guys. No union brakes here.
all right, so 5 after 3, okay?
Thank you.
So I'll give her credit. She came back hard and started with both barrels. I mean, she started putting it to him like, you don't know about this. You don't know about that. What do you really know? Oh, were there any threats? I couldn't find any threats. What about this right here? Did you find this? Yeah. What do those look like? Those look like pretty big freaking threats. Oh, I'm going to kill you and fuck you. And yes, this guy looks, she's doing a pretty good job now. She's hitting hard. And apparently it sounds like it gets even better. So here we go. This is a good cross. Put it to him. So.
The jury. May I continue? Okay, thank you.
Oh, wow. Okay. Wow. They came to play now because, I knew they were prepared, but like this right here, these are new. I think they're going to be like, what about this? Boo, 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 boo. Brrr, brrr, for this guy. So get ready. It's going to get good, it sounds like. Brrr.
All right, so we've been sitting here going over March 9th, 2021. There was also some messages from March 8th, so the day before that you testified about. Do you recall those messages?
I do.
Okay. Do you recall? Do you need to see those messages, or are you able to answer questions without?
I'd like to see it. Not yes, please.
Okay. So these are going to be. Let's see here. This is Exhibit 84. Okay, Exhibit 84. Can you see it up on your screen?
Yes, I can.
Okay, these are texts that are between James and Jennifer Crumbley, correct?
Correct.
Now, these texts are confirming that Jennifer is saying she's swamped at work and is going to have to not go to the barn that night, correct?
I'm sorry. Do you have a copy? Don't scroll into
I don't know what I did with my copy. Let me just. I'm sorry. Here it is. It's right
You're
here.
just scrolling too fast.
Here you go. Sorry.
No, it's fine.
This is 84.
Thank you.
Do you want me to take these or do you want to keep those?
Unless you're going to refer to them, I don't need them.
I'm not sure if I will. We'll find out. Okay. So on Exhibit 84, these are the texts from the day before. March 9th are the texts where Ethan is sending those things saying there's somebody slamming the door, things like that, right?
Correct.
Okay. These are from the day before on March 8th. Yes?
Correct.
And you testified about these texts from March 8th on direct, and those were admitted through the prosecution.
Correct.
Okay. On March 8th, the parents are talking about Ethan at the beginning of the text messages. Is that a fair statement?
At 3:09, Jennifer asks, is Ethan going bowling?
Okay, so on page 386, she starts off with, is Ethan going bowling? He says ITK, which is I don't know. We can agree on that. Okay. What do you mean? I don't know. Okay, goes down further. And Jennifer Crumbley on the 8th is asking at 3:12 in the afternoon, why isn't he home yet? Correct?
That's correct.
At 3:12 and 51 seconds, she says he should be home by now. Correct?
That's correct.
When she's saying he, we know that she's talking about Ethan. Correct?
Correct.
And then it goes on at 3:12 and 56 seconds. She says freaking out. correct?
Correct.
And James responds to her at 3:13, so not even a minute later. He doesn't get home until 3:16, correct?
Correct. That's what he says, yes.
So these parents are communicating about when their son gets home down to the minute of when he can be expected, yes?
Correct.
Jennifer's text back to him is, I told you to pick him up because he's upset and I don't want him to do anything stupid, God damn it, correct?
Correct.
That's Jennifer saying that to James.
Correct.
On this date in March of 2021, Jennifer is working at Princeton at her job that's out in West Bloomfield, correct?
Correct.
And as far as you know, James at that time is a DoorDash driver working out in the Oxford area.
Correct.
And at that time, James was in between jobs. And if you don't know, please tell me, in between jobs and door dashing on the side as he was waiting for another job to come along, correct?
I do recall a text message about trying to be an interviewer or something like that on between them, yes.
Okay, and in all fairness, if I ask you something you don't know, just let me know.
Absolutely.
Okay, I'm just trying to speed it up a little. Okay, so Jennifer's yelling at James, I don't want him to do anything stupid, goddammit. When she says that, it's fair to say you don't know what she means by I don't want him to do anything stupid, correct?
I have no idea, correct.
Okay, and James's response is, dude, chill, he is fine, and I'm trying to fucking work, correct?
Correct.
And Jennifer's texting back again, not even a minute later, does he have his phone? Yes?
Yes.
And James texts back right away, he won't answer while he's walking, I'll let you know the minute he walks in, correct?
Correct.
And Jennifer, within a minute of that, is sending another text. I'm serious, freaking out. Is he home yet? Those are the next two texts in succession, correct?
Correct.
It would appear from these text messages that Jennifer is voicing concern over Ethan.
In this one thread, yes.
Okay,
Correct.
and again, we're guessing if she's concerned about him, correct?
The language makes her like she's excited. I would say yes.
Okay, so the next day, when she's not responding to Ethan's text, again, we've gone over this ad nauseum. We don't know why she's not responding or what's going on in her head or if she's getting the messages, correct?
I don't know, yes.
You would agree with me in the text messages between Jennifer and James, and I'm sorry, they communicate way more by Facebook Messenger, correct?
Yes, they did.
Okay, and if I were to say that this is the printed out stack of Facebook messages between James and Jennifer, would that surprise you?
I don't, there were a lot of them. I can tell you that. I don't know what it would look like printed out yet. If you say that, I believe you.
Okay, approximately how many messages do you recall reviewing between them? Thousands?
Yes, thousands.
Okay, and in the messages, you read every one of these messages, correct?
Correct.
And when you were putting together information for the prosecution and for this investigation, you went through and found the evidence that's obviously brought into this trial.
I'm sorry, I don't understand.
The evidence that's been admitted, these texts are texts you found when you read the whole thing.
Correct.
Okay, and obviously, if there were texts between Jennifer and James that said something like, I think Ethan's psychotic, you would have brought that into this court, correct?
Just like the text we had where she said she was worried he was depressed, yes.
Okay, so, and I'm gonna get to the text about him being depressed later, but if you saw something in these text messages, like, I think our son is a serious threat, you would have brought that in here to show this jury.
I don't understand the question. I mean, this chat was brought in because for an unknown reason, she's very excited or doesn't want to do anything stupid. I don't know what he would do that's stupid.
Right, okay, so you don't know what he would do that's stupid. Aside from that though, my point is, we're not going to have this jury read all of the text and messages between James and Jennifer Crumbley, right?
Correct.
And in prepping for a trial, you bring in the ones that show the point you're trying to make, correct?
Correct.
So to do that, you read through all of them.
Correct.
And you pick out the ones that you think are important.
Correct.
And the ones that you've shown the jury are the most important ones you found.
Correct.
And we can agree that the balance of the messages, there's a lot more information that this jury is not going to see because it's not important to proving this case.
I'm sorry. What was give me the question again?
I'll ask a different question. It's fair to say throughout these texts, there are numerous conversations between James Crumbley and Jennifer Crumbley about their son.
Numerous?
Yes.
I wouldn't say numerous.
Okay, there's many conversations about, is he home yet from school?
There's some, yes.
Okay, there are conversations about him having to go to take headache medication.
I don't recall it. It might be that I recall headache medication. I remember him having a headache.
Okay, there are texts in here about what they're going to eat for dinner with their son.
Okay,
Do you agree?
correct, yes,
Okay, there's texts about all kinds of things that a mom and a dad would talk about that are not important in terms of proving this case, correct?
correct,
Okay, and the most important information you found are the papers that have been admitted through the prosecutor.
correct.
Okay, and in the rest of the text messages, my point is, if you saw something that was more serious, like I think Ethan's going to shoot people, you would have brought that into court.
Just like the one, yes, we
Okay,
would have.
so when we're looking at the
Yeah, I
evidence.
just need to object to the form of the question. She's characterizing that he brings it into court. He doesn't bring it into court.
He's the investigator, the prosecutor decides what they're asking to be admitted, so.
Right, she's insinuating that he's taking certain things out and not telling anybody else, and everything's been turned over. I mean, it's.
I'm
it's the same
not
argument.
insinuating that.
I'm starting to think it might be shorter to ask the jury to read that, right? Would that be shorter? Yeah.
Okay. My point and my question is, James and Jennifer discussed Ethan in other text messages.
Yes, they do.
And if there were text messages that showed evidence that either one of them believed Ethan was sick, mentally ill, anything along those lines, you would be pointing them out for this jury.
More than what we have, correct, yes.
Okay, what you have is the best evidence.
Now she's doing something that is good. That's all you got. He's like, okay, yes, this is actually all we have. A couple of slivers. And this is what David's pointing out, I guess. This is all they got. You know, oh, ladies and gentlemen, she's evil. This is all we got. This ain't, you want to fucking lock a woman up, but this is all you got? Mannheim Steamroller, come on.
You could find after going through all of them.
That, like was said, I turn over to the prosecution, yes.
Okay, and that's true too of the messages between Ethan and his friend, correct?
Not-
In terms of the evidence you brought in, is the most important evidence you thought that was relevant to this case, correct?
Not entirely,
Same
no.
objection. It's the witness doesn't bring in evidence when he thinks it's relevant. He's already testified. His job is to take the data, he extracts it from devices, and he passes along all the information.
The prosecutor decides.
Thank you.
Bullshit, you had him commenting on stuff already, so fuck that.
Decides what might be relevant and what might be innocent.
You already had him talking about
When you
stuff.
went through the cell phone reports, you read all of the messages between the shooter and his friend, the friend that the prosecution has not named, but the one friend that's been an issue in this trial, correct?
Correct,
You read through, there were over 25,000 messages exchanged between the shooter and his friend that came off of the phones.
correct.
If I told you that this was the amount of text messages all printed out, would you disagree with that?
I would not.
Okay. And when you went through and pulled out, we can agree that there's lots of different topics discussed among these text messages.
Correct,
And the text messages that were brought in and entered as evidence were from this large stack of text as a whole.
What was presented, I'm sorry,
They're in these,
yes,
they're from here.
yes, there was more information that was turned over, but
Right. Okay. So my point is though, the pieces, the materials that have been admitted and that you've been testifying about are a part of all of the messages between the shooter and his friend.
correct.
Judge, if counsel wants to continue with this, that's admissible. And she has asked it for
I
not to
think we
be.
need to be really careful, okay? See, this is the conversation we had when we were picking the jury, that we are not trying the case of the shooter. So we've all endeavored to give you the thing.
We're not trying to case the shooter, but guess what the state's doing? Showing you every damn thing the shooter did. Okay, so why isn't the friend being charged? Exactly. Why isn't this whole community? I indict this whole community, even you on this jury. You're all guilty. We should all be in jail. And maybe, I'd be like,
Things that are
maybe you could be like, hey, maybe our existence here, this hell that we live in every day, maybe this is our prison. We're all forced to live with the decisions Ethan made that we didn't stop. I get all philosophical about it, but yeah. Yeah, just go after the judge for this nonsense.
Important to this case that are not specific to the shooter's case. So, you know, I don't want the jury to think that they are not allowed to see something. All right. So I don't want the jury to think that either side is hiding something, because they're not. There have been evidentiary rulings made over the last year and a half in this case, and those are rulings that I've made after extensive research and briefing and all those different things with the prosecutor and defense counsel. So I don't want you to think anything's being hidden. That's not a fair, you know, characterization. So
Judge, I asked the court to instruct counsel that you can't request certain things and then make this line of questioning without opening the door.
well, I do not want to try the shooter's case. Okay, so let's not do that, right? Yeah, yes.
Thank you.
Okay, so we've talked about March 8th, and we've talked about text from March 9th, yes?
Correct, yes.
Okay, and then you also testified about text messages that were sent on March 17th. Do you recall that?
I recall the date, yes.
And the overall point of those messages, and please correct me if I'm wrong, is that on that date, the parents were at the barn together with their horses.
Those are the pictures, yeah. I don't remember if you have a copy of the text messages that were in that day.
I can show you them.
Can I make a request?
Yes.
Could you disassemble the Leaning Tower of Pisa?
Oh, sure.
Honestly, it looked like it was.
Yes.
Yeah, that's
on
funny.
that date, the parents were at the barn together with their
I love
horses.
that. That's so funny. I got to
Those are
rewind
the
that.
pictures, yeah. I don't remember if you have a copy of the text messages that were in that day.
I can show you them.
Can I make a request?
Yes.
Could you disassemble the Leaning Tower of Pisa?
Oh, sure.
Honestly, it looked like it was. I would hate.
To be fair, I would agree. That's just waiting to fall over, and if that falls over, holy Jesus, that's a mess waiting to happen. So yes, I would recommend that too.
You'd have to reconstruct that. It just looked like it was gonna fit, and then you'd have to try to re-put it together, and that would take. I'm hoping you're gonna be drinking a glass of wine in your sweatpants this weekend instead of reassembling that file. So
5 bottles.
I just, it looked like it was gonna tip. so.
Okay. No,
Oh,
thank
geez, you shouldn't say stuff like
Um,
that. Fuck. That's where the
all right.
bottle comment came from.
You talked about 3.8, you talked about 3.9, I'm going to 3.17. You asked me what text
Yes, it did.
messages I'm talking about.
That was very clever for her to go back and stack that all up, though. That was very clever of her to do. I'll give her credit. You know, I think it's good to go back to that point real quick. As she does
What you
that.
have is the best evidence you could find after going through all of them.
That, like Liz said, I turn over to the prosecution, yes.
Okay, and that's true too of the messages between Ethan and his friend, correct? In terms of the evidence you brought in, is the most important evidence you thought that was relevant to this case, correct?
Yes.
Not
Very
entirely,
good.
no.
Same objection is the witness doesn't bring in evidence when he thinks.
Reconstruct that.
Okay.
So that was very good. And you notice the comments are like, oh, she talked about drinking wine. Not like she fucking stomped a mud hole in this guy's ass.
Looked like it was gonna.
Drink a bottle.
So good job for her. Good job on her doing all that.
All right. We
How
talked
can she
about
lift that
3.8,
pile?
we
You
talked
guys
about
are
3.9.
ridiculous.
I'm going to 3.17.
No.
You asked me what text messages I'm talking about, and these are the exhibits that are around exhibits 83 through 86. Would you like me to bring you the text messages so that you can see those?
If you could, please, yes.
I think the March 17th starts with exhibit 85.
Okay, now
I'm not taking to a game.
on 85, we amended it, so there are texts that
I
were,
remember, yes, ma'am.
okay. And then I'm also gonna hand you right now what's on 86, okay?
Okay, thank you.
Okay. Now, the overall point of these text messages was to show that both of the parents were at the barn on March 17th, correct?
Correct.
Okay, and on that day, while they were at the barn on March 17th, the shooter was trying to get a hold of them. Is that correct?
That's correct.
Okay. And on that date, we have cell phone evidence that was admitted in Exhibit 83 that shows, and tell me if I need to slow down, I can break this down more. An hour after the shooter was texting Jennifer Crumbley, she called him and had a phone conversation within an hour, correct?
Correct,
And that phone conversation lasted less than a minute,
correct. I remember that.
and you have no idea what was said during that phone conversation.
No, I do not.
You have no idea what happened after Jennifer left the barn that day or James left the barn.
No, I do not.
You have no knowledge that the family, whether they were together that night or not, correct?
Correct,
You've done the best you can do to put together the information with materials you have.
correct.
Okay, so we've talked about March 17th. Now I want to talk about March 20th. I'm sorry, the 19th and the 20th. On March 19th, there were text messages that were introduced, and tell me if you need them, they're exhibits 95 through 100, where there's a discussion about Ethan waking up and seeming hungover. Do you recall those?
I do, yes.
Would you like me to give you those?
I just like having a copy in my hand or on
that's-
the screen either way. Thank you.
Yeah, absolutely. Okay, so here's exhibit, this is 95. And I'm gonna put 95 up on the screen. So now we're talking about March. Sean, can you please? Okay, all right, so we're looking at exhibit 95, okay, which has been submitted. And this is from March 18th, correct?
1995?
Okay, exhibit 95 is from March 18th.
It's-
You know, it goes over multiple days. Okay, may I please approach with 96 also?
Sure.
Okay, there's two that are in order and they both contain multiple days, correct?
Correct.
Okay, so I'm sorry, this is a little bit confusing because we've got two different dates on two different exhibits. Okay, so I'm gonna go to 96 first. These texts actually come before 95. On this date, these are the texts where Ethan says, I just finished picking up the room. I cleaned until shelves or clothes started flying off the shelf. This stuff only happens when I'm home alone, correct?
Correct.
Okay, and I am totally off. I am so sorry. March 17th. I need to be on exhibit 85.
85 is, it says is the thread from March 17th, 2020.
Yes, and 85 is one that I cannot display because it's been redacted. So I'm asking if the prosecution can please put 85 up on the screen.
Can you put rejected 85 on the screen?
I kind of just need a minute, but
Okay, so on 85, this is on March 17th. This is the text where it started off, gonna get drunk and ride my horse. Jennifer Crumbley sent that at 1:30 PM.
Correct.
Okay, and I'm sorry, Mr. Keys, can you please scroll down? Okay, Jennifer Crumbley's indicating that afternoon, I hate my job. Can you bring out last, please? And I don't know what that means. You don't know what that means. Would you agree with that?
I don't know what she's referring to.
I don't either. Okay, can you go down, please?
Well,
Okay,
that
Jennifer
helps.
Crumbley indicates at 4:02 that she's left work, yes?
Correct.
I'm sorry, I might be going too fast.
Nope, you're good.
Okay, and then if we can go down more, please. That jumped exhibits.
That's the end.
Oh, I'm sorry, so 85, can you go to the end of 85? Because it jumped to 86. Okay, so on 402, at 4:02, Jennifer Crumbley said she left work.
Correct.
Okay, and the important thing about the 17th is showing that on that date, she was at the bar.
Correct.
And the next day is on the 18th, when we have the text messages about, I'm sorry, March 19th, exhibit 95. Do you have 95 in your hand?
I do not.
It would be easier probably just to make the whole thing go page numbers, but I'm obviously, we're not gonna do that. I'm just having a difficult time with these pages. Do you have exhibit 95?
I do not. I have 96.
Okay. I am so sorry, but this is a mess. Okay. On March 19th, I've got it up on the screen. This is when Jennifer Crumbley and James Crumbley are talking about Ethan acting
And
like
I don't
or seeming
disagree.
like he was way hungover
I don't disagree,
that day,
Jen.
correct?
Correct.
And it appears from the text that Jennifer is asking if he's okay. She says, "How is he?"
Correct.
Okay. Why is this doing this now? I am gonna kill myself. Okay. Okay. So he woke up acting like he had way too much to drink last night, complaining about a headache. That's what James said back to Jennifer, correct?
Correct.
And, okay, Your Honor, I need like a minute, and I'm so sorry. Now I've got exhibits that are doubles on the page, and I'm having a really tough time with these exhibits. I apologize to the jury. Can I please have a minute?
Okay, well, I'm trying to excuse them because.
Can you help me get this
Are you
done?
able to do it while we're here?
Yeah, I'm trying to just
The
get it
next time I
done.
excuse on this, I'm at home. I was hoping to finish this with this. I have this yes completion thing. So, I like to-
You know what, we can just leave it at 2 pages on the screen. So right now it's got on 440, page 441 is on the left, 442 is on the right. Okay, so starting with 441, this is where the text says, well, he was really worked up and out of control, so I can see why. This is after they're talking about him waking up, correct?
Correct.
And Jennifer Crumbley texts, all I know is he needs to eat, go to work hard, not complain, and he can get his stuff back, correct?
Correct.
And James ends up saying that Ethan asked, why was I in your room last night?
Correct.
And Jennifer ultimately says she gave him a melatonin pill or melatonin tablet.
Correct.
And James says to her, I thought you gave him a Xanax last night.
Correct.
And it's evident from this that Ethan, or the shooter, their son slept in their bed that night.
Correct.
And it appears that on March 19th, as the parents are talking, there was some kind of argument where something happened with their son the night before.
Correct.
And we don't know anything about what happened the night before on March 18th that preceded this whole conversation.
Correct.
It appears from the conversation on the 19th that something was taken away from him because it implies he can get his stuff back.
There's objection in the form of the question. He can't testify what it implies or what it appears when it's on the phone.
I'm sorry, I'll restate that. The text explicitly says if he does these things, he can get his stuff back.
Correct.
Okay. All right, now I'm going to skip ahead to the 20th of March in 2021. On the 20th, we admitted exhibits 97 through 100.
The 96 are text messages dated March 20th. And the 97 starts with something.
Okay, so 96 are the text messages that are up on the screen. Do you see those?
Yes, I do. I have
Okay,
them.
and it's on the 20th that the shooter is saying things like, I cleaned up and clothes started flying off the shelf. He's making other claims that something is happening that's not normal, correct?
I would say yes.
Okay, he's making claims that things happen when he's home alone and trying to make his mother think things are flying off the shelf.
That's what he said, yes.
Okay, and you don't see any response from Jennifer Crumbley that day.
Correct.
And you showed the jury, we introduced and admitted all of the exhibits to show on that day she was at the barn again, correct?
Correct.
Now, you don't know what they talked about before or after she got home from the barn.
Correct.
All we know are that we have these couple of text messages making it sound like something is flying around in the house from
Yeah,
her
Judge,
side.
I don't know how often I can say this. Objection in the form of the question. He can testify to what he found on the device.
Yeah, he doesn't know beyond that, right?
Okay, I
He
apologize.
wasn't there.
Okay.
Yeah,
And
but he's
so-
testified about a
so
lot.
on
Oh,
The
this
20th,
is,
Mrs.
but he's
Crumbley,
testified about a ton of fucking things. Oh, he looked all brave and proud. How the fuck can he testify to that? I'd bring it up. The state allowed him to testify to a lot of things. She should have. Court might say, well, you didn't object, but the court might say fair game.
is obviously at the bar. So we've talked now about March 8th, March 9th, the 17th, 19th, and 20th, correct?
Correct.
So we can agree that from the 8th through the 20th, we're talking about a period in time that's about 12 days long.
Correct.
And we've seen bits of the 8th, the 9th, 17th, 19th, and 20th.
Correct.
Okay. In April 4th are the dates of the texts between the shooter and his friend, correct?
I would, there was a lot of text messages. I believe they texted on that date.
Okay. And I believe it is Exhibit 101. Okay. I have 101 on the screen. Do you recall these?
Correct. Yes, I do.
Okay. Now, these texts on April 4th are between, we agree that they are between the shooter and his friend.
That's correct.
This is not a group chat where Mrs. Crumbley is on it.
That's correct.
There is no evidence that these texts were ever forwarded to Jennifer Crumbley.
Correct.
There is no evidence to show that Jennifer Crumbley ever saw these text messages.
Correct.
For example, there isn't a text like, oh my gosh, you should see what our son sent to his friend today. There's nothing along those lines, correct?
Well, not in this group. Are you talking about this chat still?
I'm just saying in general, if you found evidence that Jennifer Crumbley saw these texts, that would be important.
If she saw it, I would say yes.
Okay, and we don't have anything to show she saw them.
Not that was on the phone, no.
So on this text thread between the shooter and his friend, he talks about how he hears people talking and he sees someone in the distance, correct?
That's correct.
There's no response from his friend.
Correct.
We don't know if his friend saw those texts and didn't respond, or if his friend didn't see those texts and the shooter just kept texting, right?
They came in rapid order, so yeah, they were one after another, correct?
Okay, so this is around, so 11:56, and then we go down 11:57, says, it's at the point that I'm asking to go to the doctor, okay? That's one of the texts that you testified about, correct?
Correct.
There are not any texts where the shooter is saying anything to his mom and dad about, I want to go to the doctor.
Correct.
While the shooter is saying this to his friend, we don't have any evidence that it's true, whether the shooter really wanted to go to a doctor or not, correct?
I mean, you said it a couple times. They talked about everything.
And all the times that he talked about it, this jury has seen, you've brought that in. Well, you haven't brought that in, I'm sorry, I keep misstating that. The evidence in this case is showing the jury what you gleaned from your investigation.
I don't understand. I'm sorry.
Okay. In the investigation, you don't have any text messages where the shooter is saying to his mother anything about going to the doctor for hallucinations or anything along those lines.
That's correct.
Okay, if that did exist, the jury would be seeing that.
That would have been turned over to the prosecution, yes.
Okay, so in this case, when the shooter says, it's at the point I'm asking to go to the doctor, my mom laughed when I told her, again, you have no idea if Mrs. Crumbley ever saw these texts between the shooter and his friend.
Correct.
And we can agree, we don't have any more context than just this text thread that exists between these two.
Judge, again, counsel is getting very close to running afoul of the motion that she filed to preclude evidence. Judge, there is a lot of context, but counsel
Your
requests
Honor, this
motions.
is making it sound like there's evidence being hidden, and there's not.
Okay, well, I've said there's no evidence being hidden. There's no evidence being hidden. But, okay, so ask the next question.
Okay.
You're not aware of any communication between the shooter and his mother?
No.
Yes.
Correct.
He's
Okay.
another
And when
attorney.
the shooter texts his
It's
friend,
co-counsel.
I was thinking of calling 911 so I could go to the hospital and text, I need help. There are no 911 calls, correct?
Correct.
there are no text messages to Mr. or Mrs. Crumbley saying those same types of things.
Correct.
And when he says, I am going to ask my parents to go to the doctor tomorrow or Tuesday again, we obviously don't know if that's true.
Correct.
And when he says, but this time I'm going to tell them about the voices, okay, that's the next text, right?
Correct. Yes.
Okay. In his words, he did not send that information to his mom and dad as far as you can see from his messages with them.
Correct.
So when we're talking about this whole text thread, where at the end he says, like, I am mentally and physically dying, you also don't have any evidence that the friend who received these showed them to the shooter's mom, correct?
Correct.
There's no evidence that his friend did anything with these text messages beyond the fact that they exist.
Correct.
We don't know if...
Judge, we just need to clarify, there's thousands and thousands of text messages. She needs to be more specific. Is she asking to comment on the 20,000 page text thread? Is she asking to comment on certain days? It isn't fair to the witness who reviewed all this information.
Okay, well, is there any
Well,
evidence-
that's the problem. He reviewed all the information.
Not that I know of.
Okay, thank you. Okay. Now, on April 29th, okay, so we've talked now about April 4th and 5th, the text between the shooter and his friend. Okay, we just finished that, correct?
Correct.
Okay, now I want to go to April 29th, and this is exhibit number 104. You testified about a text thread that went between Jennifer Crumbley and the shooter's friend's mother, correct?
Yes, ma'am.
Now, in this text thread, the moms are, you would agree with me, talking about the difficulties of online school and how it's wreaked havoc essentially on their kids.
Correct.
Okay, and they start off by talking because Jennifer is telling the friend's mother that Ethan is not going to bowling, correct?
Correct.
And she says he's been acting kind of depressed. I don't know what's going on, correct?
Correct.
And she says, I'm not sure if there's something bothering him at school. He doesn't really feel good. I can't get anything out of him, correct?
Correct.
She doesn't say anything in here like he's seeing things, he's hallucinating, I'm noticing that he's paranoid, correct?
Correct.
She uses the word, he appears to be somewhat depressed. Depressed is the word she uses.
Correct.
In terms of the word depressed, that could have meanings.
Objection, speculation.
He's not going to explain what being depressed means.
Well, that was actually my exact question, was just, you can't explain what it means. That was my question.
It means different things to different people, different professions.
You answered my question. That was my question. Thank you. Okay. I'm sorry, may I continue?
Yes.
Okay. So then they're talking about how the shooter and his friend are happy when they're together, and Mrs. Crumbley was concerned, based on these text messages, that there had been something going on between the shooter and his friend, but it's clear that's not an issue, correct?
Correct.
So these text messages, Mrs. Crumbley is, you would agree with me that overall, she is indicating an interest in figuring out what's wrong with her son,
She's pointing out things that she's aware of.
okay? And this text thread, there are more texts between Jennifer Crumbley and the friend's mother, correct?
Correct.
And there's one other set that we're going to talk about, but this evidence about, there's not any further explanation of what the word depressed means in the messages or not, correct?
Correct.
All we have is what's in these text messages. I'm sorry, scratch that. Okay, so this is on 4/29. We can agree that obviously on that date, Mrs. Crumbley made representations using the word depressed.
Correct.
The next set of text messages with the shooter's friend's mother were admitted as Exhibit 105. And we can agree these are months and months later in October of 2021, correct?
That's correct.
So this jury is seeing texts from April 29th and then October 31st.
That's correct.
On October 31st, there was discussion between Jennifer and the shooter's friend's mother about the decision they had to make to send the friend away, correct?
There wasn't discussion. She didn't reply back to the 4th of November, but Jennifer texted her or sent a message to her.
Okay, send a message to her asking how they're doing, saying you're thinking about them.
Correct.
Okay, and the friend's mom writes back talking about how hard it is. I appreciate you checking on our family, those kind of things, correct?
Correct.
And in these texts, Jennifer mentions, I know Ethan misses him, meaning his friend, correct?
Correct.
And she's asking just how things are going for the friend who's away.
Correct.
Okay. Now, at the end of these text messages, there's a few texts from December of 2021, correct?
Correct.
Now, those text messages are not about anything related to the shooter being sad or depressed, correct? Those text messages are after the shooting has taken place, correct?
Correct.
And those text messages, there's not many. We're only talking about a couple. The friend's mother asks if Ethan is safe on November 30th, correct?
Correct.
So on the day of the shooting, when the friend's mother asks at 3:47, is Ethan home safe? It would be fair, and if you don't know the answer, you can tell me, it would be fair to assume she's asking, is he safe from the shooting?
He can't answer that question, and these are Facebook messages, not text.
Yeah, he doesn't know.
Okay. So Jennifer Crumbley says, I'm sure you've seen the news, and ultimately says, I'm sick to my stomach, correct?
Correct.
And she mentions to the friend's mother that they're getting threats all over social media, which is something we talked about earlier, correct?
Correct.
And she also says that they're staying in a hotel because the news is camped out at their house.
Correct.
Yes?
Yes.
During your testimony, you admitted some GPS location information.
Yes.
And if you need to see the exhibits, let me know, but I think these will be simple questions. When you provided the jury evidence that James was at the gun store on the 26th, we can agree Jennifer was not at the store when the gun was purchased, correct?
Correct.
And when
The
that
gun
day, there was a
show.
video on the 26th that the shooter made of him holding the gun. It's a short video that was admitted as Exhibit 417. Do you recall that little video?
Yes, I do.
And in that little video, we can't see who else is around while the shooter is filming himself with holding the Sig Sauer gun.
In the video, correct.
And we don't know, obviously, who was present in the home or in the room even with him.
Correct.
That was the day the gun was bought.
Correct.
And the shooter took that video himself, as far as we can tell.
It was on his phone, yes. It was on his phone.
And he, and it was a video that he sent I'm sorry, let me back up. There were also photographs taken that day of the gun,
Correct.
the day they purchased it.
Correct.
Jennifer Crumbley actually posted a photo that was taken of the gun.
After they went to the gun range?
No, the day before, on Friday, the day the gun was bought. And if you don't recall, you can just, I believe it came in through the witness before you, and so if you don't know, you can just let me know.
I don't know.
Okay, thank you. So the gun was purchased on the 26th, and the next day is Saturday, the 27th, correct?
Correct.
On the 27th, we know that James Crumbley was door dashing that day.
Correct.
That's the day that the shooter and his mother went to the gun range.
Correct.
That is the day where there was posts about a mother-son experience at the range, in terms of shooting the gun, going to shoot the gun.
I remember those, yes.
Okay, now, there is not any information about where the gun was stored or placed in the Crumbley's home overnight between the 26th and the 27th.
Judge, I'm going to object. These exhibits weren't introduced to this witness. It's inappropriate to ask this witness those questions. Agent Brandon testified yesterday, the same questions that she asked him at cross-examination. He doesn't have the foundation to give that sort of testimony.
Well, I guess I don't understand the question. Are you asking, is there any communication on a text or Facebook or picture about whether the guns were stored, where they were stored, or whether they were?
Yeah.
Okay, so did you?
On the phones, no, I did not find.
Also, in the very minimum, he should be given the opportunity to review the exhibit before he's asked that.
I don't know if she specifically asked him about it.
She was asking about Instagram posting.
Oh,
He answered the question and said he didn't need a review, so it's
storage
that's
or
not a problem.
locked up or anything like that.
Not that I saw, no, ma'am.
Okay,
You don't see
so,
any locked guns on Instagram.
Locked guns, no.
and the evidence that you showed us from the 27th, there's not any information about who put the gun in the vehicle that drove the gun to the target, to the shooting range, correct?
I don't know anything about that.
We don't know anything about who did anything aside from the fact that we know when Mrs. Crumbley and her son went over to the shooting range.
I don't know anything about the transportation of the gun, no.
Okay, we know when they got to the range that Mrs. Crumbley and her son went in and they shot some targets, correct?
Correct.
We,
Well, the ATF guy testified to that. Do you know that?
What,
Video?
I do know the video, yes.
Oh,
The
okay.
gun range video?
Alright.
I have seen it.
okay, and in terms of the text messages and all the evidence that you have reviewed, from the night of the 27th to the 28th, there are not any text messages or Facebook messages about where the gun was that night, where it was in the home, where it was in general, correct?
Correct, I don't know anything
Okay.
about that.
In these same days that Mr. Crumbley bought the gun and mom and the shooter went to the shooting range, from the evidence that you've talked about in front of the jury, it's clear one of their horses has some kind of an issue, a health issue going on, correct?
Correct.
So as the evidence is unfolding about what's happening on those days in terms of what the parents were doing, there's also talk about medication for the horse and things along those lines.
Correct.
When you testified about the search on Mrs. Crumbley's phone about clinical depression, you don't know anything other than what was typed in when she searched for information about clinical depression, correct?
Correct.
You don't know if that was her looking up information for herself.
Correct.
You don't know if that's looking for information about the shooter,
Correct.
or if it's looking up information about some other person.
That's right.
On the 29th, that was a Monday. Does that sound right?
Yes, ma'am.
Of November.
And yes.
I'm sorry, of November.
Yes.
Okay. And that was the day that the voicemail was left that was played as evidence as Exhibit 115 from Ms. Fine. Do you know what voicemail I'm talking about?
Yes, I recall it.
Okay. So going a little bit backwards, that day, on that Monday, the voicemail indicates that Ethan was caught looking at bullets on his phone, correct?
That's correct.
The voicemail, we saw lots of evidence, was left on Jennifer's cell phone.
Correct.
We know Jennifer Crumbley listened to the voicemail.
That's correct.
We all heard the voicemail.
Correct.
And the voicemail did not ask Jennifer Crumbley to call back, to return the phone call, correct?
I don't believe so.
That message indicated that Ethan was not in any trouble, but the teacher or Ms. Fine wanted to make Mrs. Crumbley aware that
Judge,
they
the
had a
exhibit
discussion.
speaks for itself. He can't interpret the exhibit.
Yeah, that's the best evidence of what was said, right?
Okay,
You can have all the exhibits, so you can listen to them now.
the conversation,
We'll listen to it again and bring it back.
in that conversation, there is talk about I can play the exhibit. I'm just gonna ask about one quote, and if I need to play the exhibit, then I'll play it.
Okay, let's hear the question.
At the end of the voicemail, Ms. Fine says that it's perfectly normal and healthy.
I can't remember what she was referring to when she said that, but I do remember those words.
Okay. The tone of that conversation was not one that, well, I'm sorry. The content of that conversation did not ask Mrs. Crumbley to come over to the school or anything along those lines, correct?
Correct.
And then
Yeah.
we did see evidence that you testified about showing that Mrs. Crumbley asked her son about that voicemail, correct?
Correct.
And her text to him was evidence we saw as Exhibit 117, where she writes to her son, seriously, bullets, correct?
Correct.
And we saw the exchange in Exhibit 117. The shooter writes back to her, I'm in no trouble.
Correct.
Judge, counsel has to show the witness the exhibits
I can do that, I'm sorry.
in the entire exhibit.
Okay, we'll do the whole thing. All right, so this is Exhibit 117. And as I asked, and I think you already answered, it starts off seriously, looking up bullets in school.
Correct.
And the Jennifer's son responds, I already went to the office for that. He admits he was. We can agree that's the content of this conversation, correct?
Was that he went to the office for that? That's the last thing you said.
He says that I already went to the office for that.
Yes, correct.
Okay, so I'm moving down and he's explaining, or at least texting, what he was looking up and saying it's because he was curious.
Correct.
In his words, on page 199, he says completely harmless.
Correct.
And based on the voicemail that we heard from Ms. Fine, it sounded like,
Objection sounded like,
okay, I apologize. I'll move on. Jennifer told her son, the school left me a voicemail, correct?
Correct.
And asked her son, did you show them your new gun?
Correct.
And obviously he says, no, he did not, and says, I did not show them the pic, my God.
Correct.
Okay. Again, says it was a harmless act,
Correct.
gives more explanation to her,
Correct.
and ultimately, at the end of the conversation, he asks if he can hear the voicemail later, and she says she saved it.
Correct.
Guys, James has not gone to trial yet. He's the second in line. He goes to trial after this.
After that, there's conversation that was admitted in Exhibit 118. I've put it on the screen.
Judge, if counsel's just going to read exhibits, it's not a cross-examination. And I want to get to my redirect. I want to finish this witness today.
Finish the sentence.
Your Honor, I find that when I'm asking questions, if I don't go step by step, I have to go backwards and go step by
You
step by
have to
step
follow
by
rules of
step.
evidence. You can't ask the witness to guess.
Yeah,
There are some
we're-
questions that could just simply be answered, and they're not being answered. So I have to go step by step by step when it's not happening.
Let's do it. Well, yeah, but they're sort of hearing the same. things in direct, so.
The evidence that was admitted as Exhibit 118 shows there was a conversation between James and Jennifer Crumbley about the issue with the bullets at school.
Correct.
We went through the timeline from November 30th, 2021 in great detail earlier. You would agree with that?
Correct.
And obviously, you've collected all of the information you could from the 30th off the cell phones of James Crumbley, Jennifer Crumbley, and the shooter to look at in your investigation.
Correct.
It's fair to say that you did not seek a search warrant for people at the school who dealt with the shooter that day.
Hold on. To clarify the form of the question, seek a search warrant for the people at the school. That's not even an investigative method.
Okay,
The search warrant for who?
For the people, right, exactly.
all right, sorry, I'll back up.
And for what?
Okay, you're aware that Jennifer and James Crumbley went to the school. We saw the video of them walking in for the appointment, correct?
Correct.
You're aware they met with Sean Hopkins.
Correct.
You're aware there was conversation in a meeting.
Correct.
You did not at any time seek the messages off of the devices of Mr. Hopkins, correct?
That's not for me to decide. That's the officer in charge of the case to decide what to collect and bring to me to get data for them.
Okay, so that's not something you did. That's my only question.
It's not something that we would do in computer crimes, correct?
Now, when the text was sent at 9:31, the first thing that Mrs. Crumbley, that we can tell she received that morning that was of alarm was the altered math sheet that the shooter had written on, correct?
Can you pull it up real quick just so I can just?
Sure. So that was exhibit 123.
Correct, okay.
Okay, so exhibit 123, now, when we say altered math sheet, the shooter initially wrote things on a math paper that was introduced as a different exhibit. It was introduced as exhibit 74. And I'll open that up. So I've got exhibit 74 on the right, and we can agree that was initially what the shooter wrote on his math paper.
Correct.
And after writing all the writings on exhibit 74, he added to the math paper and added the things that we see on exhibit 123.
Correct.
Now, the first thing that Mrs. Crumbley receives is exhibit 123, which is the altered drawing, correct?
Correct.
And in terms of what's on the drawing, it speaks for itself, but it has things like, I love my life so much, harmless act, we're all friends here. It has a bunch of writings like that on there. The jury can see what's on there. It speaks for itself, fair to say?
It does, yes.
Okay. And when Mrs. Crumbley got that, we know that she immediately, because we have the timestamps, sent Mr. Crumbley.
God, look at that. So there were two of them. You know, so like there was some screwing around with this. Like, look at all this crap. So what the heck?
A message to let him know that something was going on.
Correct.
And in the text messages or Facebook messages, which were admitted as exhibit 125, and I'll put it up. It specifically, Mrs. Crumbley specifically sent photos over to, I'm sorry, scratch that. Jennifer's first message at 9:33 says call now being in capital letters, correct?
Correct.
And emergency.
Correct.
And her next text right after says emergency again.
Correct.
And then we know that Mr. Crumbley texts back.
Correct.
And that's in a separate, it's further down in the thread. And his response is, my God, WTF, which stands for what the fuck, correct?
Correct.
So the parents, we can agree that as soon as the math paper is received by Jennifer Crumbley, there's conversation between the parents.
Correct.
In addition to the messages, there's also phone conversation.
Correct.
And at 10:04, we know that Jennifer Crumbley is heading to the school, physically going to the school, correct?
Correct.
And At 10:05, we can see she's sending text saying, "I'm very concerned."
Correct.
We know, obviously, they get to the school and have a meeting with the counselor.
Correct.
And we know that that meeting only lasted 12 minutes long. That was your testimony.
Correct.
We don't have any kind of record or recording of that meeting in the counselor's office.
Not that I've made aware of, no. Correct.
After leaving the counselor's office, we have the text messages that Jennifer Crumbley sent Kira Pennick.
Correct.
Okay, we have text messages that Jennifer Crumbley sent Andy Smith, which were introduced and admitted.
Correct.
And it's fair to say that Jennifer Crumbley is telling at least those people about what's going on with her son, or that she's dealing with something.
Correct.
Now, we know Jennifer Crumbley goes back to work. We saw the exhibit showing her re-entering back at her office.
Correct.
Okay, and we know that at some point, there's obviously a notice out that was admitted. The Oxford High School has there's an alarm of an active shooter, correct?
Yes, correct.
Upon hearing that, we saw all of the evidence about Mr. and Mrs. Crumbley heading back to the school, correct?
Correct.
And all of that evidence speaks for itself in terms of the timeline of events that happened. And you went through those times on the record already, so we don't need to do that again.
Correct.
In those messages, there was not anything from Jennifer Crumbley saying, anything along the lines of, "I think Ethan might shoot people today."
It's actually the form of the question, anything along the lines.
Okay, I'll rephrase. Jennifer Crumbley, the text messages that we have are the extent of the text messages. You've provided everything from November 30th. Everything we've gone through, there's not more text messages that this jury's not seen. Is that a fair statement? On November 30th.
On November 30th.
Correct.
Okay,
That's still
And-
not a good thing to argue.
we can see the messages that Jennifer
She's
sent
not arguing
over
that right. There's a
to her
better way to
son at the
ask that.
time. You introduced those when you testified.
Correct.
And there's various exchanges, obviously between them that speak for themselves, and the jury can read those,
There were changes, yes.
okay? And there is a message that says, ultimately from Mrs. Crumbley, and if you need to see it, you can let me know, "Ethan, don't do it."
After he was in custody, yes. She said that message was sent.
And at the time that message was sent, we don't know what Jennifer Crumbley knew in her head.
Correct.
All we can do is look at the evidence and read what's before us and what's been admitted in the testimony.
The text messages?
Yes.
Correct.
I see where she's going with this. It's not a bad idea.
You testified about alarm images in exhibits 149 and 150. Do you recall that?
I do, yes.
Okay, so I'm gonna just put up 149 and 150. Okay, and I just want to make sure I understand this correctly. This was an alarm plaque on the track phone. Is that right?
Correct.
So this is an alarm plaque set for 6:30 in the morning and 6:45 in the morning that would have been for Saturday, December 4th.
Correct.
Is that accurate?
Yes.
Okay, so these alarms, from what you can tell, were set on the day before, on the 3rd.
Correct.
then again, there was some testimony, and I believe we've mostly covered this. Ultimately, when you looked at the cell phone between Jennifer Crumbley and Kira Pennick, you testified, I believe, that there were 26 messages still on the phone.
Correct.
And from the data, you could see there was actually 4,047 that existed at one time between them.
Correct.
So obviously, many messages had been deleted between Kira and Jennifer Crumbley by Jennifer Crumbley on her phone.
That's correct.
And again, there's not any texts or anything that have explanations about deleting things. All we know is that they were deleted.
Correct.
Scary. I don't know
May I
if I
have one
like
moment,
this.
please?
I'd be careful about going down this road. Say, do people routinely delete messages? Yes. Do some apps delete on their own after a while?
So
Yes.
there's also, I just have one point of clarification and then I'm done, promise. There are some messages that say that they are unsent. What's the difference between unsent or deleted?
Deleted would tell me that it's just not there anymore. You would delete the message that says it was unsent even.
Okay, so the unsent messages, it's possible for someone to send a message to someone else, but before it's received to unsend it and recall it back. Is that a fair statement?
I believe also if it was received, that you can unsend it, you can pull it back, yes.
Okay, and throughout some of the evidence we've seen, it appears that messages were unsent at times.
Correct.
I have nothing further.
Tell me how long you need to redraft.
I'll finish today.
Okay.
Just give me a few minutes.
All right.
Okay. Now, let's talk first about the deleted messages on the message between Jennifer and Brian Malone. So when you looked at the return, it didn't just say unsent, it had the red X insignia next to it. What does that signify to you?
That it is deleted.
Okay, so clearly Jennifer probably knew how to delete those messages.
Correct.
Okay, and in fact, she deleted ones that said, we're on the run again,
That's correct.
and we're fucked.
Correct.
Okay, and I want to talk to you just really quickly about this word right here. It was a harmless act. Does that signify anything to you?
Yes, it does.
How so?
It was also written on the modified math paperwork.
Harmless act, right there. Okay, that's exhibit 123. And Jennifer was sent that,
Correct.
and she was sent that on November the 30th before the shooting.
That's correct.
She was also sent this, People 74. And People 74, the shooter wrote, help me.
Correct.
She was sent that, and she saw that.
Yes, sir.
Okay, and then she communicated about that with her husband.
Correct.
Okay. Now, you were asked lots and lots and lots of questions about, is there any evidence of, did you find any evidence of certain topics? So specifically with deleted content, you can't tell if there's something that was deleted but unable to be recovered by search warrant.
That's correct.
And we've already established that Jennifer Crumbley knew how to delete. In fact, she did delete certain messages.
Correct.
All right. And one message in particular she deleted from to Kira Pennick was that picture of this drawing.
Correct.
Okay. And speaking of that exhibit between Jennifer Crumbley and Kira Pennick, that's People's 130. In those exhibits, they're in front of you if you want to look at them. There's about 28 pictures. They're screenshots. So there are many communications regarding her horses.
Yes, sir.
Okay. So one of the first things she does after the meeting is say, I can't, or after the shooting rather, is I won't be able to make it there tonight. Is that correct?
I believe that's correct. I can look up.
Take a look.
Yes, because she's gonna take care of her kid, who's got a fucking mental health issue.
And tell us the time that came into. You want? I'll pull it up for you.
Yeah, I don't see it real quick.
That's all right. I'll pull it up for you. 2:36 p.m. Kira, I won't be there tonight. Okay, it's on the screen.
Okay.
That's part of exhibit 130. And that is, the shooting ended at 1 p.m. So that's an hour and 36 minutes after he was taken into custody.
Correct. I see it now. Yes.
That's 6 minutes after she arrived home from the substation, after she was brought there.
Correct.
And that's the last time she saw her son.
Correct.
6 minutes after. Okay. So you were asked about a lot of questions about this Facebook chat here, including a particular message where Jennifer says, "I wish there had been some kind of warnings."
Correct.
Okay.
Remember that?
But she sent this to Kira, and this is the picture where he said, "Help me," with a picture of, or he wrote, "Help me," with a picture of the firearm.
Correct.
Okay. And she deleted that though. She later on deleted that particular text that she sent to Kira.
Correct.
Now you were asked a lot of questions about this big stack of these messages between James and Jennifer Crumbley. Do you remember those questions?
Yeah,
John?
that's
Yes, sir.
Okay.
try to
And,
downplay that. Yeah.
You were asked if there were certain messages about any messages that Jennifer had about my son's going to shoot the school, things like that.
I remember that. Yes.
Okay. You have had a chance to review some of those messages, or all of those messages.
Yes.
Okay. And was there anything in the messages indicating they were going to take him to see a therapist?
No, there was not.
Anything in there indicating they were worried and they want to take him to see a psychiatrist?
No, there was not.
Was there any time they tried to set up any mental health counseling?
No.
In the phone logs or text messages from the period after the school meeting to the shooting, were there any indications that they researched any mental health professionals?
No, there was not.
Did they call any counseling offices?
No, they were. No,
Did
they
they
did not.
call any psychiatrists?
No.
I'd like you just referring
Well,
to that
Ethan
message
said he
and
saw
have
a
it for the
doctor,
record
so did
again,
that
I'd like to
happen or
omit the
not?
entire thread, that's Exhibit 423. That's the entire Facebook thread between James and Jennifer Crumbley. I'd like to have that available for the jury if they want to look at that.
Your Honor, I would have no objection to that as long as we redact the things that this court's already deemed inadmissible. That would be fine.
Okay, I don't recall specifically what those are, but if there's already been a ruling and things have been rejected, then I would like those taken out.
Certainly.
Okay.
Certainly. Sir, if you could, referring to what would be Exhibit 423, contrast for the jury, please, the amount of time and messages between James and Jennifer Crumbley regarding their horses with their messages regarding their son.
Your Honor, I would object. There needs to be a foundation that he can
Contrast.
determine this or has data to support this.
Did you look at the messages?
I look at the messages. Yes.
Okay. Are you able to contrast the amount of time and messages between James and Jennifer Crumbley regarding their horses versus
Your
their
Honor, I would
son?
object. This is misleading and speculative, and
It's-
there's been lots of talk about things that have been deleted, that we don't have all the messages. So I would object, Your Honor.
Judge, for the record, the point is that counsel asked, is there any evidence of when
Okay.
this witness has already testified, so things are deleted, and he's going to testify what's actually on thread.
Okay, I'm making you dust a little bit here. Okay, first of all, you want 423 text messages between,
Facebook messages.
Facebook messages between Mr. and Mrs. Crumbley admitted in a rejected form. I'm gonna ask that on the rejected form be verified by Ms. Smith, and then I'll admit 423 because you do not object.
Thank
Okay,
you.
you want him to ask him, he's going to be estimating obviously.
I'm asking for an
And
estimation.
Your Honor, I was not allowed to ask his interpretation of topics or words that were in there. And so for the prosecutor to ask this question, that's asking him to interpret how often they're talking about various topics. That's the same kind of question I was asking and I was prohibited from asking.
Well,
So-
you asked him to interpret something that someone said or what they thought.
I-
can't do-
I also asked questions about, in those text messages, there was nothing about, I believe our son could be a shooter. And that was objected to and he wasn't
No,
able to.
he answered.
There were other questions along the same lines where I was not able to talk about
No,
the
he
top.
answered that there were no communications like that. He answered that. If you had another example, he reviewed all of these, the text messages. He also said someone deleted. He looked at the Facebook, right?
423 is going to be admitted, so it can be argued later. I will withdraw my objection.
Whoa, you're
Did you
giving,
contrast
don't withdraw
for us
the
the amount of
objection, just have it
messages?
stand.
Between James and Jennifer Crumbley regarding their horses with the messages regarding their son.
I would say there was a vast majority of just discussing the horses and putting ointments on their legs and getting the vets to see them. If I had to put a number on it, it'd be upwards of 75, 80% of the conversation
Gregory, what period of time do you know?
with that volume right there.
Oh, okay. When does that start? When did you then
It's
answer?
early in 2021.
Early 2020.
Thank you. Now, what about the percentage of time expressing concern over their son?
Up
Your
until-
Honor, I object. This is speculation and there's no way he doesn't have data on this.
Do you have data on this?
just the conversation after the pictures were sent, that they drew on the math paper. And there's a couple other conversations about him having a headache, and that further than that, can't remember. any
That's not
conversation.
enough.
So I have some data.
You're going to make us listen to data?
No, well, this is just a one question. Does this sound right to you that
Your Honor, I object to leading this witness into this. If he has data, he can testify about it. If he doesn't have data, this is
Just people are
inappropriate.
entitled to lead
That's
into
not
it?
the question.
Okay. If you were to put a name search, because it's a PDF, right? So you can do a name search.
Correct.
And if you were to do a name search of their son, you could find how many times their son was mentioned.
That's correct.
Okay. And if you were to do a name search of either their horses' names or horses, you could find how many times that was mentioned.
That's correct.
Okay.
Your Honor, this is going so far beyond the scope of,
No, it's not. This is, you asked about this. You asked about this.
Okay. Would it surprise you that it's thousands and thousands and thousands different?
It would not at all.
Thank you.
Thousands
Now-
and thousands. That's
You, sir,
is counsel testifying
we're
now.
asked a lot of questions about March 9th, March 8th, March 17th, March 19th, and March 9th. It's this area of spring of 2021 that we talked about where the defendant's son was text messaging his mother and where James and Jennifer were at.
Correct. Yeah, I
Okay.
remember, yes.
So you were asked specifically, are you able to tell if Jennifer Crumbley saw those messages coming? You remember those questions?
Yes, I remember those questions.
Okay. I want to make clear that all of that information, all that evidence that was admitted on those days came from Jennifer Crumbley's original phone.
Correct.
Okay. So if she wouldn't have received it because either her phone was off or no service, it wouldn't have had the same timestamps that we see in here.
Correct.
Okay. So the timestamp of 6:03 on her phone, the exhibit, that means that's the time it actually got to her phone.
Correct.
Okay. Let me ask you something, sir. I don't think you need to be an expert to identify this, but when you take a picture, you have to open your
Objection.
I mean, you have to access you have to take the picture, yes.
phone. Right? You have to look at your phone.
Not necessarily, you just push the button on the
You have to
side.
hold it up and push a button.
Correct.
Okay. And so when we have pictures on Jennifer's phone from the exact same time that her son is sending your text messages, what does that tell you?
That she would have seen them.
How do you know that? How do you know that?
Now we
Are
asked,
you an Apple
you asked about the
expert?
alarm sent on December the 4th.
Object to that shit,
2021.
girl.
And it was up on the screen. It's an exhibit.
I remember.
It was set for 6:30 a.m. and 6:45 a.m. on December the 4th, 2020.
Correct.
Okay. And it said when it was set. It said from 7 hours and 30 minutes from now.
Correct.
So then we can tell that she actually set that alarm at around 11 p.m. on Friday, December the 3rd.
That's correct.
Were you aware that Detroit police were actually on scene at that date and time, at that specific time, at the location where she was found?
Your Honor, I object in terms,
If he knows, if he knows.
I would,
Okay, what is the objection?
well, the objection is the lack of foundation about whether he knows.
You can tell me.
See, that's a funny thing, though. Remember, he's a cop, so he's like, "Yeah, I know, I can answer this question." Ah,
Well, he can tell us if he knows. I don't know.
I was not aware when Detroit police was.
oh wow.
I object in terms,
If he knows, if he knows.
I would.
Why is that replaying?
Okay,
Oh,
what is the
weird.
objection?
well, the objection is the lack of foundation about whether he knows.
You can tell me.
Well, he can tell us if he knows. I don't know.
I was not aware when Detroit police was.
Okay. You were aware that they were on scene that evening.
Yes, I was. Yes, I am.
You were also asked about what counsel referred to as threats and her, Jennifer Crumbley, receiving threats. You remember those questions?
Yes.
Okay. And you didn't just review the Facebook messages between Jennifer Crumbley and Kara Pennick. You also reviewed other Facebook messages, other chats. Is that right?
That's correct.
Okay. And including the chat where she was communicating with a neighbor of hers on East Street, and James and Jennifer Crumbley met her at the Red Naps in Oxford the night of the shooting to exchange pet food.
I remember that.
Okay. Now, how close is the Red Naps to her home?
It's just down the road.
It's right in downtown Oxford,
Yep,
right?
correct.
Like a block away.
Correct.
So you were asked specifically about Exhibit 130 here. If Jennifer Crumbley expressed some sort of concern over what her son did. Right here, it's, "I'm bawling right now, Kara. My son ruined so many lives today."
Yes, correct.
Okay. Now, that was substantially after she was asking to sell her horses for cash,
Correct.
asking cash stats. I think it was
Correct.
stats.
Yes.
Okay. And is there any text messages at all in this exhibit expressing any sort of sympathy over the victims after this?
Not that I recall.
And in fact, the conversation continues about liquidating her assets.
Correct.
And it continues about her not being able to see her horses
That's correct.
and expressing how upset she is that she can't see her horses.
That's correct.
Nothing further, Judge.
All right, we'll stop down. We'll excuse. All right, ladies and gentlemen, during this trial, do not be listened to or watch any news reports about the case. Under the law, the evidence you would consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they include incorrect or misleading information that might unfairly favor one side or the other. So to be fair to both sides, you must follow this instruction. You must not go on social media, you must not post, you must not do research, you must not discuss the case with anyone. We're moving quickly. Please follow my instruction. It's so important. I don't want to have to put you in the local holiday again. All right? I can still do it. Okay, so follow my instructions so that we don't have to do that. Okay? I'm gonna have you return at 8:30 on Monday. Don't look at anything over the weekend. I should have served you some vitamins with your lunch. Please stay healthy and go well.
All right for the jury?
See you Monday.
Your Honor, I want to make the court
You
aware,
can be seated. You can be seated.
because I know the court, are we on record?
Oh, yes.
Okay, I know the court does not like,
Okay, so overall, there's like 20 minutes left, so we're gonna get through this and then we'll talk.
objections in the midst of testimony. There is an officer that is going to be testifying. I have numerous objections to many of his exhibits that are proposed.
Who is it?
Stoya, I'm not sure I'm saying Stoya. I'm not-
Stoya.
Stoya.
Okay.
And Your Honor, I just want to make the record clear. I received all of the materials in this case in over 30 discovery, sets of discovery given to me. Okay, I went through all the discovery obviously as it came in. I did not get the exhibits that were being used in this trial. They weren't identified. I didn't get them until after day one of jury selection. So I have done my best.
There's a scheduling order in this case.
Judge, all of the exhibits come from the discovery. This digital evidence was turned over 2 years ago.
Well, she doesn't say she didn't have it.
I'm not saying I didn't have the evidence. I'm saying that it wasn't identified until after day one of jury selection. So I just want the court to know I'm doing my best to object and to handle the evidence.
I don't envy your job, Ms. Smith, at all. I don't. It's a lot.
This is bullshit by the state.
It's sad. It's voluminous.
It's
I know
absolute.
it's very difficult. I know
It's
very
absolutely
difficult.
fucking ridiculous.
So tell me what you're asking.
Okay, so the issue is I have numerous objections to exhibits they intend to admit. I know the court does not like to have objections, but
No, that's not true. I didn't want to rule on I didn't want a surprise ruling on a motion this morning. I would have been more prepared and also would have told the jury about it. I don't like the jury waiting for us.
Judge,
There's nothing wrong with objecting to an exhibit as someone attempts to introduce it.
Judge, we handed over the exhibit list with very precise pages, and we did that. We weren't required to at a certain time, but we did
Right.
that. I think the first day we were here, Ms. Smith told Mr. Keese she would be providing her exhibit list to us that night. We did not receive it. So I'm not sure what the purpose of providing an exhibit list is if she's not going to actually go through it and say, these are the ones I want to object to, these are the ones I have an issue with, and we can talk about it, and then the court knows that there's something to argue about before we bring the jury in.
Your Honor,
Okay, well, I think that's what she's trying to tell me now.
I'm trying to tell you that now, and also, every time we've been off the record, I've had conversations with Mr. Keese during this next witness. I'm not objecting to any of these exhibits. Mr. Keese, I plan to object to a lot of the photos with
Okay.
Stoic. I haven't talked to Ms. McDonald, but that doesn't mean I haven't communicated to them when I have objections.
Okay.
That is just misleading, and I'm tired of it.
Okay.
I'm saying,
The jury
I
will
just want to know
know.
what the objections are so we don't have it. It'd be great if we could know that before.
Can they, how long are we gonna be here? Because the jury, I gotta release, the jury's waiting for her to be brought down, so I'm pushing the luck of the deputies here.
We have a few more things. We're just asking, let's hear what the objections are about the
I'm gonna release
exhibits.
jury. I'm gonna release the jury.
Okay.
For one thing, these walls are not okay with that. And the deputies are, I'm gonna owe the deputies their months every for the rest of my career. Let's let the jury go, okay?
Okay, that's
Your Honor, I have just a suggestion. I think there's going to be evidentiary issues.
gonna stay
with
quit
some
being
of these
fucking dickheads,
exhibits.
Your Honor.
So I'm wondering if maybe the jury should come back at 9:30 on Monday or something.
Actually, can you tell the jury to come back at 9? Tell the jury to come back at 9. Okay. All right,
Just so we have
release it.
time. I know the court
Okay.
doesn't want to waste their time.
Well, you do handle one exhibit at a time. There's nothing wrong with that. People do that in trials all the time. But obviously, if we can streamline in any way and not do all the juries here and have them not moving in and out since there's 17 of them, that would be good. I guess I don't know who the first witness is going to be on Monday. There's an Officer Stoyak who is with what department?
Sheriff's Office, Judge. We don't know if he'll be first witness.
No, and she's let us know she has some issues with some of those pictures,
Okay.
and we'll figure, if she tells us which ones, then we'll decide if we want to stipulate. If not, then we can handle it before the juries.
Oh, I can already tell you they're not gonna stipulate. I can tell you we're gonna need time on the record, like,
Okay, well, I think.
I'm not sure how to respond to that.
No, I think that the prosecutor was saying that you might stipulate to the admission of some of them, right? And we have a right to object to something being admitted, right?
right.
Okay, so I'm looking at the list,
There's many photos from inside the home
okay?
that I believe are contrary to the orders this court has already given. Like the messiness, there are irrelevant photos. There are photos of the stairway to the basement, completely irrelevant to this case.
Why do we care about the stairway to the basement?
Judge,
That's why-
counsel might, she indicated she was going to create a list of which exhibit numbers, they're numbered already, they're numbered,
Right.
and just tell us which ones she's object to. We'll review that. If we agree, then we'll strike them from our exhibit list.
So where's the
Okay,
shit
we're
show?
Here to talk about it at 8:30 on Monday morning, because maybe we can.
We could get a list before that, then we might not have to argue about it.
Your Honor, part of the problem is they won't tell me who they're calling. They gave me the exhibits after the trial, the list of exhibits after the trial started. There's one of me. I have co-counsel that has not been with me this whole ride. And so I'm doing the best I can, and I have to sleep at night. And I've been here for 8 hours a day this whole
We've all been
week.
here. I've spent many hours on this case, and so
I
as a
know.
prosecution, I know there's only one of you, but you're also retained counsel,
I
right?
understand that, but
Oh, she is
I
retained.
need,
Oh.
and this weekend, thankfully,
Oh.
I'll have time. I will get them the list of objections,
Okay.
but
all right,
when
that helps.
when I don't even know which witnesses are being called the next day,
Okay, I don't know of a rule that obligates them to do that.
Okay.
And Judge, you asked us to communicate, we did.
We
You
did.
did. Okay.
She knew Lance,
Wagorowski.
Wagorowski was good. I mean, we did tell
Okay,
her.
all right. So over the weekend, hopefully they're going to do the same. Over the weekend, you tell them the witnesses you're going to call Monday. Will you do that?
We tell her every single day when she
Well,
asks,
then
these are our
tell
list. But we do, if I can,
9:30 at
if
night.
I can just finish.
Okay,
If I
I'm
can
sure
just
you
finish.
don't know yet. exactly.
We already changed that today. I mean,
Okay.
that does change, but
What are you going to tell her about?
When we can confirm childcare for our witnesses
Okay.
and confirm, we have one person with COVID right now, we have one person out of the state. We're rearranging witnesses in real time.
Okay. What objection, non-responsive? Can you tell her Sunday by noon?
I hope to have those answers by then, and
Sure.
I'll communicate as soon as I have the answers.
I don't think they're obligated to do that. On the other hand, it is a courtesy, and it is something that helps the trial move quicker.
I think it should just be fair.
it
For
would
instance,
also,
we
Oh,
don't
no,
have.
we don't want this to be.
We don't have an exhibit list from the defense. She said she'd provide it the same time we did that night. We don't have it. We
I
just
didn't say
want
I
to be
would
treated.
provide it that night, and
Okay.
I didn't know what exhibits I would need until I saw your list, and I haven't had time this week because we've been in court or.
Okay, all right. All right, yeah, I'm obligated to be fair to both sides, right? This exhibit list, regardless of when you got it, to me has been very helpful. It's descriptive of
Thank you.
where and when, and because, some of it,
You can
some
thank
of them
Natalie
overlap.
for that.
Some of them
Judge,
overlap.
okay,
Your Honor,
but you
I
don't, aren't going
disagree,
through all
but
the
also
discovery,
some of mine don't
Judge.
match what's been put up on the screen. Like it's not as simple and as clear cut. I have this weekend, which is going to give me the time.
Okay, good. Yeah, okay. They're gonna communicate with you, and if you tell them which ones you object to, I don't know if I've seen some of these. Some of these are in the house, some of them might be relevant, some of them might not be.
I don't think you've seen any of that.
What's
I
that?
don't think you've seen any of that.
Judge, listen, if she just make a list, we'll be happy to review it with her, so you don't have to.
Okay,
I
so
told her
you're
to fuck
here
off.
8:30 on Monday morning, we'll talk. We'll talk about as many exhibits as possible. In general, they can go question and answer and all that, but if we can agree on some beforehand, I'm just going to pray that by Monday morning, there are no issues. Can I do that? Can I go to the river in Egypt?
Judge, regarding Exhibit 423, counsel indicated that there are certain messages she wants redacted. Counsel can indicate what messages they are. We'll be happy to redact them before the actual exhibit's turned over to the jury.
Thank you. I think that it was based on messages that were already excluded via previous motions.
And
I don't recall any specific messages previously excluded by
I
this
don't
court
recall-
from Exhibit 423.
There
Counsel
was
said-
topics-
hang on,
It would be
counsel-
hard for me to compare this right now to my orders.
Right, that's why if counsel is requesting for it to be redacted, I just ask counsel, tell us what to be redacted so we can do it.
Okay.
Your Honor, then I need them to send me this proposed exhibit.
You have it, you already have it.
423.
You had it in January of 22.
Messages between,
Wait a second.
wait, you guys wanted, someone said they want all the,
It's
you
the Facebook
said
messages.
I'm
you want all
trying-
the Instagram messages between the defendants and that's what you said.
Facebook.
And that's,
Facebook.
Your Honor, that's totally fine. All we have to do is make them compliant with the other orders of the court that have already excluded evidence.
Okay, that's fine.
Yeah,
You
I'll
can ask
reject
for
it.
to come in.
But I'm asking them to give me the original file of 423, because I don't have 423, and I will go through and redact it. I'll do it tonight.
Judge,
Okay, but
they
you
have
can't
it.
just- You can't just redact it. They have to know.
Well, I-
They have it. You give them a
What the
whole
truth
county load of shit.
She has 423. It's the entire Facebook message string between Jennifer Crumbley
Yes.
and James Crumbley. It's the thing that she piles up. She has
It's the entire string, but you're not showing the entire string in the exhibit when you publish it to the jury. You're publishing bits and pieces. That's where the problem is.
that string. So
the court would like we can produce a proof of service first thing Monday morning.
No, and I'm not saying I do
Fucking assholes.
have it in the evidence. I don't have it. They're talking about it as if they've given me a 423. They haven't. It's buried in the stacks of evidence.
Okay.
That's fine. I'll dig it out. I will go through it tonight. I will let them know what I want redacted.
Okay.
All I
You can
want
send them,
is
yeah.
redactions.
we provide the digital
It's a
copy.
thumb drive.
I don't understand.
There's a thumb drive that has 420.
Yeah.
Yeah, they handed it to me
It's
today
like-
while we've been in court for 8 hours.
Okay,
So
Okay, but you're the one who asked for it to be admitted, right? You're the one who asked for it to be admitted. So, which I'm happy to do. Everybody agrees. So, all right.
We
Everybody,
have just a couple more things here.
Also, I hope that wasn't the cat fight because that was kind of meh here.
Just one thing I think is important. I asked this court to instruct counsel to show the appropriate decorum in this particular case. The jokes indicating I'm going to kill myself in a joking manner. I'm drinking 5
The
bottles
bottles
of
of
wine.
wine. It's just
You've
there
got-
are parents
That's
who
my
had their children
that's my
murdered in this courtroom, and we are the people who
I-
communicate with them after we leave
I
here.
said something about wine because I was looking at her.
Oh, fuck you two. You little bitch-made assholes.
Was trying to nicely suggest.
Look at that. Look at that. Well, the fucking smirk right there. I'm sure you're going to smirk while you're holding the snack tray tonight. How many snack trays you hold up? 2. You're going to be like Atlas, just shouldering those snack trays. Shouldering those snack trays. The fate of bulls on your shoulders, son.
Killing yourself in this courtroom at this time. I understand.
I didn't mean it like that. I'm sorry. I am so
Prosecutor
sorry. I
lady.
did not mean it
Stop
like that.
yelling. That I don't
I
want to
did not mean it like that. And they
Oh, I don't want to be yelled at. Dude, stop yelling at me, ma'am. It's too loud. Fuck you. Fuck you. Fuck you. This is why people hate the state.
know I didn't mean it like that.
We're responding to literally just sitting here, the amount of messages we get from victims in the community. And I just think
It doesn't matter. It doesn't matter if the community's a big flopping sloppy tampon. It does not matter. It doesn't matter if the Jews are just streaming out of their pussies and they can't fucking stem the tide. It doesn't matter if there aren't enough tampons at Costco to save them. It doesn't matter if they can't shove a comforter up there and it just blows right out like a fucking hole in the Titanic. It does not matter. People cry and bitch and fucking moan. You're the county prosecutor. You're the prosecuting attorney. You're not the county gynecologist. For fuck's sake.
be an abundance of respect and caution if we could just not say things like that. I'm not accusing anyone of any malice or any bad intent. I'm just asking that we just not engage in that because this is hard enough for the people who are sitting here now and who will be sitting here next week.
Fuck them and fuck their problems. This is about the defendant.
Your Honor, I am not joking around about anything.
Okay, I think it was a slip of the tongue. It was a slip of the tongue, right? Emotions are running high. We also, a lot of people are saying he is the shooter,
But Your Honor, I do want to make a point. I'm not making an objection because my emotions are running
Yes,
high.
you are.
That's
You're
like-
doing because you're a
I'm
bitch.
not having an
Doing 'cause you're a
emotional
fucking
response here.
bitch.
I am simply asking that we be respectful to victims. That's it.
Monsieur David. Oh, you just missed. We're about to finish up here. We only got 2 minutes left. I just heard about the whole. Apparently, the county's tampon is just soggy, and it's just menstruation everywhere.
I got a text from
Oh.
Jungmin in your chat. She's like, he's just got to the fight. He just got to the fight.
Okay. Yeah. Oh, okay. So hold on. Yeah, we'll get to the end of this. Yes. Apparently, there's a soggy tampon problem in the county, and the prosecutor's concerned about it.
I've watched this so
Oh.
many times.
Your Honor, I am being respectful. So that is implying I'm being disrespectful. Me saying I'm going to kill myself. I didn't mean in any way to offend
I know you didn't.
these
I know
families.
you didn't. It was a slip of the tongue. She's just.
It was absolutely not related to them.
I know.
This shooting is awful. It's the prosecution that's parading all of this up here and putting the
Parading?
victims through
The
this.
shooting is the result of the defendant's gross negligence. That is the case.
They are the ones putting
You're parading it all. You're dragging these bodies out to make this happen, son. Yes.
Exactly.
Yes, you are. You fuck. Like I said, he's got them snack trays on his shoulders last night, folks. It was a rough night holding it all up.
Loving this.
Everybody
re-seeing all of this
everybody needs-
over and over
Your
and
Honor,
over.
Whoa! Everybody needs to go home. Everybody needs to go home.
Good.
All right?
I
Good
understand that we're not.
Judge is
putting
done.
victims
Good for her.
through
Good
anything
for her
that-
controlling that
and
courtroom.
I'm sorry, but that just because everybody's disagreeing doesn't mean everyone is inappropriate. We aren't putting victims through everything. We're prosecuting our
You are putting them through this. Oh,
Yeah, you
we
don't
did
have
nothing
to-
wrong. We're God's children here. We're doing God's work.
The defense has stipulated to the fact that there was a shooting, that these people
Yeah.
died, that this was the gun
Yeah.
that was used. It's your
Yeah.
choice. They actually brought a
Yes.
motion to exclude all of that, and the court is like, "Well, it's their burden, so if they
Yeah.
want to introduce it, they
Yeah.
can." And of course they do.
It's
because it
yeah,
brings
it's not
up
our
emotion.
fault. We're not showing Tate dodging the shot right. Like, okay, great, he missed.
Mhm.
He bobbed instead of weaved.
case.
Okay.
And we're trying to do it in the most efficient way
And she's
possible.
defending her case. I think that was a slip of the tongue. Everybody needs to take a deep breath and go home. Everybody go home. I'm going home.
All right.
This judge is like,
Sends
fuck
a
you all.
Oh. I did hear the "I'm gonna kill myself" comment live, and I'm like, "Oh, that was just the wrong thing to say."
You know what? I don't. They can all fit tampons for all I care. They can all. They can. Oh no, I'm serious. Like it's like oh no, I'm getting messages from the county. People are messaging us. So what? So what? Like I'm sorry. Apparently, David, Oakland County, you guys are like, there's a tampon shortage, and it's just out in the streets, just drizzling out everywhere. There's just floods of juice, and people are slipping and falling. Cars are spinning out. The National Guard's gonna have to send out bales of hay to feed the cows because there's just rivers of juice everywhere because people won't stop menstruating. I mean, God, I hope like wear a life jacket, man. Apparently, it's bad out there.
it's
I'm sorry, but
no. It
yeah,
got
they're
terrible.
sending letters. They're so mad.
They're sending letters. Well,
Yeah.
so the
Oh.
okay, so I have a problem with the defense counsel in that I believe she's getting too emotionally involved, and
Yes.
she's getting pulled into these arguments from Karen.
Yeah.
She shouldn't be arguing with Karen right now, and she's getting pulled
Yes.
into it. And I know this isn't in front of the jury, but it looks really bad.
And when she's like, I agree, this is horrible. Don't know. No, I agree. Yeah. No, it's like she's like, it was fucking brilliant. Look how he spread those shell casings around. Like, best shooting ever. Like, 10 out of 10. Like, for a kid who just picked up that gun, he did decent. Like, yes, I agree. She shouldn't be running around like she gets all into it. Like, I agree, it was so horrible. No, I don't care what the fuck my guy's done. You don't ever play that game.
She I don't know if kowtows is the right word, but she apologizes. She accepts the state's position on way too many things, especially with the cross-examination. You saw how when she was trying to get the inference of what did they mean by this sort of text message?
Yeah.
They kept objecting, and she kept apologizing and backing off when she allowed the same thing to happen when the state was on direct.
Yeah, she should have gone full tilt. Oh, he can't interpret. I would have said he interpreted that Ethan walked out with his chest held high when he started shooting. They've already established him able to discern this family's information.
Yeah, she says sorry.
And I will say though, her cross was fucking good.
You liked her cross?
I liked it. Like when she stacked all that shit up.
Well, that I did like. Yeah,
but I like that. Like, you know, you don't know what you have just these terms, right? It's just these like couple of handful of things, right? You don't know what's said in response. You don't know this or that. And he's like, yeah, I don't. The other thing I would have mentioned.
I thought it was a clumsy cross.
It was clumsier, but I think it got the point across. Like, well, you know, that I thought it was a great point of showing like this is it. That's all they've got to hang their hat on are these like 4 or 5 messages.
I love how the judge was talking about it like the Leaning Tower of Pisa, and you go home with your 6 bottles of wine, go through it all. The judge was cracking jokes too, and when Karen, the prosecutor, brought it up, I think that was a jab at also the judge. That's why the judge wasn't having it.
I know, and the judge is fair. And I will say the judge got in front of that. She's like, no, I said that. Yeah. So like that's not her fault. And you know, like, and here's the thing. Were you ever a prosecutor, David?
For a very short time.
I mean, like, I will say this much. Yes, I understand victims have had hard times, but oh my God, they can be fucking insufferable. Like, you know, okay, great. Yeah, your relative got murdered. Yeah, but they were also a junkie. Fuck. Like, let's not act like they were going to MIT in the fall. Or they were going to cure fucking cancer. Like, I get it. They were your relative. But you'd also shun them because they stole everything every time you helped them out. Like let's be real about what we're dealing with. Now, I get these are kids. It's a little different. But, you know, the only other way I can think of it is like, have you seen the OJ movie, the series, The People versus OJ?
Yeah.
Yeah, you know, at the end where like they lose and like the Goldmans are like, do you know how that feels? Like, okay, like, yes, I get it. You're a victim. Your indignancy doesn't make you any more right than anybody else.
The bad guy is in jail.
Yeah.
For the rest of his life. The actual shooter. Yes. Remember what we're talking about here. Yeah. You know, she didn't pull the trigger.
Mm-hmm. Oh yeah.
And but these are all victims, and these are all. It's just it's a railroad of a prosecution. It's an anti-gun prosecution. It's a political prosecution. They want to make it so that they unattractive to just own a firearm. That no one will, because they can't ban you from owning it. They can't ban you from carrying it. But God willing, if you use it, or if someone closest to you uses it, you're all going away. That's what they want to do.
Yeah. Well, and the only other thing I think is going to have to happen, because, you know, once you do this, the police are going to go overboard with it. They're going to start hitting bombs up in Pontiac. Pontiac's in Oakland County, right?
Oh, yeah. Yeah. No, that's a bad area.
They're going to start hitting. Well, and guys, if you don't know, Pontiac is, Pontiac, Michigan. It's, you know, where Silverdome used to be and all that. It's part of Detroit. You know, and it's not nice. It's a little rough and tumble up there. Well, guess what's going to happen? Eventually, the police in that part of the county are going to start using this theory and start hemming up parents of kids who are out gangbanging. And guess what? It's going to get charged in the news, and then they're going to have to, like, they've pulled this, you know, they've started this now. So if they start tossing this out, people are going to be like, wait, I thought it was all their faults. Why is it just not, like, they've kind of caused a problem that, you know, and this is more of a point I keep bringing up. You know, people want enforcement of the law. You eventually end up just harming minorities, and, you know, guess what? Detroit's full of not white people.
Exactly.
So
someone asked me if I thought that she was getting a fair trial. So I sat through the jury voir dire for the first day, and everyone who had a political opinion or didn't like the idea of guns, period. Like, there was a British woman that said, I don't like, no one should have guns at all. Except for, you know, the good guys, you know, the state officers. Then those people got booted right away.
Yes.
Now there might be some, you know, undercover jurors on the on the panel. I don't know. But anyone who gave any sort of indication that she's got to be guilty, or I don't like guns, or just the mere fact that she took or gave her son a gun and went hunting, or not hunting, target shooting or anything like that, was just bad. The judge kept emphasizing that we as a panel here, we're going to agree that guns are legal, owning a gun is legal, taking your gun or your son shooting is legal. All of this is legal. That's not what we're questioning here. So anyone who had an issue with firearms in general was booted. Anyone who had proclivity for cops was booted. There's one guy that said, it was funny. One guy said that he would believe cops over other witnesses, and the judge questioned him. It's like, okay, so you have a witness at the scene that saw everything versus a cop that shows up after the fact, and their testimonies differ. Who are you going to believe? And he's like, oh, the cop. And she's like, all right, thank you.
Hey, some people they love them boots.
They
love
do.
them boots.
They do. So they booted a lot of people. I wasn't there for the final seating of the jury, but based off of the questioning that I heard, I feel like it was a fair process, and I believe they should have a fair.
Now, she's not getting a fair trial. Her jury selection may have been fair, but this is not a fair trial.
No, with all the hearsay stuff allowed in, without the ability to cross-examine it. I am a little concerned about the prosecutor, or not the prosecutor, the defense attorney. I think she's a little emotionally wrapped up in it. I think she's a little defensive herself personally, which I don't like it. I don't think it's going to come off well with the jury.
No. And we had more and more of this whole nonsense. They were talking about the whole Facebook transaction. They're going to offer it as an exhibit. And they're like, well, we gave it to her. And they did more and more of this where they're offering snippets as the exhibit, and she still has to rifle through it. Yeah. And I'm still infuriated by that, because that doesn't fly in any other courtroom I've ever been in.
It doesn't. The judge was clear, though, on that hearing that you just heard at the end, that you're going to produce the documents. You're going to give her a list of your witnesses that you plan on calling on Monday. And you're going to give it to her tonight. And in fact, they went into the back room and hashed out all the exhibits and the pages and all that stuff. So the rest of the trial hopefully will go smoother. If there's more of an issue, I don't know what the judge is going to do.
No, I hope so, because but I will say I think they did a pretty good job on that. Now, I will say she did also a very good job fighting back on redirect when they started trying to say well, if you examine this and typed in horse and Control F, and it's like, well, he didn't do that, so how does he know?
Well, by way of example, when the defense counsel was trying to get the witnesses to speculate as to what was the meaning behind the text, she was doing it the wrong way. The prosecutor on redirect absolutely did it the right way. Here's this text message about me bawling. Now let's go to the text above it, and it says selling horses. That's the inference to the jury that she's all upset about selling horses. Now, I don't think that's the right inference, but that's how you do it. You can't ask the witness, well, what do you think she was all upset about? You just question it that way, and that's the way to do it. And I hope she picked up on that and is able to move forward doing that, because you need to make those inferences.
You have to run, it's just like how if any of us were just reading a text message out of context, you'd ask, well, what does the before and what do the after say? Because that would help us figure out what we're talking about. And then you could say, what does it appear? And you might be able to get away with that, but if you don't, the jury at least gets some context of what you're trying to show.
Right. So, but the prosecution is much better at developing that inference without even asking the witness to speculate. Oh, my dog is barking.
That's all right. He's doing his job. All right, we'll do some super chats real quick while David comes back. That's a shame for $4.99. It's good to see you. It's saying, I haven't started this yet, and I can't decide if I should jump in now or try to catch up from the beginning. I appreciate the bonus streams either way. Well, I mean, it's kind of a shit show, and it's going to piss you off. So, I mean, if you want to get pissed off, great. Yeah, go ahead and start watching from the beginning. Julio for $4.99, thank you, is saying, speaking of horses, my mom convinced me as a child they stuck up a carrot up Mr. Ed's ass to make his mouth move. Oh, that sounds like some Vince McMahon stuff. Yes. Potentially Skip says, I cried until he stuffed the wrench in my face. Oh, you're taking it like a champ. I'm glad you wiped them tears away. And Unhung Hero for $2 says, I was about to doze off and Sean yelled, be awake. Well, yeah.
I think I got
and
the
then
box over there.
Let's go. Brandon says, remember when she committed suicide by wine? Oh, funny. This is something, I don't know if you can answer the question too. Ellie Fant was saying, it's a mini courtroom. How many people do you think could fit in there?
So the jury selection moved in 50 people, and they all sat comfortably in the audience section, and then there were 9 media also sitting off to the side, and there are other family members, and then everyone else. So I don't know, it fits like 60-70 people. It looks smaller than it is in real life, although it's not the biggest of courtrooms, and they're all the same size. We have some other wings with extra space. In fact, there's a really nice big courtroom in the West Wing, but all those courtrooms are pretty much that size in that layout.
Yeah, and I was just trying to tell people, like, these aren't the biggest courtrooms, like the whole Johnny Depp, where you can have like 150 people sitting in your courtroom, things like that. That's not the standard. Most of them are pretty small. I mean, I was actually bigger than I thought it was. I thought, when I was looking at it, they showed a shot panning back during break, and I thought, okay, maybe you could fit like 30 some odd people in the gallery, but
yeah, I mean, it's not comfortable seating when you have that many people. It's definitely tight, but you could fit in, 60, 70 people, and that includes the parties and the attorneys and jurors and the box and the judge. I'm counting everybody in that room.
Okay,
I'm not just counting the audience.
Oh, okay.
Yeah.
Okay. Well, so that's about the size I'm kind of thinking, but yeah, that's guys. This is the normal size of things in America. It's not everything is super huge and massive.
And I say that this courtroom is bigger and better laid out than, say, Wayne County, downtown Detroit. If you go into those courtrooms, they're even smaller and they're weirdly configured.
Because you have a bunch of them, I bet.
Yeah, you
all
do.
On top of each other. Well, I will say, though, this is a very nice looking courtroom. It's got that like 70s vibe to it a little bit, but at least it's very well laid out. I like how it's laid out. The flow of that room seems to be very good.
My biggest complaint about those courtrooms are the desks are big, but they're heavy. Yeah. And if you wanted to configure it in a way where the defendant is facing the jury and the prosecutor's close, it's not really convenient to do that, which is what I prefer. There's not a lot of places to move stuff around beyond the bar, between the bar and the bench. It's just that's kind of small. But otherwise, it's not that horrible.
Okay.
So. But no, I wanted to hear your take on it. I'm glad that you feel like she did a good job, because I was getting the points across, or I was hearing the points coming across on Cross, but I felt like her manner of Cross, maybe everything kind of got lost, and in her approach. And so I'm happy that you think she did good, because I think she hit the right points. It was just a little messy.
Yeah. Hold on one second.
I'm just finishing my my update, like little review video, which went a lot longer than I thought it was going to be.
Yeah. Let me see here. What some of you guys had questions. Just double checking here, see what you guys have questions about.
I would be scared if I was a parent in Michigan. Well, that's one of my thoughts. Is always I don't. If I had to, some people say, like, why are you so invested in this case? I don't want my kids to do something stupid and then I get charged. And so maybe it's selfish.
Yeah, that could easily be you.
It could easily be me. My kid could go off and do something. Every kid does something stupid. And every kid, has the potential to get picked up and charged with something for the stupid thing that they did. And do you want that to come back on you because you weren't good enough as a parent in the eyes of the state?
Yeah.
And the other thing is what could these parents have done? Let's assume they got him into therapy. Let's assume they gave him the medication. Well, it just wasn't enough, because obviously he still did this. So, it wasn't enough. So we're still going to charge you. Where's the line? Where's the line that you draw, state? What is enough? What exactly are you demanding of us parents? If they took him to therapy, is that enough? Did you say that ahead of time? We just don't know. And that's why I'm always a proponent of the common law that's existed for hundreds of years, that the intentional wrongful acts of a third party will get you off of your negligence claim or your gross negligence claim, right?
Yes. No, that's how it's Yeah, it's a massive, as far as intervening events go, like, how the hell are you supposed to know that's going to be something you can argue.
Yeah.
Like that person interacted in a way I had no control over. And then Carrie wanted to bring up, are we caught up? Yes, this is caught up as of 8:29 tomorrow. Well, 8:29 tomorrow morning. That being said, for you guys, if you go to hold on here at the bottom. If you go to youtube.com/@making-law-simple network, David will be covering it right away at 8:30 and going forward the rest of this trial. So yeah, I may pop in tomorrow if I have a little bit of time here or there, but yes, this will be going full tilt. This week, guys, we're gonna on my channel, we're gonna get back into Michelle Troconis. We gotta get going on that one. Although she's kind of, guys, if you've been watching that with me, she's been shooting herself in the foot. Aaron says, how hard is it to defend somebody when there's a case law?
Well,
It's hard at times.
It is very hard. And, you're pointing to a blank slate. And, the burden is on the prosecutor. And these defense attorneys did really well, both James and Jennifer's, in appealing it to the Court of Appeals, then to the Supreme Court, then back to the Court of Appeals, and now back in the state court. They've been hammering on the law quite a bit, and just nobody's biting yet, because essentially they want to see a development of all the facts and the evidence that comes in. It's hard to do. So you basically convince the jury that, like Sean said, they did the best that they could with the information that they had. And hopefully this goes away. It's a catch-22. Like, if they're convicted, then they could be used to set new precedent and say, you can't charge parents, right? But you don't want to see them convicted. And if if it's an acquittal, then it doesn't go to the Court of Appeals. So the state might try this again with another parent. So you're like, I don't want to see them convicted, but I kind of want the Supreme Court to say, no, you can't charge parents for this. It's a weird spot to be in.
And it's also tough because when you're in this like uncharted territory, it's hard to get a judge to want to make a decision because they don't want to get, they don't like being overturned. And some judges are, some judges act like they're terrified, like they're going to get killed if they get overturned. I've been in front of a judge or two like that, where like, they're always like, oh, well, the Court of Appeals. I'm like, okay, great. What are they going to do? Kill you if it turns out that way? Like, you get the notice and you get the opinion in the mail. Like, we overturned because of the judge. And there's going to be like a knock at your door. Like, and it's the Court of Appeals standing outside with a pistol. Like, it's like, yes, I get it. It's not good, but a lot of judges are risk averse. There's very few cowboy judges out there, except in very ideologically driven situations. And this is not going to be one of them.
And in Michigan, they're elected. So you're dealing with a politician at the end of the day.
Yeah.
And they have their little groups. There's the Oakland County Bar Association. There's the Women's Attorney League. There's all these different little groups that they're a part of. And they don't want to walk into those groups and be shamed by everybody, because then they're probably not going to get reelected.
Yeah. There's all those parts as well. Yeah. Because if, it's like I said, if she throws us out, it's like, she let the killer's mom walk. It's like, okay, well, she's done. So
but you need the judges that are willing to make the hard decisions.
Yeah.
And
100%.
Unfortunately, we just don't have them. I don't know of a better system to get them, except getting more cameras in more courtrooms so that more people are aware of what's going on in these courtrooms and what these judges are doing. That's the only way that I know of. More eyes on the judges, more eyes on the prosecutors is really the only way to try to balance this out.
Yeah.
So
no,
cool.
I agree. That's the that is kind of where we are with it. But yeah, no, I think I don't know. I mean, like, I'm trying to think it's okay, but
did you see anything in your watching this? Anything that you could realistically put yourself in the prosecutor's shoes?
Yeah.
Is there anything that you could point to and say this attributes to the mother's guilt?
I would be hampering on all those things where it's like, oh my God, what are you doing? Stop doing that. Like, all of her reactions to those things, like, acting like a panicked white woman. Yeah, I can use that against her entirely. And then I would point out, like, the whole, like, these guns were left out. Like, where was this gun? Because it's not clear. I'm sure they're going to have Ethan talk about when the cops interviewed him, how did you get the gun? Where did the gun come from? And I don't know what the answer to that is, but I'm assuming it's to an extent, oh, it was in my room. And am I wrong, or is that where it came from?
Wait until you see there's more text messages to the friend, and there's more journal entries. The journal entry, one of the journal entries is, by the way, there's no evidence that the parents even knew this one journal existed, but there's a journal entry written on November 28th or something like that. So this is like 2 days before the shooting, that says, all I need now is my gun. If I could find where my dad hid it.
Okay, well, see. Okay, well, there you go.
So
because they didn't bring it up, and if they knew it was like stuck under his mattress and they let him have it, I'm assuming they would have brought that up in opening, but I didn't know because they didn't say anything about it.
So there's been no evidence as to where the gun has been stored, where it was kept, or anything like that, because the parents aren't talking, and Ethan apparently didn't say it. Nobody's brought it up during a preliminary examination or anything, but the journal entry that was entered during a preliminary examination clearly says, all I need to know is where my father hid the gun, indicating that he didn't have free access to it.
Yeah, well, and if that's the case, then I don't know what more.
And then I see some people in the chat. He thought demons were in the house. He is mentally ill. Do we know that he thought demons were in the house, or was he just saying it?
Yeah, you brought that up. Because I asked you about that earlier. It's like, well, what was there ever treatment for that? Did it ever manifest in anything? Has Ethan ever claimed that since then? Because I know he says in the text messages, but did he ever try to make up that BS when he was getting interviewed? Or I saw his sentencing. I watched it and listened to it. He doesn't claim about demons or anything like that.
Yeah, if you go back through the Miller hearing, which was like 4 days or so of testimony, essentially regarding this kid's mental health. He was not diagnosed with anything. He doesn't have delusions. He doesn't have psychosis. He doesn't have anything that would lead to a conclusion that he was actually seeing things.
Yeah, he just sounds like an asshole.
Yeah, really.
More
he
or
just
less.
does. So
no, okay. So that's where I was. Yeah, I'm not. I mean, they have some things I think they could point to, and it's enough a jury would say okay. But in reality, I think they've got a long way to go still. I don't think they're close to. I don't think they're close, but I mean they're ahead of the curve right now because they're the prosecution. Right. But otherwise, I don't think if they think they're riding high, they are grossly overcounting their chickens at this point.
We have supposedly 20 to 25 state's witnesses. We've been through 5 of them. I don't know who else they're going to call. We have the horse.
They're going to call some parents, I bet. And my kid died. I'm sure we're going to see a lot of that.
There was a motion regarding excluding the testimony from the teachers and all that stuff. The judge allowed 2 in. I think we've heard the 2 from them. So I think what we're left with is the horse training lady, some coworkers and friends of Jennifer, and I don't know who else. I honestly have no idea who else is going to be called. So maybe a bunch of state police officers to talk about this and that.
Maybe. I don't. Yeah, because I'm wondering how much more they can have, because when you told me 2 to 3 weeks, and I'm like, this is pretty straightforward. I mean, there's not an elaborate theory of negligence here. It's a pretty straightforward theory of negligence.
So the preliminary examination lasted 2 days.
Yes, I remember that.
Most everything that we've seen so far was introduced at the preliminary examination. There's nothing new except for a couple of videos of Ethan at the range. That's really the only thing new. And they're about halfway through the evidence that was admitted at the preliminary examination. What we're missing is a few more texts and some journals. And that's about it. I don't know what else there is.
Oh, I remember what I was going to ask you about, David. Okay, so I don't know about how this court normally does things, but this chilled my blood when they this was completely unacceptable, at least in my experiences of being in court with weapons. Was just the unsecured weapons that were in that courtroom. And the funny thing is, the way these guns were being handled, there are judges I've been in front of that would have held people in contempt. And the first one here, this is funny because it's an Mr. ATF agent. And it's
when he racks it?
Well, no, this one here with the SIG, that's a zip tie. So I could cut that with a pair of scissors, and he keeps dropping the slide on it. Eventually, he's going to cut that in half.
I know. That's why he keeps dropping the slide. He keeps racking that gun on a zip tie.
Yeah.
Yeah.
And I want it to break, and I'll be like, are you a safety expert, sir?
I know. I saw that too.
Do you put a zip tie on a gun? Is that safe, sir? And this is the thing. If she was a gun expert, she could then go to the next one with the Derringer and say, sir, is this gun operable right now? Yeah. Well, I'm sure the judge would shit a brick if she knew this was an operable firearm.
Yeah.
Most judges don't want unsecured weapons, but I'd say, oh, okay, so there's a lot to safety. Even professionals mess up. Like, I would be hammering that. Like, okay, well, apparently the prosecution, the state's not being safe. Because I think he's saying he secured these weapons.
Yeah, I think
and that's where
yeah.
And that's where I'd have to say, okay, so you're telling me sometimes things are just dangerous. And I'd leave him sitting there.
I was a little nervous when they were walking around with those guns. That
is an unsecured firearm.
She wanted to place them in the gun safe for some reason. That's why she took them out of the boxes. But it didn't make sense to me as to why you would do that.
Well, I think she was trying to show like the safe wasn't big enough for the SIG.
Yeah, okay, sure. But
but once again, that is an unsecured firearm. That firearm could be used right now, and there's nothing to stop it. And ATF, suck boy, ATF boy right here. Unsecured firearms is just, this is, I've had judges who they would have a stroke over this. Like I've been in some courts where the judges like designate like before the trial starts, like we'll have a pre-trial and he'll say, there's going to be firearms present. And he says, cause he shows it. And I'd been in his courtroom before, but the prosecutor had it. And he said, look, and he came over and walked over to us. And there was next to the jury box, there was like an empty spot before the bar. Before, like, kind of like at the end of the well. And he's like, that is where firearms will be pointed and only pointed.
Yeah, there's nothing like
he says if you don't, he says if you don't, well, but just in general, a lot of judges say like, okay, well, how are you safely going to operate these? And this guy, they're just,
I know at one point it was sitting there pointed at the clerk. I know where the clerk sits, and I was like, it'd be uncomfortable if I was the clerk sitting there.
Yeah, and just like you can't, like this gun right here, you can cut that zip tie off.
Yeah, I saw that. I was like, that's a zip tie. And then he racked it closed. And I was like, no.
Well, see, but that's where I'd hammer on that it's a zip tie, yeah. What is that made out of plastic? Yeah, can I cut those with I grab a pair of scissors and I say, can I cut this with that?
Mm-hmm.
Yeah. Is this really safe? No. I guess safety is harder than it looks, huh? Like I would have just used that, like because they're gonna claim they're gonna hammer on shit's not safe. You motherfuckers aren't safe.
They have two deputies outside the courtroom, not the courthouse. The courtroom with metal detectors. Anyone going in and out gets wanded before you go in. But they've got unsecured guns on the inside.
Yeah. Well, no, that's the thing. Like a lot that is just like because I've had guns accidentally, like I've been muzzle swept before in court, and I fucking have I've swatted like a barrel of a shotgun away because like I didn't even want to come in close to me.
Yeah.
And I'm like, no, and I stopped it, and it's like and the prosecutor looked at me, and the judge they looked at the judge. The judge's like, don't point it at people.
And this guy was pointing it, and so was Karen when she was handling it all. I mean, they were pointing at all kinds of people.
Yeah, this is, but yeah, I think there's. But this is once again, when guns, that's a great argument to make. Like these, I point out like this weapon's not secure, ladies and gentlemen. Are these guys guilty if something happens? I mean, I'd say like if something were to happen, if I were to load this right now and kill someone, well, by their logic, they're all guilty of manslaughter. They'd sit here and tell you, oh no, we tried our best. So that's just sorry. That was just something that got me.
Yeah, no, sorry. I mean that's typical of what I see.
Oh, Keopathic. The judges normally are on top of that. Like they're like if you're bringing guns in a courtroom, most judges know enough to know like that gun's not secured. Like they judges are very persnickety about bringing like weapons.
I think the judge saw the zip tie and ATF agent was handling it and thought, okay, it's secure. Then no one flinched when he racked it closed. Nobody made a movement.
Yeah. Well, hold on. Because I was going to say Ohio.
we don't really have a procedure like built into the court rules or anything with regarding
Oh,
to
okay.
handling that. And not even like local courts have their own rules, like Oakland County.
Yeah,
doesn't
but
have
I
any
think our
particular
rules
rule.
of superintendents cover this actually, and those rules of superintendents mean like the Supreme Court passed, passed some rules. Well, I was saying that to like not you, to like the normies out there listening.
Sure.
Not, I'm just saying to you guys. I like you all. You guys are fine. Where is it at? Because I'm pretty sure we have a rule on this.
You guys, I have no idea if she's pregnant. I don't.
Yes,
Everyone wants to know if she's
that
pregnant.
is a major thing here. So
You want me to ask
people.
her? Let me email her.
Do you know her? Like, have you interacted with her before?
No, she's out
Okay, I didn't
of she's not out of Oakland County usually. But you know, she defended Larry Nassar.
Yes. Yeah. Well, that was an easy one. It's not like he was walking away from that one.
I know. It was just mitigating the sentence at that point.
Yeah. But no, that's the thing though. That's just. But yeah, no. Most rules, most courts I've been in, like they have rules like, you know, it's actual locks, trigger locks, cable locks. Yeah. So yeah, Alec Baldwin energy. Yes, but that's once again people who don't deal with guns, like this prosecutor. Okay, a gun is a gun. They aren't thinking ahead.
Yeah.
And that also says a lot about ATF agents. So
this ATF agent is. I think the judge even made a comment that he's barely out of high school.
Yeah.
For the ATF agent, I'm like, oh my god, that was great.
Yeah. Yes.
So
how much time is she looking at if she gets convicted?
15 years. 15
per
years.
count.
We serve concurrent sentences, not consecutive. Max is concurrent, or max is 15 years. $7,500 fine.
Oh, so she can't get stacked up and do 60 years on this, can she? Oh, thank God.
It's going to be
thank
15
God.
years regardless.
I mean, that I'm not saying she should go to 15, but that makes me feel a little better.
Yeah, I know it does too when I looked into it, but still, I don't think she should do 15.
Oh, I don't want her to go to a day.
She's already done 2.5.
Yeah.
I mean, she was locked up December 2021. It's now what, January?
Mm-hmm.
Oh, she's already done essentially two years.
But the only other part of the cross I was going to say real quick, David, I know you're probably getting ready to watch the Lions.
I was just pulling it up.
Is when she said, well, did you ever see any threat? Was she ever threatened? He's like, oh, I didn't see any threats. And then she immediately pulls up the Facebook thing. What's that say? What's that say? What's that say?
Well, and the judge even pointed out this. I will say that the judge sometimes talks a little too much when I don't want her to, but then talks just fine enough when I want her to, because the judge pointed out, like, well, that wasn't threatening, but they're definitely not good. That was the comment from the judge on the bench. I just wish she wouldn't talk so much, but that's very normal for Oakland County and for Michigan judges to intervene a lot like that, or ask witnesses questions. You notice she's asked a lot of questions.
Yes.
It's normal.
And I'm fine with the judges asking a witness a question because they're trying to figure stuff out. But the trial in Connecticut we're covering, the Michelle Troconis trial. Oh my God! Like this judge, he articulates. He's very intelligent. I generally don't have an issue with his rulings. They're very well grounded. But he, like, the question meaning to be asked is, and he fucking runs through it, and then you're like, and then counsel's like, yeah, that's what I mean. And either side, it's actually he's been very,
and that's what I mean by, I think this judge is fair in that she has at times helped the defense with cross-examination and phrased questions that the defense attorney is trying to get out in a weird, convoluted way, in a very simple way, and then forces the witness to answer it. And the defense is like, thank you, that's what I wanted, and move on.
Yeah.
So it's okay.
And to be fair, though, part of her problem is she's dealing with police, and police are trained to be, oh, I don't know what you mean. What do you mean, hurt? Like they're trained to be difficult. I mean, they're not told, oh, cooperate, Mr. Defense Attorney. They're like, I don't understand what you mean. Like that's how they're trained to be. So that's not not a surprise.
When the defense was asking about, you don't know if James and Jennifer were standing right next to Ethan when he was taking the video of that gun. You don't know that. You don't know that when he sent the message to his friend saying, look what my dad left out, he was lying to his friend, right? You don't know that. And it was very convoluted until the judge stepped in and said, you have no knowledge of this, correct? And then the witness finally answered, yeah, I don't know.
Well, I think you don't know is clear also, but that's them just being cute. Like, well, I don't know what you mean. And sorry, ma'am. I can't help you. Oh, yuck.
It's fun. Well, my point in saying that is that the
Yeah.
witness was all dancing around the question being stupid,
Yes,
like
yes.
you were saying, until the judge point blank asked
Yeah.
the witness, and then the witness answered.
Oh yeah. No, he's like, I'm just simple police folk, ma'am. Eyes don't know. And the judge asks a question. Oh yes, ma'am, because they know they can't fuck with the judge.
Exactly.
So,
Exactly.
Yeah.
So,
But yeah,
well,
no,
I'm
that
glad
was
you watched
interesting.
it. I'm glad.
I today was a lot better than yesterday.
Yeah. I love the fighting was ridiculous.
Oh, I'm sure that's not going to end from here.
I don't know. It makes for bad lawyering, but it makes for good entertaining streams for sure.
Well, I know, but that just reveals. I think the prosecution is going to show their ass continually throughout this.
Yeah, we'll see. We'll hope
So,
so. I hope
their closing's
the
gonna-
one guy comes off as a douche because I think he should. I don't remember his name.
Oh, the guy prosecutor.
Yeah.
Yeah. Oh, I don't know. Whatever his name is.
Mark Keist.
Mark Keist. Oh,
Mark Keist.
Keister. And
Yeah,
Keistermeister.
Yeah, the Keistermeister. I hope it comes to bite him in the ass. He's actually lead prosecutor too. Karen McDonald, the elected prosecutor,
Yeah.
sitting second chair officially.
That's because she doesn't run plays.
Yeah.
That's her thing. Yeah.
Right.
Now, and guys, that's not normal. The elected, they may have had experience, but it's been a long time since they hopped on a horse. So normally someone
if
else.
you didn't notice from her, oh no, wait. No, it was during jury voir dire, so you wouldn't have seen it. She acknowledged that she was a circuit court judge for 12 years before stepping down and then running for prosecutor. She's told the jury that, I want to say, at least 12 times.
Yeah, well, that's the thing. Judges like telling you they were a judge. By the way, she was a judge. Why did she stepping down though? That's a bit of a downgrade. Did something happen?
I don't know. I
don't know
wasn't
if
really paying attention that much
at the time. Okay.
Yeah.
Normally that doesn't happen voluntarily.
I know. And then she ran.
That's prestigious. Well, like circuit court, when she says circuit court, that means like appellate, or does that mean like
like
the
felony
judge we're in
level.
front of?
It's felony level trial court. That's circuit
So
court.
she was a colleague of this judge we're in front of.
Yep, for 12 years. Yeah, they worked together.
Okay, yeah, that is, oh God, that is not a voluntary decision, I don't think.
Yeah, I don't think it was either. Yeah, no, they worked the Karen McDonald, the prosecutor in this case, worked alongside as a judge with the judge that's currently sitting on this case.
Okay.
Yeah.
Why is she like, Karen, honey, I know how you get. Just relax, sweetie.
I know, that's what it was. I think they've known each other for a number of years.
Okay.
And so I hear a little bit of that when the judge is talking to her, saying, especially with the whole emotion thing that went on day one. No, I didn't tell them that they couldn't show emotions. And then Karen jumps up, she's like, Judge, I understand your orders. Well, I don't think you do, because I didn't say you couldn't show emotions. I hear that bantering a little bit, like judge to judge.
Yes. That's a shame, since I don't like that. I think that's prejudicial to say to the jury. I do too, but you know what? She said it. There's only so much you can do at that point.
Yeah.
So
she talked about her whole career. She talked about how she sat on a school board, and she's been
school board. Oh God,
yeah,
I'm sure she was a
from the
peach of a human being.
I know. She went through her whole thing. I don't know why she did that. And it was funny because I was sitting with the rest of the media, and all the media was like, how many times is she going to mention that she was a judge? We were like ticking off every time she did it.
So, all right.
I'm going to go get to my Lions game. Thanks for having me on.
Thanks for being on, David. Yeah, guys, Making Law Simple Network. He'll be on tomorrow morning, plowing through this trial, and we'll see what happens. Maybe there'll be more fireworks, or at least there's
going to be more.
Things will keep going good for Jennifer. So thanks for being here, David.
No problem. Take care. You guys have a good rest of your day.
Yeah, take care. Yep, and then you guys, if you want to see him tomorrow, over at Making Law Simple. So, as far as us guys, with that being said, here, I think all my thoughts have been addressed. What are we doing tomorrow? What do we got left? We got Michelle Triconis. We did not get day 11. Day 11 would have been Friday. We did not get that done yet. It's 6:00. You know what? I'm gonna go have dinner. We might watch. Well. Actually, hold on. How long is it? Let's see here. Michelle Kunis trial. Day 11, 6 hours, 54 minutes. Okay, well, that means it's 5 hours, 7 hour. Hold on, what's a breakdown like? Okay, so there's 3 hours, 2.5 hours. Hold on here. Yeah, I think. Well, no, hold on here. I'm looking at this. All right, here. Let's see how long is bad boy. You know what? We'll do Michelle Trakunis tonight. We'll do day 11 and get caught up for the. We'll get caught up for the week, and then we'll probably start trying to catch up on that as we go throughout the week. Then, so we'll do that. Yeah, we'll do that 7 o'clock, guys. So hang tight here. I'll set up a live for that real quick. All right. Scheduled for later. 7:05 p.m. All right. So that's set. I'm going to take this and we are going to send you guys over there if you want to go there. If not, have a good night. You guys can catch up with us later. But we are going to move on. Yeah, we got time tonight. Why not? And yeah, that's it, guys, for right now. So if you have other questions, let me know. Appreciate everybody being here over on Rumble, Twitch, and here on YouTube. Thank you for all the super chats. Thank you for everybody who bought memberships. I know everybody who got one is going to be very appreciative as well. Let's see here. So until, I don't know, about a half hour from now, good night. We'll see you guys there. So, yeah, see you guys in a little while.